Yes. So 439 की बेल एप्लीकेशन इसमें एप्लीकेंट के फादर के बाईपास सर्जरी होना है तो 8 तारीख से है। It was adjourned after 3 weeks. वो आर्ग्यूमेंट काउंसिल दूसरी कोर्ट में आर्ग्यूमेंट चल रहा था कोई अभी एप्लीकेशन लगाइए प्रीपोनमेंट नहीं कर सकते तो रिजेक्टेड शॉर्ट कॉल हुआ था 11/12/2023 की डेट कब लगना है कोर्ट ऑर्डर से क्या कोर्ट ऑर्डर कब लगेगा 11/12 तारीख को नहीं क्या आप प्लीज हमारी पर रिकॉर्ड कॉल हुआ था चलिए उसको वेरीफाई कराइए कुछ उसमें रहता है ना कि लिस्ट आफ्टर 1 वीक 2 वीक्स वो सब कुछ रहता है वो रिकॉर्ड कॉल होना था इसलिए 4 वीक हो तो उसके बाद लगेगा रिकॉर्ड इश्यू हो गया होगा बट वो कोर्ट ऑर्डर को मॉडिफाई नहीं कर सकते कोर्ट स्लिप से ठीक है नेक्स्ट वैसे वेरीफाई कराओ यस ठीक है 34 ये कोई एक्सरसाइज की गेन ज्यादा समय 3/11 की फाइलिंग लगा नहीं अभी तक लगेगा ना 1-2 दिन में लग जाएगा चलिए रिजेक्टेड circumventing the ordinary procedure of not dropping in the Dropbox for the dire urgency ward, I think issued a notice on 25th of last month asking me to evict myself from the premises in 7 days time. So he was served on the 2nd. This uniform? Yes. Therefore, what I pay for the listing today. They say that you are a registered purchaser of the land, your name stands in the revenue records, there is a diversion in your favor. When are you going to be evicted? Could be today afternoon, could be today evening, not any time. Today itself. I'm good. First temporary grade application number belongs to the sister, which is 1911. The marriage is also to be verified. Tomorrow. Application for correction typography mail order में ST number tomorrow.
For suspension of sentence last week लगी थी next week का order हुआ था in spite of that matter got not listed.
ठीक है इसको वेरीफाई करा लीजिए सुनीति सराफ its date was given it's 4th October but the case was not linked on that date and thereafter no tentative date has been fixed and the petitioners here working on the post of computer operator while in other mistake they have been regularized and thus sir हो गई 15 सर्व हो गई 4-10 को लगा भी था पर आरबीएमसी में लिखाने के बाद में फिर एग्जाम हो गया अभी तक कोई टेंटेटिव डेट भी नहीं आ रही ठीक वेरीफाई करा लो केनर भाटी on the fresh bail application which was filed on 2nd of November still not listed because the fact which was clear on the very next day नहीं लग जाएगा अब देखिए उसमें डिफेक्ट रहते हैं इसलिए लगता है लिस्ट और आज तक इसको वेरीफाई कराइए जब वो वेरीफाई कराते हैं सब चीजें सामने आ जाती है ये डिफेक्ट्स है और तो भी मतलब लगेगा नहीं आपको ऐसा बताने चाहिए मालूम नहीं गांड टुमारो we'll just verify then grant because what you say is correct or not we have to verify most of the time what is happening suppose today case is listed and gets adjourned tomorrow they will appear here and ask for a court slip that is not correct नहीं बता रहा था most of the cases we find कि एक दिन पहले adjourn हो गया for some reason there is a judicial order and the next day they will come up with court slip के साथ केस नहीं लग रहा हमारा लगा था ना कल आपने बताया नहीं कल लगा था मतलब दिस इज दी सिस्टम व्हिच इज व्हाई वी हैव टू स्पेंड हाफ एन आवर फॉर दिस चेकिंग जहां जेन्युइन है वहां दे देते हैं वेरी रेयर केसेस में देना है ये वेरी एक्सट्रीम अर्जेंट आप देखिए स्कीम देखिए क्या व्हाट इज दिस दैट्स वन दिस इनसाइड द प्रिजन एंड एवरीबॉडी इज इनसाइड द प्रिजन ऑल 482 जो भी है आपके 389 दे आर ऑल इन जेल
Your Worship, this is a tender matter. The technical bid will open tomorrow. I was praying this matter to be listed today.
चलो
It's a temporary bail application on account of his uncle's death. I'm praying for tomorrow.
6/11 को फाइल किया, कब? आज फाइल किया?
Filing.
अभी फाइल हुआ ही नहीं है।
Then filing now.
नंबर भी बिना नंबर के कैसे हो?
I'll supply.
अंकल डाइड ऑन 1/11 ना, तो उसको पहले नंबर दीजिए, उसके बाद देखेंगे।
So this is the first bail application, Lordship. Lordship, other conspicuous person already granted bail. And this matter was listed on the proposal date 20/11/2023 किया।
कब लगा था केस?
Lordship, third petition.
लगा ही नहीं।
और उसकी चेकिंग के बाद में 20/11/2022 को डेट दिखा रहा है।
चलो उसकी वेरीफाई करो, वेरीफाई करके देंगे। ये क्या है?
ये भी सैम एक्ट पे फर्स्ट बेल एप्लीकेशन है और ये भी 20/11/2023 के लिए अपडेटेड दिखा रहा है मुझे।
वेरीफाई कर।
438 एंटीसिपेटरी बेल है लॉर्डशिप, ये भी 20/11 के लिए अपडेटेड दिखा रहा है, बट दिवाली का लॉन्ग वेकेशन में लॉर्डशिप कभी भी अरेस्ट कर सकते हैं। सो
वेकेशन सिटिंग नहीं होगी, नहीं मालूम।
वेकेशन में बेंचेस में इस बार दिवाली वेकेशन में बेंचेस में
यस 2/11 को फाइल किया, 2/11 को फाइल किया आपने?
केस तो ठीक 9/11
नहीं, 2/11 लिखा है इसमें डेट। 9/11 तो अभी आया नहीं है, अभी 2/11
तो 9/11 7 की
9/11 तो है, लगी है ना।
9/11 को सारे केसेस एक ही दिन में लिस्ट कर दी और उसकी बीमार है।
9/11 को अपन वो कर देते हैं, इसको कंफर्म कर देते हैं 9/11
7 तारीख को
लास्ट वर्किंग डे वेरीफाई कर।
नंबर नहीं आएगा,
ये भी हुई है,
एक ये दे दे, एक रहने देता है, संदीप की दे दे, कल की सब एक ही तारीख में सब सारे लिस्ट करो।
एक साथ फाइलिंग होती है तो एक साथ ही
सब इकट्ठी
ये सब 2 तारीख को फाइल हुई है आपके डेट के मुताबिक।
और दूसरे केसेस में सब चलो लास्ट वर्किंग डे
इसको दो कल के लिए,
वो में सी की बेल
इसको फाइल से उसको अलग कर।
Your Lordship, we have filed a suspension application on 20th of October 2023, but the case has still not been listed. It's the first suspension application, and we are praying for the
टाइम के लिए लगा था।
सचिन वर्मा
the items pertaining to the inspection list, and the coordinate is shown on 3/11/2023, but it's not listed.
3/11
Yes, sir. But it's not listed, right?
9
no replies to be filed.
2 weeks।
पिछले टाइम में इन्हें रिप्लाई के लिए टाइम दिया था। पॉजिटिवली
एकदम अपना लास्ट इंटेलिजेंस 2 weeks टाइम इज ग्रांटेड। चलिए नेक्स्ट
रिप्लाई नोटिस बोथ है।
प्लान नोटिस 2 weeks।
रिप्लाईज फाइल्ड। नंबर 4
पास हो कि 4
रिप्लाईज फाइल्ड मान
ये है ना ला नहीं क्यों
कलेक्टेड की बयान की नहीं कलेक्टेड की रिपोर्ट स्टेटमेंट नहीं मिल
गुड स्टेटमेंट नहीं
3.2
the Council for Appeal is not ready to argue the matter list after 4 weeks as paid. 4 में क्या?
4 में 500
ठीक है 5
लकी है।
Yes, Lordship, in this matter, there is a suspension of application of one 2G by Lordship. Yes, पे application है सर, केवल 140 नंबर 12 नंबर 12 वॉल फैमिली सर इसकी इम्प्लीकेट कर दी है। और जो प्रोसिक्यूशन स्टोरी है सर, इट इज इन पेज नंबर 4 ऑफ दी इंडियन ऑर्डर लॉर्डशिप। यस, अभियोजन कथनाक संक्षेप में इस प्रकार है कि दिनांक 8/4/2019 को 26 बजे फरियादी छोगालाल ने हाथगन के साथ थाना चैनपुर जिला सोइलतो पर इस आशय की मौखिक सूचना दी कि वो ग्राम करानिया रहता है, खेती मजदूरी का काम करता है। दिनांक 7/4/2019 को रात्रि की बात है, वो उसके घर में खाना खा रहा था तो उसका पड़ोसी दीपक उनके पुराने खले की जमीन को लेकर सोइलतो गाली देने लगा, कहने लगा कि बाहर निकल, तेरे को बताता हूँ। इस पर वो उसके घर से बाहर निकला और दीपक को गालियां देने से मना किया। दीपक ने लकड़ी से मारपीट की जिससे उसके उल्टे हाथ की कोहनी पर चोट आई। झगड़ा छुड़ाने के लिए उसके पिता रतन, उसका लड़का राहुल, भाभी गंजीबाई, उसकी पत्नी मीराबाई आए तो दीपक के परिवार वाले तोताराम, सुमित ने उसके साथ गाली गलौज कर उसके साथ मारपीट की। दीपक ने उसके लड़के राहुल के सिर में ईंट मार दी जिससे चोट लगकर खून निकलने लगा। बाकी सभी ने हाथ मुख को एवं लकड़ी से मारपीट की, सभी को चोट लगी। घटना के समय कालू पिता संतोष, राकेश पिता थान सिंह मौजूद थे। बाद में दीपक जाते जाते बोल रहा था कि आज तो बच गया, आइंदा जान से खत्म कर दूंगा, जिस पर से थाना चैनपुर से अपराध 1600, 294, 323, 336, 506, 34 भांति दंड प्रथम संहिता दर्ज की गई। फिर आपको नोटिस पेरा 5 डेथ हो गई उसकी। अनुसंधान के दौरान घटनास्थल का मौका नक्शा निर्मित किया गया। आहतजन का जिला अस्पताल खरगोन में, निजी अस्पताल खरगोन में उपचार किया गया। आहूत राहुल के सर में ऑपरेशन किया गया। उसके पश्चात उससे इलाज हेतु अस्पताल ले गए, जहाँ इलाज के दौरान राहुल की मृत्यु हो गई। जिसमें डेथ हो गई सर 10 तारीख के दिन, 2 दिन बाद, 3 दिन बाद, 7 तारीख की दूसरा स्टेटमेंट रिकॉर्ड है। इसका स्टेटमेंट रिकॉर्ड नहीं है सर, नहीं है, इसका स्टेटमेंट रिकॉर्ड नहीं है सर। और जो फैमिली के सभी लोग इम्प्लीकेट हुए हैं सर, वो 149 के बेस पे इम्प्लीकेट किया है सर। 149 की जो फाइंडिंग दी है इन्होंने, 149 क्यों लगाया गया, आप पेरा नंबर 96 एक बार देखें। इसको दूसरी बार को एंटीसिपेटरी बेल दी थी ऑनरेबल कोर्ट ने, एंटीसिपेटरी बेल दी थी और पूरा ट्रायल में एंटीसिपेटरी बेल पर बेल आउट की सर। 96 का तेरा नंबर इसको, ये एप्लीकेंट को इसके ऊपर एलिगेशन राहुल जो मृतक के उसके साथ मारपीट का नहीं है, उसकी माता के साथ मारने का है, जिसको चोट सामान्य चोट बताई, कुछ भी नहीं बताया। 96 पेरा नंबर में प्रकरण में अब यह तथ्य देखा जाना आवश्यक होगा कि अभियुक्त गण का मृतक राहुल को मारने का आशय या ज्ञान था अथवा नहीं, इस संबंध में अभिलेख पर आई साक्ष्य प्रकट होता है। अभियुक्त ने लकड़ी, ईंट व साइकिल से मारपीट किए जाने का परिणाम स्वरूप मृतक को सिर में आई चोट एवं छाती पर चोट आना डॉक्टर विजय, डॉक्टर चिन्मय भालके ने शव परीक्षण तथा प्रशांत राजपूत ने शव परीक्षण रिपोर्ट में उल्लेखित किया है। जिस प्रकार मृतक राहुल को अभियुक्त गण ने ईंट, पत्थर, साइकिल के हैंडल से सिर एवं छाती में मारकर चोटें कारित की, इन तथ्यों से स्पष्ट रूप से प्रकट होता है कि अभियुक्त गण का आशय एवं ज्ञान मृतक राहुल की मृत्यु करने का था। पेरा नंबर 97 के था, जहां तक अभियुक्त के पास राहुल की मृत्यु कारित करने के लिए हेतु था। सत्य को देखा जाए तो अभियोजन साक्ष्य एवं अभियुक्त गण की ओर से प्रस्तुत बचाव साक्ष्य अनुसार खले की भूमि को फरियादी पक्ष उनकी, अभियुक्त गण उनकी बताते हैं। उसी खले की भूमि के विवाद पर से अभियुक्त गण द्वारा लकड़ी, ईंट, साइकिल के हैंडल से सोन को मार डालना अभिकथित किया। पेरा नंबर 98 बहुत इंपॉर्टेंट है सर। प्रकरण में हेतु का तथ्य स्थापित नहीं होने के आधार पर अभियुक्त गण की अपराध में संलिप्तता खंडित नहीं होती है, क्योंकि प्रकरण में प्रत्यक्ष साक्षी स्वयं को
कि साक्ष्य से अभियुक्तगण द्वारा लकड़ी, ईंट के टुकड़े और साइकिल के हैंडल से मारे जाने के परिणाम स्वरूप राहुल की मृत्यु होना स्थापित होकर प्रमाणित है। साक्षीगण की साक्ष्य से मृत्यु भी प्रमाणित है। मेरा ये सबमिशन है सर।
उपस्थिति पर्याप्त है 149 यस, क्या है इसका रोल, क्या है इसका?
Should be she was present. She was present. She actually participated. Should be covered under section 149. Since in the statements of the other eyewitnesses, PW1 mainly Choga Lal. Let me kindly come para number 25 of the judgment.
यस,
प्रत्यक्ष दर्शी साक्षी छोगालाल ऐसा एक ने अपने न्यायालयिक कथन में बताया है कि वह अभियुक्तगण को पहचानता है। घटना उसके न्यायालयिक कथन से 6-7 माह पूर्व की ग्राम करानिया में रात्रि 8 बजे की है। घटना दिनांक को वह उसके घर पर खाना खा रहा था। दीपक ने से होकर उससे गाली दी, उसे मारने लगा। उसका लड़का राहुल और उसके पिताजी रतन छुड़ाने गए, पर करतान ने राहुल को सिर में लट्ठू मारा। उसके बाद दारा सिंह प्रकाश दीपक ने भी राहुल को साइकिल से मारा। उसकी मां कालीबाई को दूजी बाई ने मारा। उसके बाद वो बेहोश हो गया। उनके साथ मारपीट जमीन पर लेकर हुई।
दूसरी बारी लगा।
So the presence is established and the intention is also clear. Now, my lords, paragraph number 28, the next page पर। This is other witness of PW6। मुख्य साक्षी ने अपने कथन में आगे यह बतलाया है कि उसकी पत्नी कालीबाई के साथ सभी आरोपीगण ने मारपीट की। आरोपीगण ने राहुल को मार मार कर वहीं पटक दिया। राहुल के सिर और छाती में चोट आई थी। आरोपीगण कह रहे थे कि जब भी 3-4 लोगों की वो जान ले लेंगे। झगड़ा जमीन को लेकर। सो एक्टिव पार्टिसिपेशन ऑफ
सर ये जो है आफ्टर कोर्ट स्टोरी है, ये एंटीसिपेटरी बेल दी थी। जब भी ऑनरेबल कोर्ट ने ये तथ्य कंसर्न किया था कि दे हैव चेंज देयर स्टेटमेंट दैट इज रिकॉर्डेड इन दैट ऑर्डर लॉर्डशिप। काइंडली सी दी ऑर्डर लॉर्डशिप। Counsel for the applicant submits that the applicant has been falsely implicated in the matter and the dispute between the family of the applicant with the neighboring complainant family on the land issue had taken place and that the FIR was lodged on 7/4/2019 and in the FIR which was lodged after the incident. The allegation have been made against the court to Deepak, Kotaran and Sumit. He further submits that even the presence of applicant was not reflected therein. He has also submitted that on 11/4/2019 a statement of Kalu was reported under section 161 of the CRPC. In that statement, also the presence of present applicant was not shown, nor any allegation made against the present applicant. He further submitted the section 161 statement Kalu was recorded on 14/4/2019, where he acknowledged that the present applicant has caused injury by hand and fist of Kalibai, Gujibai and Meenabai. He submits that this is the out and that all the male member of the applicant family have already been taken in the custody of the entire family has been brought in the incident. Applicant being a lady, ये और my submission is that lordship अगर 149 के अगर इनको implication लाना है, so they have to observe in the order lordship. This is not observed. Can we see this? I have highlighted the portion lordship page number 20 पर। 21 पर है सर। क्या करना पड़ेगा? To convict a person under section 149 IPC, prosecution has to establish with the help of evidence that firstly appellant shared a common object and were part of unlawful assembly, and secondly it had to prove that they were aware of the offence likely to be committed is to achieve the said common object।
तो थी।
और मेरा सबमिशन है सर इसके अंदर कि ये जो 3 स्टेटमेंट हुए सर, केवल सिंगल एक इंजरी है सर उसको हेड तक, और जो वेपन यूज हुआ है अंदर को जो मटर के राहुल केवल एक सिंगल, ये डॉक्टर के स्टेटमेंट में आया है सर। ये आप देखिए मेरा जो नंबर 97 है सर, जिसके अंदर 3 डॉक्टरों का उल्लेख है। आप मेरा नंबर 96 देखें, मेरा नंबर 96 में डॉक्टर हरीश का नाम, डॉक्टर विजय और डॉक्टर चिन्मय भांडके का वो है सर। मैं अब आपको उसका स्टेटमेंट दिखा देता हूँ। डॉक्टर हरीश का नाम PW सर, PW सर, डॉक्टर हरीश का नाम। मैं दिनांक 7/4 चीफ से ही पढ़ देता हूँ सर। 7/4/2019 को सामुदायिक
पैराग्राफ
चीफ भी पढ़ देता हूँ। पेरा 8 से चीफ और क्रॉस जला से ये 3 पेरा आता है ये। मैं दिनांक 7/4/2019 को सामूहिक कार्य के झिंझिया में मेडिकल ऑफिसर के पद पर पदस्थ था। उक्त दिनांक को पुलिस थाना तो पिता छोगालाल निवासी कर्मिया का मेडिकल परीक्षण हेतु लाया। परीक्षण से आहत के पेट के ऊपरी हिस्से व छाती के निचले हिस्से पर 2 से अधिक विभिन्न आकार की खरोंचें थी। आहत के सिर के बाईं ओर खरोंच 2.5 x 1 सेंटीमीटर थी मौजूद। उक्त दोनों चोटें किसी सख्त एवं बोतरी वस्तु से आना प्रतीत होकर परीक्षण से 6 घंटे की भीतर तो मैंने आहत को जिला अस्पताल रेफर किया गया। फिर आपको जो इसका क्रॉस एग्जामिनेशन है प्रति परीक्षण का, उसमें कहता है ये कहना सही है कि आहत राहुल की सामान्य परिस्थिति के संबंध में एमएलसी रिपोर्ट में कोई उल्लेख नहीं। ये कहना सही है कि उसकी चोटों के इतिहास के बारे में कोई उल्लेख। ये कहना सही है कि मैंने जो दोनों चोटें लिखी है वो दोनों ही खरोंच होकर सामान्य है। तो देर इज नो कॉमन ऑब्जेक्ट और नो इंटेंशन सर। अगर वेपन वो यूज करते हैं सर, अगर ऑब्जेक्टिव उनका वो होता कि मर्डर करना है सर, तो वो ईट जो मौके पर मारना है, इसको ईट से चोट आना बताइए, जिसके कारण थ्योरी रिपोर्ट में भी आया है कि उस ईट के कारण उसकी मृत्यु हुई है। और सर इसके बाद ये दोनों डॉक्टर का भी है सर। सर इसकी जो डेथ भी हुई है वो इस कारण से हुई है कि इसको ब्रेन हेमरेज हो गया था। ब्रेन ठीक है
एडमिशन 6 नंबर में डिफेक्ट है उसमें डिफेक्ट रीच टाइम पे मैंने जो लिखा है लिस्ट आपको डिफेक्ट इज रिमूव
7 praying for time to cure the defects.
6.1 का कितना एडमिशन 7 में 1 वीक टाइम रिमूव द डिफेक्ट 7
Item number 8, the state government has moved an application for vacating the stay or modification of the stay order dated 19/10/2023. But in the
I am praying for 3 days time to file a lab this application. They file an application for vacating stay ballot. I have received a copy one.
but there is an examination tomorrow itself, my lord. And what has happened, my lord? He has moved application relying upon the Supreme Court judgment, my lord. Kindly consider his application, my lord. In para 4, my lord. अनिल बस्ती का डिसीजन है।
देखना पड़ेगा फाइनली क्या है। एक बार ऑलरेडी इंट्रीम ऑर्डर वाज ग्रांटेड बाय दिस कोर्ट इन स्पाइट ऑफ दैट you again issued the notification.
Yes, my lord.
It was said, why is you have done like this, ignoring the orders passed by this court?
Yes, my lord. Because Supreme Court has said identical matters, my lord. Supreme Court has already stated the decision of Delhi High Court. The similar virus was challenged before the Delhi High Court, and that has been stated by the Supreme Court. Yes, please.
I mean, the question is,
Here, my lord. Here,
one minute, please listen. When we pass an interim order, you are supposed to follow that. You
consider my lord. Judgment we have relied upon. मैं ये नहीं कह रही हूँ कि आप एग्जाम दें। एक बार इसको देख तो ले, इनकी इंट्रीम इन्होंने जो एप्लीकेशन लगाई है और जो जजमेंट इन्होंने रिलाई किया है।
interim relief has been granted only on
मैं ये नहीं कह रही हूँ मैं।
orders passed by this court. Issuing the same
Application has been issued by Jabalpur College, and he is not a party in this matter.
they are the party.
He is not invited. He is not in the amendment.
मतलब वो इन्होंने जिस जजमेंट में रिलाई किया है
What you not saying? You have not seen there.
मतलब जो ऑर्डर जिसको रिलाई किया है सुप्रीम कोर्ट का, उसकी 4 लाइन आप देख ले। सिमिलर ऑर्डर के में भी, दिस ऑर्डर में भी मॉडिफाइड by way of interim relief, it is directed that no penal action will be taken against a doctor who has put in practice for not less than 15 years. In case he does not take the proposed examination, it is however not clear that candidates are free to take the proposed examination. So those who are interested in giving the examination, they may be permitted, madam. This is what we are asking for. Delhi High Court was under challenge before the Supreme Court, and Supreme Court has stated the order passed by Delhi High Court. और उसमें उन्होंने कहा कि प्राइमरी बेसिस द रूल्स आर neither parent legislation nor do they suffer from manifest arbitrariness. They stayed the High Court order passed by the Delhi High Court.
What will happen to the stay order passed by this court? Here, it was passed in.
But later on, Supreme Court has stayed such kind of orders, Malad. In Delhi High Court का same sections under challenge थे same कल examination है. If your lordship will permit those who are interested, इनको नहीं देना उनके पक्ष में वैसे भी stay. But those who are interested in giving the examination, they may be permitted. And there is an order of the Supreme Court, Malad, we stayed the Delhi High Court.
Because of the stay order, you could not have issued the notification at all. That is
Malad, the Supreme Court has stayed the similar in the similar matter. Supreme Court has stayed, Malad.
सबसे पहले इंट्री ऑर्डर
Yes, Malad.
been issuing notifications after notification.
Malad, we are not issued the
From the beginning, medical university has issued that notification.
they intentionally not made to the medical educationist.
That amendment has been allowed.
Sir, but why just now? At that stage of
Let me see their application for vacating stay, madam. They have just asked for vacating of stay order dated 19/10/2023, madam. Whereby the stay order which is already there, this is from 2016. They have asked, madam, this court that this order to be stayed from 2016, madam. Because earlier, this court has passed this interim order on 1910 on the basis of earlier order filed by this honorable court, madam. They have not mentioned about all these facts, well.
And at that point of time also the Honorable Supreme Court's decisions have been considered and that has attained finality. उनके पक्ष में नहीं है. उसके बाद एक
दिवाली लगाना
मतलब ये एक बार ये डिसीजन आप देख चलिए इसको. This is also the same matter. The same virus was challenged.
of the orders passed by this court.
But there are
16 states है ना, आज की बात नहीं है. We have not passed this state for the first time. It is for 7 years now.
Malad, but
Still holds and holding up for contempt. We'll issue suo motu notice.
complaint होती नहीं है because there is an order of the Supreme Court. Malad. It may not be like this.
Reconsider, yes, like
But initially,
Malad may kindly consider the para 10 and 11 of this order. Because the similar virus was under challenge before the Supreme Court. Para 6 देख ले पहले आप. And there is a judgment of the apex court, my lord. And certain guidelines have been issued in that judgment. Voluntary Health Association of Punjab का जो judgment है, certain guidelines have been issued by the Supreme Court. Para 6 है, my lord. Para 10 and 11.
So the proper course would have been to make an application for vacating stay earlier.
Yes, my lord.
फिर क्या करते हैं कि ये सुप्रीम कोर्ट में फलाना ऑर्डर पास कर दिया इसलिए हमने ये नोटिफिकेशन
That's
निकाला.
why I wrote application for modification. Those who are interested in giving examination, they may be permitted. Examination है जिनके देना है इनके अगेंस्ट कोई कोर्ट सिस्टम
कि पहले नोटिफिकेशन इशू करने के पहले यार अमेंडमेंट के करा लेते हैं ऑर्डर का. अपने मन से यूज करते हैं ना, ये गलत है. यू एडवाइस योर क्लाइंट्स लाइक दैट. अदरवाइज वी ड्रॉ कंटेंट. आपकी बात है सुप्रीम कोर्ट में क्या किया? कोर्ट के ऑर्डर्स का डिफाइन 2016 से चल रहा है.
This order may kindly be modified.
They can interpret the orders part.
My lord, I am not representing.
If you understand, please explain them. This is not the way. Now we have filed a vacating stay third time when this court passed the interim order third time. Clear 2 times you have not made any application. You never tried to get it modified.
My lord, that's why I am praying that it may be modified to the extent that those who are interested.
क्या है?
हमारी प्रेयर है कि जिनकी जो इंटरेस्टेड है वो एग्जाम दे दे. उन्हें नहीं देना, ये मत दे.
तो ऐसा नहीं होगा ना, वो तो आपका आर्गुमेंट अलग बात है.
इन्होंने जिसके ऊपर अनिल
सुप्रीम कोर्ट ऑर्डर यू शुड फाइल एन एप्लीकेशन हियर. ठीक है, देखेंगे. This involves a very short question. The idea had after Diwali vacation अभी फाइनल हियरिंग नहीं होता है वीक का जो भी 2-3 केस करेंगे ज्यादा नहीं इससे ज्यादा नहीं
ये केस है सर बहुत ज्यादा
दिस इज ऑलरेडी एडमिटेड इट हैज टू बी हेard फाइनली इन दी फाइनल हियरिंग मैटर देखिए ना पोस्ट फॉर हियरिंग इन द यूजुअल कोर्स की इशू
के बाद पिछली बार आपने ऑर्डर किया था कि आज की डेट लगाई थी आप
your lordship every week which is convenient
if it is convenient it may be had to take sir
maybe अगले
छोटा सा मैटर
after the list is over madam it's very small matter only one issue is involved madam ठीक है पासवर्ड कर लो पासवर्ड
Mallards, in fact, Mallards at serial number 9, we would pray for after Diwali Mallards. Though the issue is small Mallards, but we would.
देखते हैं इधर देखें तो फिर बढ़ा देते हैं चलिए नेक्स्ट मीडिएशन रिपोर्ट क्या हो गया फिर
लोगों से
लिखिए state list in the week commencing 4th of December.
And this we have an application for modification of order, Bharat, as he is contesting an election of legislative assembly. And there is basically section 62 of Representation of People Act is there, Bharat. They have the right to vote is there, Bharat. And in the right to vote in 2013,
It has been extended, no?
yes, sir, we had been extended. Single bench is upon that order, Mallet. And thereafter, division bench is also upon Mallet. Meantime, in between, he has filed an application, nomination form before the authorities, Mallet. Authorities have accepted the nomination form and said, you can contest the election, Mallet. From Indore, Mallet, constituency number 1, Mallet.
And he has been extended
And from Khargone, Mallet.
extended to enter in Indore also.
Indore also. That 6 districts are there, in which this Indore is also mentioned over there. So we are just before this honorable court, we have filed an application, writ petition in the High Court also, Madam. I have managed a copy of orders. That is on page number 18, Madam. In that petition, the court has ordered that you must seek a notification in the orders passed by division bench in the writ appeal, Madam. That's why writ petition हमने फाइल की थी सर ये लेके कि हमें जो है सिर्फ 10 दिन की परमिशन दी जाए कि हम इलेक्शन कंटेस्ट कर रहे हैं तो वहां पे हमें पब्लिक के सामने जाके वोट मांगने की परमिशन और ये सारी चीजें हो सके पब्लिक कांटेक्ट हो सके कोर्ट ने ये कहा कि यू मस्ट सीक अ मॉडिफिकेशन ऑफ ऑर्डर्स बिफोर रिट अपील because writ appeal has once affirmed the order saying कि जो excitement था that is in proper orders one. So that's why we are before this honorable court. So my submission is there, Malad, only 10 days time may be granted to this person, Malad, this appellant, to have an election campaign in his own area, whereby he has
the guarantee that he will not misuse.
That he will, every day he will go to police thana and he will make the presence over there, Malad. Thereafter,
ये कैंडिडेट है कहाँ से?
yes, candidate Indore once is
Indore once.
Indore once is.
कैंडिडेट से अलाउ कर दिया है उसको अपन इंदौर में घुसने नहीं देंगे he will not enter
17 election है sir, 17 के बाद we will not enter into this Indore. 17 को election है, 17
कंडीशन डालना पड़ेगा
17 तक election है, 17 we will not enter.
आपको जब
नहीं sir, उस time ticket नहीं मिली थी. Thereafter we have filed the nomination form and we have got the tickets also from one of the parties, GIM party is there.
आपका रिकॉर्ड देखते हुए तो रिविजन नहीं होनी चाहिए लेकिन अगर ऑनरेबल कोर्ट इसको नहीं इसको टिकट दे दिया इसको ऑलरेडी दिस फैक्ट मस्ट हैव बीन डिस्क्लोज्ड
Yes, Bharat. Our nomination has been accepted, Bharat. I filed the
नॉमिनेशन फॉर्म में ये फैक्ट डिस्क्लोज किया है
सब disclosed, yes.
क्योंकि जब रिटर्निंग ऑफिसर को भी राइट जब है, जब उसको 2 साल से ऊपर की सजा हो,
कलेक्टर भी कर सकते हैं उसको.
यस कर सकते हैं.
In fact, collector has the powers.
Yes, yes, under section 12 he can suspend, he can reconsider.
दिखाइए जरा सेक्शन 12 दिखाइए. तो कलेक्टर के पास है तो अपने से क्यों करा. नहीं, even if we dismiss the writ petition, then also the collector has the power.
But my submission
जरा देखिए section 12.
section 12 is there that temporary permission has also been granted by the collector. But whereby my problem is this, man, once this court has affirmed the orders, then collector will not going to entertain my application. That's why I am before this honorable court to seek the permission of 15 days to have an election campaign over. Only 20 days time is there.
कोर्ट से हो जाने के बाद वही करा.
Which we do of representation of people at their ballot. There is 2013, there was a judgment by the Supreme Court which is saying the right to vote is not a constitutional right, whereby the court has said it's a statutory right, whereby they have also permitted person in jail to contest the election ballot. But he is not in jail. He has been detained by the authorities. My submission is this, at least because on 17 it's only I think it's 6 ballot. Only 10 days time to campaign over there. And collector is also not entertaining our application and he is dismissing our application. We have filed the application before the collector also.
He has dismissed.
He has dismissed that.
ठीक है सकारात्मक होगा. कंडीशंस याद होता है.
Any condition is.
इसलिए मेरा भी यही निवेदन है कि कंडीशंस के साथ ही अपना पुराना that will automatically
Cancel this.
order.
But we are ready to abide by any condition.
ठीक है चलिए नेक्स्ट.
कन्वर्टिंग की एप्लीकेशन है गलती से फर्स्ट कॉपी में रजिस्टर्ड हो गया क्रिमिनल रिवीजन में रजिस्टर्ड
क्रिमिनल रिवीजन करना चाहिए.
क्यों मेंशन इसका 125 का है सीआर
125 का ऑर्डर चैलेंज करनी है. देखिए आई नंबर 736823 एप्लीकेशन फॉर कन्वर्टिंग द फर्स्ट अपील इनटू अ क्रिमिनल डिवीजन. Learned Counsel for appellant submitted that the order under challenge in this first appeal is passed under section 125 of the CRPC. Therefore, criminal division is maintainable. Accordingly, I have allowed this first appeal is disposed of. Office is directed to register this case as criminal division. Note the same for hearing and admission before the appropriate bench. Certified नहीं. अच्छा ठीक है yes.
This matter, I'm seeking a week's time to find the reply. Last time.
The last occasion, my lord, the state was directed to file the reply and seek instructions as to why they have not taken any action on the complaint filed by the petitioner bank, my lord.
Complaint in respect of what?
My lord, the petitioner bank had
Section 14 application.
yes, my lord, that was
Been decided.
has been decided. The possession was given to the bank. Thereafter, the borrower has illegally trespassed into the property, my lord, by breaking the locks. regarding which we had moved an application before the district magistrate, which was not entertained. Thereafter, my lord, we had filed a complaint before
The application under what section? Which section?
that was not an application, that was a complaint against the respondent number 5 for his illegal trespass on the property which belonged to the bank, which was obtained by
See, once the section 40 has been complied with,
yes, my lord.
then public remedy available. Suppose somebody encroaches on the property, so can they take an action under the SURFACE Act?
My lords, I'm not following under SURFACE Act, my lord. The possession was handed over. They have, my lord, there is a judgment of the Honorable Apex Court.
Order which has been passed under section 14 of SUSHRUT has been passed against the debtors. Which order has been included in the party proceeding under section 14 of SUSHRUT.
My lords, first of all, they'll have to establish their inheritance rights through a civil court, my lord. The borrower, the guarantor, was very much alive and he had given his consent while keeping the property as mortgage, my lord. If my lordship may kindly have para 20.
Suppose this 14 order has been passed against a dead person.
Yes.
It was against the borrower. He was a co-borrower.
Against the dead person.
He, my lord, he is still alive.
Muhammad Rahim has guarantor.
The mortgage was created way back in the year 2014, my lord.
I'm asking you a very pertinent question. 14 section 14 has been complied.
Yes, my lord.
Possession granted.
Yes, ma'am.
उसके बाद कोई अगर आपके प्रॉपर्टी में घुस जाता तो how this authorities
If my lordship may kindly have this judgment, my lord. Which is the para 20 है इसका, my lord. This is the Supreme Court's judgment, my lord. If my lordship may have para 20. That the secured asset having been taken possession by recourse to the provisions of section 14 of the Act, the sanctity of the order of the learned magistrate is required to be ensured. As a sentinel to the QI, this court can in appropriate cases direct the police force of the state to use its force to restore possession of the property which has wrongly been deprived from the true owner. The need to exercise the power of this court to act as a guardian of law is amplified in the case due to the facts placed on record. When the undisputable records produced explicitly show the absence of any bona fide or real disputed question of facts, this court must step in to aid the enforcement of rule of law. Para 21, madam. The present case reveals an instance where a person has taken the law into his hands by force and thereafter seeks the benefit of legal principles. If such actions are permitted to be perpetrated, rule of law will survive.
This may be listed on 23rd up to that month, up to that time.
Particular learned counsel for the state. Case for us is granted 2 weeks time to file the reply. This case in the week commencing this November.
Yes, may I request for a fixed date, madam, because this matter does not get listed again and again. You have to make a
Week
mention.
commencing 20th of November means 5 days, any day it will be listed. Most probably it will be listed on this tarikh only. Yes.
Already.
The PI is not on various grounds. Subject matter of which is evident opening of illegal liquor shops in the prohibited area, such as education institutions.
Please tell us what happened to the earlier order, whether you have complied.
Yes, Your Lordship, complaint.
Tell us. Otherwise we want to find out कि आपने president का नाम लिखा कि नहीं लिखा.
Your Lordship, we have complied with that order.
कहाँ किया, कहाँ लिखा नाम?
हमने first right made the amendments.
क्या है? What is this?
My Lordship, this PI is on various grounds, Your Lordship. The subject matter of which is abundant opening of liquor shops in prohibited areas such as education institutions, religious places, Your Lordship, hospitals, de-addiction centers, as well as national and state highways, Your Lordship. Your Lordship, state government as well as central government has issued notifications which are annexed as annexes P3, page number 38 to 14, Your Lordship, may perish. Page number 38, the state government notification dated 31/3/2023.
This notification prohibits opening of liquor shops.
Yes, Your Lordship. On national highways, educational institutions, near educational institutions, as well as the religious places, Your Lordship. The central government has also issued a notification and there are getting out judgments, Your Lordship, which I am relying on of the Apex Court, Your Lordship, to support this particular petition.
Notice cannot notice. If you notice, here.
एप्लीकेशन है इसमें कोविड के टाइम से अपीयरेंस बंद हो गई है, तो नेक्स्ट डेट ऑफ अपीयरेंस के लिए एप्लीकेशन
है क्या प्रो?
आज तो नहीं आया, आप जो भी डेट देंगे
इसको बुलाना पड़ेगा एक बार। हाँ, और डायरेक्ट उसको टाइम दे दो तो हो गया फिर।
रजिस्ट्री के समक्ष होता ही हो।
पहले एक बार कोर्ट में देखना पड़ेगा, उसके बाद फिर
डेट दीजिए आपसे।
इसमें लिखिएगा आईए नंबर 12128-23 एप्लीकेशन फॉर granting the next date of appearance has been filed on behalf of the appellant Vijay.
विजय
Appellant Vijay is directed to remain present before this court on is November 23 and mark his presence. मैंने इससे फ्लॉट claim has been allowed by the arbitration tribunal and part has been rejected. So far as the part claim allowed against the state has also filed arbitration division, that is 74/23, in which this honorable court is directed to issuance of notice. Yes, when you heard on the question of admission, issue notice on payment of process fee by already more within 7 working days, returnable within 4 weeks. List this case along with AR number 74/23.
Are you praying for time alert? Outside council will allow.
What about the
Direction to
cleared? Then why did you file this application for ignoring the defect?
Malad, certain corporation copies are eligible. Malad, or
How do you say that you have cured the defects?
Malad, these pages has not a related malad.
Certified copy?
How will you find that?
कहाँ फाइल की सर्टिफाइड कॉपी आपने? इसका लिमिटेशन कैसे कैलकुलेट करेंगे? Suppose if you don't find the certified copy, limitation cannot be calculated.
Malad, I am praying for time alert. I will see it.
सर्टिफाइड कॉपी इधर पीछे लगी है। कब चाहिए आपको?
After Diwali vacation.
अरे भाई आउट स्टेशन काउंसिल की बात कर रहे हैं आप। After दिवाली लिख दो, फिर उस दिन आप डेट मांगे तो फिर नहीं मांगो ना डेट, कब आएंगे आपके आउट स्टेशन काउंसिल?
अरे नवंबर एक माला 28 27 28
क्या मालूम, बिना पूछे आप लोग खड़े हो जाते हैं। जो काउंसिल है उनसे पूछ तो लेते कि आप कब आएंगे आप यहाँ पे इंदौर?
मैं 27 और 28
27 को छुट्टी है। देखिए Learned Council submit that outstation council shall argue the matter, therefore a full state be granted as spread list on 28th of November. चलो will not be appellant
was appointed as a constable in CRPF in the year 2001. Yes, he went on leave from 9/2/2007 to 9/2/2007. 2 months leave. Thereafter,
He was granted 60 days leave earlier.
thereafter he failed to report for duty.
Yes.
And the period of absence is
And he also did not inform the authorities.
बिल्कुल ठीक है. No doubt about it.
Yes.
The period of absence is from 10/4/2007 to 15/4.
उसको क्या डाइस नॉट ट्रीट कर दिया उस पीरियड को?
How कर दिया sir? But why you saying that now? Now, what I'm submitting is his explanation was that when I was in my village, he said hardly any medical facilities. I fell ill. Now, we're not sitting here in Indore or Jabalpur. We cannot understand the problems of small villages where there are no medical facilities at all available. So he said, I went to Court-9 to my in-laws place to undergo treatment. Now, he kept on sending UPCs to his unit. In the meantime, his unit also was transferred from Pahalgam in Kashmir to somewhere in Assam. So the net result was that the employer had shifted from Kashmir to Assam, and the employee had shifted from his hometown to his in-laws town. Now, this resulted in his absence. And ultimately, he was dismissed after the Deputy Departmental inquiry. Now, the only submission,
What is the date of punishment?
15/4/2008.
15/4/2008. And then you approached this court in 23.
No, sir. I approached this court. The appeal was dismissed on 11/2/2010 by the highest authority.
24 अप्रैल 2010 को.
सर ये 11/2/10 को मेरी आईजी ने अपील खारिज की और 24/4 को मैंने कोर्ट में रिट लगा दी.
24/4/2010.
2010 से my petition remained pending till 25/9/23. Now his explanation was that I fell ill. Now, which is a rejoinder, he has filed a number of medical certificates. Now, the only submission, my lord, is that in such matters, the Supreme Court has said that para 21, my lord. That's it now. Para 21. What the court has said that the absence from duty should be willful. Before that, whether the same view is taken in para 16, 16 and 17. Sir. Para 17 says this: if the absence is the result of compelling circumstances under which it was not possible to perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control like illness, accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure of devotion to duty
or behavior and behavior.
The problem is he failed to prove what kind of sickness he had.
मेडिकल सर्टिफिकेट लगे ऐसे डॉक्टर के एंड द कोर्ट डिड नॉट लुक इनटू देम ऑन द ग्राउंड कि आपने पिटीशन के साथ फाइल क्यों नहीं करे, रिजॉइंटर के साथ क्यों करे. नाउ डोंट एक्सपेक्ट दिस काइंड ऑफ ए विजडम फ्रॉम ए कांस्टेबल फ्रॉम रीवा, स्मॉल टाउन, स्मॉल विलेज इन रीवा. उसने बेचारे ने सुप्रीम कोर्ट में पीआईएल लगा दी. सुप्रीम कोर्ट ने रजिस्ट्रार ने कहा यहाँ नहीं चलती है. Then he went to legal aid. Legal aid assigned him a counsel. That counsel said आप तो जबलपुर में पिटीशन लगाओ. And somehow he dragged his feet into this court. But don't judge him by our standards. Question is there any finding that the actions were willful? Did he stand to gain by not coming, my lord? और अगर ऐसा होता है, why would he keep fighting in the court? There is no reason not to join. So let this aspect be considered by my lords. That is the only subject.
ये रेस्पोंडेंट्स का डिस्क्रिप्शन भी बड़ा डाउटफुल है कि रायपुर में पार्टी बना दिया, छत्तीसगढ़ में है वो.
नहीं सर, वो
इंस्पेक्टर जनरल सेंट्रल रिजर्व पुलिस फोर्स मध्य प्रदेश,
वो सब सर्विस हो गई, सब एपीआर हो गए.
नहीं अपीयर हो गया, बट ये गलत है सब. ये
गलत है सर.
देखिए आप जाए
उस समय तो वही था ना.
लोकेश भटनागर है, फाइल दिस डेट पिटीशन.
देखिए जरा देखिए, सेक्रेटरी यूनियन ऑफ इंडिया एंड 3 अदर गवर्नमेंट होम मिनिस्ट्री, न्यू दिल्ली, मध्य प्रदेश.
वो एमपी तो सर वो गलत थी, वो हमारी गलती नहीं सर. लेकिन सही लिखा,
देखना पड़ता है, सब चीजें देखना पड़ता है.
नहीं पर वो
I think Mr. Bhatnagar would be careful in future. I also request.
All the 4 respondents are absolutely
गलत कर दिया एमपी.
total गलत है.
ये टाइटल में सर,
हाँ, ये काम कहाँ करते थे ये?
sir, you are posted with the unit in Assam. But with evidence,
Ultimately he was dismissed now.
Nimesh sir dismiss शेयर किएगा headquarter Nimesh में बना सर.
इमेज को किसी ने पार्टी नहीं बनाया है.
बना सर, ये जो आई ये सब निमेश के ही हैं.
नहीं, सिर्फ मध्य प्रदेश बस.
सर ये हमारी रेस्टिट्यूशन में आप देखेंगे.
ऑर्डर देखिए, फर्स्ट टाइटल देखिए, ऑर्डर का पेज नंबर 14.
नहीं वो तो सब क्या हुआ सर, मैं फिर निवेदन करूँ, हमारी रीट में सही है, ऑर्डर में एमपी कर दिया सर स्टेनो साहब ने.
नहीं ऐसा नहीं होता.
जी हाँ ऐसे ही हुआ. मेरी रीट में देखा आप.
ये रेंज का लाइन होती है, कंप्यूटराइजेशन है.
ये सर मेरा रीट का टाइटल,
ये रेंज का टाइप.
ये रीट का टाइटल.
उसके बाद ये सर हमारा ओरिजिनल रेंज का टाइटल. माय लॉर्ड में सी द ओरिजिनल रेंज टाइटल.
हाँ ठीक है, वो हमारे स्टेनो की गलती है.
हाँ सर, आई एम रिक्वेस्टिंग माय लॉर्ड.
वहाँ देखेंगे अब ये प्रॉब्लम शुरू हो गया
तो सर
इतना भी देखो गलती रह ही जाती है.
to give him a break. That's all. Now, even if he is brought back, he will probably be retiring soon. सर दिल्ली फिर ग्रेड 5-6 साल की नौकरी बाकी है उसकी. तो माय लॉर्ड में सिंपैथेटिकली कंसीडर दिस केस. दैट इज द रिक्वेस्ट. बिकॉज़ वी हैव नो रीजन नॉट टू जॉइन. होता तो फिर ये ऐसे दरवाजे को मांगता रहता सब. ये देखने वाला भी नहीं है. So the absence does not appear to be willful. There is some kind of an excuse given by way of medical certificates. So let us give him a break.
How have you explained the delay?
इनने कहा अपील के बाद इमीडिएटली
P1 जो है 2008 का ऑर्डर है, P2 2009 का है. नहीं 10 का.
पिछला सब सर ये डिसमिसल है 15/4/2008 का. Within time an appeal was filed. Appeal was dismissed by the DIG on 11/8/2009. Then there is a further appeal provided to IG. IG decided my appeal on 11/2/2010.
15 साल के बाद आ रहे हैं सब.
April में इस कोर्ट में आ गया.
Reply was filed or not? Reply पेश किया था.
It was fine.
So I am requesting my lord to take a sympathetic if possible and give him chance.
We issue notice first. Issue notice. You accept notice?
I am accepting notice on behalf of Union of India.
All four. All the ones. Well, the three of them. Notice on the arms. First week of December. I'm little. So. Waiting for passport. Passport. Please, Your Honor. The issue before the magistrate regarding duty substituted section 129, my lord would find it at page 10 and 11 of the return. Is it read up in? Where is the order? The impugned order is annexure A25 and it begins at page 160. Para 5 minute at page 164. MPLR से जो मेरा 129 section page 10 और 11 पे reproduce किया है मैंने relevant. Bill. Lordship, page 11, Mano. Yes. Section 5 and 6 are relevant. Before your Lordship goes to it, if there is a pre-existing demarcation of lands between two individuals and one feels aggrieved under subsection 5, he can apply to the STO. Now, under subsection 6, before considering that application made against a previous demarcation, the SDO has to hear everyone and consider to make an inquiry. You will also kindly see subsection 6 without page 11. The sub-divisional officer may, if he admits the application made under subsection, after giving opportunity of hearing the parties interested, including the neighboring landholders, and making such inquiries as he may think fit, either confirm the demarcation report submitted under subsection 2 or include a team consisting of such persons as may be prescribed to carry out demarcation oneself. So he can either confirm the previous demarcation or direct a fresh demarcation. Now in this case, if your lordship sees annexure A8, page 58, my lord, the respondent number 3 filed an application on 9th of February 2020 for demarcation. Page 58, my lord. Before the Tehsildar. And next page, my lord would find that case was registered. But the civil suit has been filed and in that injunction is there? No. They have filed it, you know. That is the factual aspect. So this respondent number 3 applied for demarcation. Case was registered, page 59. Then below on 6/3/2020, the demarcation प्रतिवेदन was given, which is 61, my lord. On 4/3/20, demarcation was carried out. On 6/3/20, Panchanama was wrong, that my lord would find at page 62. And this report demarcation was accepted by the Tehsildar at page 60. The hard copy is there, madam, 20th March 2021. Page 60, bottom, my lord. March 2021. Yes, he accepts this report. Now, the respondent number 3 lies under 129(5) that my lord will find at page 75 on 1/12/21. This is an application given by respondent number 3 under 129(5). Yes. Now, my lord, based on this, a case is registered, which my lord will find at page 77. By the SDO, my lord. Now, please see the proceeding at page 79, my lord. 11/2/22. प्रकरण पेश, अभिलाष के अधिवक्ता उपस्थित, एलसीआर अभिलाष के अधिवक्ता द्वारा मौखिक तर्क पेश, न्यायालय द्वारा अंकित किया गया अवलोकना। So he doesn't pass an order under 126. Then we not please see at page 90 on the very same day, without passing an order under 129(6). Forget about hearing or issuing notices to the landowners. He constitutes a team for fresh demarcation. सीमांकन दर गठन आदेश. This is 11/2/22. So without any order, without any hearing, without any notice, and this aspect has already been dealt with by another coordinate bench that your lordship would be pleased to find at page 166. A similar writ petition came on 27th of June 2023 in WP 3204 of 22. Kindly see the order, madam. Identical facts, madam. Your lordship may kindly see in paragraph 7 at page 170, section 129 is reproduced. And please come to the operative portion, madam, page 172, paragraph 10. Subsection 6 of subsection 6 of section 129 of MPNRC says that subdivisional officer, if he admits the application made under subsection 129 of MPNRC, then he shall give an opportunity of hearing to the parties interested, including neighboring landowners, and making such inquiry as he may think fit, either confirm the demarcation report submitted under subsection 2 of section 129 of the MPNRC or depute a team consisting of such persons as may be prescribed to carry out demarcation once again. Therefore, it is incumbent upon the SDO to first examine the order passed by the Tehsildar under subsection 4 of section 129 of MPNRC, giving an opportunity to counsel in whose favor the order is passed, neighboring the landowners, then decide whether to confirm the report submitted under subsection 2 of section 129 of MPNRC or depute the team consisting of such persons to carry out demarcation once again. Under subsection 6 of section 129 of the MPNRC, the procedure is prescribed for conducting a demarcation, and after obtaining the fresh demarcation report, the subdivision officer may pass on identical facts. Yes, this petition has been allowed. Yes, that he has to apply his mind here. There is a without an order conducting a fresh demarcation. इसमें civil suit था क्या इसमें? Yes, ma'am. इसमें kindly see the facts. The facts are mentioned in paragraph 3, madam. But it was 250 proceeding, my lord, based on demarcation. And when this objection is raised before the SDO, or the order of SDO, your lordship will be to see order of the SDO, my lord, is 15/10/2022. Your lordship will be pleased to find 116. When I came to know about this, I went to the SDO saying that you are not following the law. At page 118 in paragraph 7.2, he says that these objections do not relate to 129. The impugned order begins at page 116, which was impugned in the writ petition. Page 116 is my lord, are pleased to come to page 118. शब्दों को उठाया गया और संहिता की धारा 129 से संबंधित नहीं है. Strange, madam. And the observation of the honorable single judge. So this impugned order before the lordships in paragraph 5, page 164 is that I have raised technical objections. This is how the honorable mid-court approaches. This is 164. The petitioner has assailed the impugned order only on technical ground. The procedure prescribed under section 129 of MPNRC has not been followed in total. In fact, my lord, demarcation took place in 1997 between the very same parties. And the other side agreed. That report is also before the docket. That position is maintained since 1997. They came to know the situation obtaining on the spot. There is a glaring mistake.
Without passing an order, you are constituting a fresh team for demarcation. Contrary to law.
ये ऑर्डर तो ऑलरेडी एग्जीक्यूट हो गया होगा 17/10/22 का।
सर 17/10/22 में तो मेरे ऑब्जेक्शंस रिजेक्ट किए उन्होंने ये कहते कि they do not come within the purview of 129. Let us confirm that demarcation report. Now, based on the demarcation report, the other side will proceed definitely in accordance with law.
नहीं तो फ्रेश टीम को कॉन्स्टिट्यूट हुई, दैट इज ऑर्डर 18
11 to 22. That is A13, my lord, page 90.
will issue notice.
The demarcation behind my back, my lord.
Issue notice, CF returnable 4 weeks.
And I'm only seeking indulgence that this A20, 17, 10, 22, this may kindly be stayed because he rejects my objection by this and confirms that demarcation report without hearing me.
But you have not assumed that fresh order of demarcation.
No, I did it before the SDM, madam. I did it before the SDM.
No, here in the application for stay,
And only not asking for stay. Only saying that this impugned order which is passed by the SDO, which was impugned before the honorable single judge, the effect and operation of that order may kindly be stayed.
let them come, we'll hear it finally.
Well, it will only give complications because
Nothing is going to happen. 2022 से कुछ नहीं होता, अभी क्या हो जाएगा?
it will proceed under 250. We have already filed 250 based on that demarcation report. We have filed a civil suit in civil court. But that order of SDO is prima facie illegal, my lord. That may kindly be stayed.
डिमार्केशन को आप स्टे मानते हो?
नहीं, demarcation तो नहीं मान रहा हूँ सर.
हाँ,
It is the order of SDO which puts a seal on demarcation. On 129/6.
बड़ी पुराना ऑर्डर है ना, सब उसमें कोई ऑर्डर तो है नहीं 17/22 में.
Single state has no. There was an interim order before the honorable single judge. There was an interim order.
But what is the 1710 annexure fee? 2020.
Number, page number is below 116. Sir, LDC, each two paras.
सीमांकन स्वीकृत किया जाता है.
He rejects my objection. I objected to that demarcation.
मतलब ठीक है, इसको स्टे करने से क्या होगा? अभी you hear and decide it finally.
There was an interim order.
Maybe, but I don't think there is any requirement of any further
Interim
interim
order signed. This was not.
ये होगा ना, उसको होगा. बट इसमें क्या है, सीमांकन दल द्वारा दिए गए 8/4/22 को किए गए सीमांकन स्वीकृत किया जाता है. दैट्स ऑल.
Yes.
रिटर्नेबल 4 वीक्स कर दी.
This matter. It's a matter pertaining to the election of state dental council matter. The petitioner has preferred in petition before this honorable court manner. For the direction,
State Dental Council.
state dental council. For the direction to the present appellant manner that members of election be notified in the official gazette. An election of president and vice president be conducted. This was their prayer in the petition manner. The next single judge manner dispose of the petition with the direction by assuming that manner that election has already been notified by the president, whereas in the official gazette, president has no power to notify the election. And second manner directed that within 15 days the election of president and vice president be conducted. He has also assumed that the 8 members which are elected members, they will conduct the election of president and vice president only and notify within the 15 days. This was the direction issued by the single judge, my lord. But before I start, my lord, kindly consider some dates, my lord. On 23/2/2019, my lord, DME appointed Mr. Harish Chandra as
There
registrar.
is a direction to complete the election.
Complete the election cannot be done because that Malad in the year 2019 Malad, before I start Malad, this is a state dental council election Malad. It has to be conducted in 2 stages Malad. The first stage Malad is the election of four members from the A register, A category register, and 4 members from the B category register. Malad, the election program was declared. Thereafter, Malad, these 4 members have been elected from A category register and 4 members have been elected from B category register. Thereafter, Malad, this election was required to be notified in the official gazette. For that, President has written a letter to the state government. The state government, the Principal Secretary, State Government will forward the letter to the Law and Legislation Department to notify the election, Malad. Malad, this process has not been done, Malad, and therefore they have
Election not notified.
in the meanwhile, the state government has issued
No direction, a direction to the government.
election process within 15 days and notified. There is a 2 stages, Malad. Second stage, Malad, here the elections of president and vice president amongst the members. तो members में 8 members नहीं होते हैं. Members में इसीलिए मैं demonstrate कर रही हूँ.
पूरा प्रोसेस करिए ना आप.
नहीं हो सकता है क्योंकि हमने डी कैटेगरी के जो मेंबर्स हैं उनको ओमिट करते हैं in the year 2019 itself. And now the entire act has been repealed and new act has come along. And as per the new act, the election is not required, madam.
रिटर्न फाइल किया था आपने?
Yes, madam. We have filed our return. और हमने ये भी कोर्ट का ऑर्डर में भी आया है कि ड्यूरिंग द पेंडेंसी ऑफ दिस पिटिशन ऑन टू
इलेक्शन इज नॉट रिक्वायर्ड नाउ.
no election is not required. State government will constitute the verdict. No act we have to do. दो 2023 में एक्ट आया है.
ये जो 8 मेंबर्स का इलेक्शन ऑलरेडी हो गया है जी.
8 मेंबर्स का इलेक्शन हो गया.
हो गया. प्रेसिडेंट एंड वाइस प्रेसिडेंट elect the members. That's right.
President and vice president will be elected as per the section 21 and 25. If your lordship will permit, I will read the order, Malad, from para 6. Subrule 1 of Rule 20 says that returning officer shall publish the result and date of election in the Madhya Pradesh Gazette in the case of first election, and also send report to the government about the election. Subrule 2 of Rule 20 in case of election other than those held for the first time under the Act, the returning officer shall inform the president of the result and date of election, who shall then publish the same in the Madhya Pradesh Gazette. The returning officer also send a report to the government about the election. It is pertinent to mention here that this is for not first election of the members under the Act, therefore Rule 20 subsection 1 will not apply. The returning officer, after notification dated 24/4/19, initiated the election process and completed and sent the information to Principal Secretary, Department of Medical Education, Director Medical Education, and President MP State Dental Council by letter dated 27/5/19. So far, its process of election members of the council had already been completed. Thereafter, under Section 7, it was for the members to elect the president and vice president for the period of 5 years. After the information given by the returning officer, the president had notified the election, which is filed as page 12 and 13 of the return. Therefore, it was for the 8 elected members to conduct the election of the president and secretary, which was not done in the case. So far as repealing of the Dental Act is concerned, Section 59(3), the National Dental Commission Act 2023 takes care of transitory provision, and according to which, notwithstanding the repeal of Dentist Act 1948, the State Council and the Joint State Council constituted respectively under Section 21 and 23 of the said Act shall continue to operate until a new state dental council is established by the state government in accordance with the provisions of Section 29 of this Act. Section 29 provides the establishment of state dental council or joint dental council, and section 56(1) gives power to the state government to make rules to carry out the provisions of section 29 and section 48 of the Act. Till that, the state government has not notified the rules to carry out the provisions of 29 of the Act. Therefore, the state dental council cannot be established under the Dental Act, and rules made thereunder shall continue. Therefore, as per the transit provision under section 59(3), the state dental council shall continue till establishment of new. Now, my lord, may kindly consider this is the Act, my lords. This is 2023 Act also, 48, और ये rules है, my lord.
Eight members already elected, है ना?
8 members elected, but election of president and vice president is not to be conducted by 8 members. बहुत सारे लोग होते हैं, बहुत सेक्शन में
बताइए कैसे?
My lord, may kindly consider section 21 of the 1948.
Dentist Act.
1948 के जो एक्ट है, my lord, डेंटल काउंसिल एक्ट, डेंटिस्ट एक्ट
Section
21. स्टेट का जो ऑर्डर में वो किया है, वो सेंट्रल के सेक्शंस उन्होंने रिप्रोड्यूस किए हैं, चैप्टर 2 में आते हैं, और जो स्टेट डेंटल काउंसिल है, चैप्टर 3.
Chapter 3. 21.
Constitution and composition of the state council. Except where a joint council is constituted in accordance with an agreement made under section 22, the state government shall constitute a state council consisting of the following members, namely 4 members elected from among themselves by dentists registered in Part A of the state register, 4 members elected from among themselves by dentists registered in Part B of the state register. The heads of the dental colleges, if any in the state, which train students for any of the recognized dental qualification included in Part 1 of the schedule ex officio. 1 member elected. This is also one of the election manner. 1 member elected from amongst themselves by the members of the medical council or the council of medical registration of the state, as the case may be. 3 members nominated by the state government. The chief medical officer of the state by whatever name called ex officio, provided that in the state of Saurashtra. Thereafter, madam, kindly consider section 25. The president and vice president of the state council shall be elected by the members amongst themselves. So, member is not these 8 members.
Yes, no, the state council shall be elected by the members from amongst themselves.
Amongst themselves. So, members are these given in the section 21. A, B, C, D, E, F जो दिए हैं. It is not that only 8 members will elect president and vice president. The government का एक nominated person होता है. उसके बाद में election के through एक person होता है medical council से. There are number of persons who are required to be. And thereafter, section kindly consider section 31 also. Repression and maintenance.
Modify कर दिया तो
Modify नहीं हो पाएगा because we have deleted. We have visited, madam. Kindly see my written, madam.
then how this council would be established?
But at present, अभी तो ये एक्ट ही उन्होंने रिपील कर दिया 2023 के एक्ट से. अब तो ये एक्ट ही रिपील हो गया. And in this particular matter, before the notification of the election, well, 17 July 2019 itself, the act has been amended, madam, in section 3 of the Dentist Act as well as in section 21 of the Principal Act. Clause B shall be omitted. And what is B, madam? B is 4 members elected from themselves by dentists registered in Part B of the state register. And thereafter, in the August 2023, this act is repealed, madam, and new act has come, madam. So, firstly, madam, the election has not been notified. Thereafter, madam, there is no notification. The learned Siddhant has wrongly given the finding that president has notified the election. It was only a pro forma. Thereafter, madam, this C category members are already omitted, madam. The effect of omission will be, madam, that It does not exist. And thirdly, it has already been repeated. So, ज़्यादा से ज़्यादा ये होगा कि registrar will take. It is not a political election law. They are the elected bodies for the purposes of maintaining this register manner. Under section 31.
So their only prayer is to get the president and vice president elected.
They are the members of B category, and now that does not exist, man. In the year 2019 itself, that does not exist, man. So they cannot be elected for as a vice president, president, man.
Announce that.
जो नया एक आया है सर, उसमें उन्होंने कहा है कि उसका सेक्शन 58 है.
Electoral Commission Act.
29 में उन्होंने कहा है, मतलब 29 है, पेज नंबर 16. The state government shall within 1 year of the commencement of this act take necessary steps to establish a state dental council having the following composition, namely.
तो कब से एप्लीकेबल होगा ये एक्ट?
It is applicable 11th August 2023. And the learned single judge has taken the
11 single judge के सामने amendment आ गया.
हाँ ये रखा लास्ट पैराग्राफ में आ रहा है क्योंकि ये रिप्लाई में नहीं आ सकता था तो उन्होंने ट्रांजिटरी प्रोविजन का वो देते हुए कहा कि आप अपॉइंट करें but that provision has already been omitted मैडम in the year 2019 they have not existed और omission का भी मिल जाएगा कि they never existed. It's not कि ये रिपील हुए या ये अमेंड हुए हैं. They never existed. तो जब आप एग्जिस्ट ही नहीं करते आपके आपसे तो इलेक्शन हो नहीं सकता.
तो आपको रिव्यू लगाना चाहिए था ना वहीं पे. You could have brought this to the notice of the learned single.
But there are number of because within 15 days it has been directed and there are so many.
Yes, what do you say?
But altogether, an entirely new case has been before this Honorable Court, my lord. In the written, they have only said that the provisions of section 21, subsection B, has been omitted from the book of the statute. Therefore, this, so far as the College of the Electorate is concerned, my lord, Part B, register, the person who have been elected from the Part B are not entitled to participate or claim for any further election, my lord. But few dates are very relevant, my lord, in this case. The election was notified in the February 2019 and the election process was completed so far as the members are concerned, my lord, from Part 1 and Part B of the register. That was completed on 27/5/2019, my lord. After election of those 4 members from both the parts, my lord, the returning officer informed the president of the then council, my lord, and as the government also, my lord. Thereafter, it was the duty of the state government to notify the further process of the election, to appoint the returning officer, to conduct the election of the president and the vice president from the members as has been mentioned in the section 21, my lord. We are not saying that only out of 8 members the election should be conducted, my lord. It may be conducted from the among the members which has been mentioned in clause 21, my lord. Now their case, my lord, which has not been even argued before the learned single judge regarding the effect of the omission, my lord. For the first time, they have come forward with this case, my lord. There is a averment in their written, but it appears that this has not been argued before the learned single judge, that since the provisions of section 21 class B has been omitted, therefore the respondent number 1 is not entitled to claim conduction of the election of the post of the president and vice president, madam. They rely on what is the legal provision. Coming to that, madam. But they have relied on the judgment of this Kolhapur sugarcane one and section 6A of the General Clauses Act. But in my humble submission, both neither the judgment of the Kolhapur sugarcane is applicable, nor the provisions of section 6A of the General Clauses Act to apply. You actually first kindly see the provisions of section 6 of the General Clauses Act.
ये नोटिफिकेशन तो पहले ही हुआ था ना 2019 में हो गया
इलेक्शन मेरे इलेक्शन हो जाने के बाद में ये नोटिफिकेशन हुआ, पूरा प्रोसेस शुरू हो चुका है. राइट हैज बीन एप्रूव्ड इन फेवर ऑफ द रिस्पोंडेंट नंबर 1 बाला. Thereafter this omission has taken place. What would be the effect of that omission that has been taken care in the section 6 of the General Clauses Act? Effect of repeal, where this any central act regulation made after the commencement of this act repeals any enactment either to made or hereafter to be made, then unless a different intention appears, the repeal shall not. Then my lord may kindly see B, clause B and C. Affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder, or affect any right, privilege, obligation or liability acquired, accrued or incurred under any enactment so repealed. So the section 6 of General Clauses Act has taken care of the effect of omission of any provision, but it is the settled position of the law that the procedural, so far as the procedural law is concerned, it has retrospective effect. So far as the substantive provision is concerned, it will always operate as the prospective effect. But they have relied on section 6A of the General Clauses Act, which has no application. Kindly see section 6A, it talks about repeal of any amending act. Lakshmi, just kindly have a look. Where any central act or regulation made after the commencement of this act repeals any enactment which the text of any central act or regulation was amended. So section 6A talks about repealing of any amending act.
Repeal shall not affect the continuance of any such amendment made by the enactment.
So far as the present case is concerned, here no amending act has been repealed, with full force the provisions of section 6 of the General Clauses Act would apply in so far as the present case is concerned, because the process of election was started, ARVIND declared as elected, and thereafter they did not completed the process, Some persons have vested interest, they occupied the post of the president, without any authority of law, even after completion of their period, Therefore, this petition was filed in the month of June 2019. It could not be decided, it has been very recent. Now, the judgment on which the other side has relied, that is reported in 2002 SCC page 536, इसमें सर एक कोल्हापुर सुपरकेन कंपनी क्या है साइटेशन साइटेशन इज 2000 वॉल्यूम 2 एससीसी पेज 536 कोल्हापुर yes my lord, it's a Kolhapur Cane Sugar Works Limited and other versus Union of India. The main company was constituted in the year 1936. Thereafter, somewhere in the 70s, my lord, a subsidiary company of this present Kolhapur Cane Sugar Works Limited and another was constituted. इन्होंने कुछ सेंट्रल एक्साइज के बेनिफिट्स वगैरह लिए थे, उसको जब डिपार्टमेंट को ये लगा कि इनको बेनिफिट गलत दे दिया, इन्होंने सेक्शन 10 और 10A के अंतर्गत के खिलाफ
सेक्शन 6 ऑफ द जनरल क्लॉजेज एक्ट,
इसके अंदर ये होगा, इसके अंदर ये प्रोसीजर था, मतलब इसमें सेक्शन 10 और 10A के अंतर्गत प्रोसीडिंग शुरू हुई थी, बाद में अमेंडमेंट होकर नया सेक्शन उससे सब्स्टिट्यूट किया 10. तो कोर्ट ने, सुप्रीम कोर्ट ने यही कहा है कि ये प्रोसीजरल अगर कोई चीजें हैं तो वो इसका इफेक्ट रिट्रोस्पेक्टिव हो सकता है, वो उस नए सेक्शन 10 के अंतर्गत 36 of that judgment, 37 of that judgment, I may be permitted to read some relevant paragraphs of this judgment, my lord, which will make the position very clear, my lord. So first of all, my lord, may kindly see para 2. The common question raised in all these cases relates to the applicability of Rule 10 and 10A of the Central Excise Rules. These cases were heard together with the consent of the learned counsel for the parties, and they are being disposed of by the common judgment for the sake of brevity. The relevant section is stated with the reference to the civil appeal number 2132 of 1994. Now, let me kindly see. Further there, Kola versus Kolhapur Sugar Mills Limited, a holding company, had been business in production of sugar at Kolhapur since the year 1933-34. The appellant versus Kolhapur Cane Sugar Works Limited was registered as a subsidiary of the said holding company in the year 1972. The holding company bifurcated their activities, whereby the activities pertaining to the manufacture and sale of the sugar was transferred to the appellant company by a resolution passed in their extraordinary general meeting held on 19/10/1972. Consequent upon the change in the appellant on 9/10/1973, applied to the assistant collector, Central Excise Kolhapur for 8-4 license for the manufacture of sugar. In the letter, the appellant had stated they had taken the sugar undertaking from the holding company. It was also stated in the letter that the holding company was having L4 license during the year 1972-73, and they had manufactured sugar during the session and were having sugar stocks in the godown now belonging to the appellant. On receipt of the letter, necessary certificate was issued to the appellant to start business on 15/11/1973, pending issue of L1. Ultimately, मतलब इसमें जो procedure के बारे में अगर if there is any amendment in an institute, then the effect of the repeal would be that it would have the retrospective effect, as if that provision is not on the book of the institute, my lord. But so far as the present case, which is before your lordship, my lord, a substantive right has been created in favor of the respondent number 1. Therefore, this judgment and the provisions of section 6A would not apply, my lord. I have just argued before your lordship, my lord, that so far as the section 6A is concerned, my lord, it would apply only in the cases where any amending act has been repealed by the subsequent enactment, my lord. So, with this section 6 would apply with full force, my lord. Now, my lord, the next contention is regarding the this Act of 2023 is concerned, but there is no pleading in the their written regarding this matter. Came into, according to them, force with effect from 11th August 2023. Mala. This would also of no assistance to the other side, Mala, for the simple reason because my election has been started under the old provision, Mala. The reason best known to them, Mala, they have not completed the process. Mala. Without otherwise it would have been completed in the year 2019, Mala. तो मेरे को 5 साल का period from the date of election से मेरे को मिलता है. अभी भी इनके हिसाब से उससे चलेगी इलेक्शन, इनका कहना है कि अभी नोटिफाई नहीं हुआ, तो जब ये बजट में नोटिफाई करेंगे उससे 5 साल मिलेगा मेरे को. और so far as the Act of 2023 is concerned, my first submission is that, my lord, I have a substantive right under the old provision. Secondly, my lord, this act has not been adopted by the state government till now. No rules have yet been framed by the state government, my lord. As has been also by the learned single judge in this case, my lord. So, my lord, there is no reason for challenging the order. I fail to understand why the state is taking too much pain to challenge this order, because they are duty bound to complete the process even in the year 2019 itself. It clearly shows that for some vested interest of some persons, the state is playing in the hands of those people.
Kindly consider the para 37 of the judgment, which of the Kolhapur case. Where it says if a provision of a statute is then conditionally omitted without a saving clause in favor of pending proceeding, all action must stop where the omissions find them. And if final relief has not been granted before the omission goes into effect, it cannot be granted afterwards. Savings of the nature contained in section 6 or in all special acts may modify the position, thus the operation of the repeal and deletion as to future and the past largely depends on the savings applicable. Malad, it has been deleted in toto. Nothing has been stated whether their right has been accrued or not. Once it has been omitted, Malad, it will be presumed that it does not exist. There is another judgment of the Supreme Court, Malad, in which all these judgments have been considered.
So the elections would take place afresh again.
Malad, because they have been deleted. तो ये एग्री नहीं होता because they have been deleted. Repeal, deletion और omission सभी का एक meaning है. And the moment they have been deleted, they are omitted manner. It will be presumed that they have been omitted. और इसका जो पैरा है मतलब इस जजमेंट का
What about section 6 of the General Clauses Act?
6A will be applicable manner because manner there should be intention has to be seen. What was the intention of the legislature man? Because they are not the eligible members. इनका ये जो members है मेरिट B कैटेगरी के, they does not hold me qualification. अगर आप मुझे परमिशन दें तो सेक्शन 30 का
सिक्स से कैसे एप्लीकेबल होगा ये बता मुझे जरा सर। सिक्स से कैसे
सेक्शन
applicable?
30 जो है उसमें क्लियरली ये कहा हुआ है कि they are the members who does not hold any specific qualification.
से कैसे एप्लीकेबल?
Textual amendment Act of regulation made after the commencement of this act repeal any enactment by which the text of any central act or regulation which was amended by express omission, insertion or substitution of any matter, then unless a different intention appears, the repeal shall not affect the continuance of any such amendment made by the necessary period and in operation at the times of submission.
अमेंडमेंट जो एक्ट है जिससे अमेंडमेंट लाया है मेन इंस्टीट्यूट में उसको रिपीट किया है।
The act is now been repealed, my lord.
By which the text of any regulation, act repeals any enactment by which the text of any central act or regulation was amended.
The power has been given to the state government to appoint the president and chairman and
ठीक है सर, I am also placing reliance on one more judgment, 2022 6 SCC, page 704. Relevant paras are 11 and 13 बना। मैं read ना? This court is under in so and so as under the above decision right for established and our decision in the Janardhan Reddy versus State in Ganpat Rai Hilalal versus so and so hold the principle that a right of appeal is not merely a matter of procedure. It is a matter of substantive right. This right of appeal from the decision of an inferior tribunal to a superior tribunal becomes vested in a party when proceedings are initiated and before a decision is given by the inferior court. In the language of Jenkins and so, an existing right of appeal is not a mere alteration in procedure. Such a vested right cannot be taken away except by express enactment or necessary entanglement. The intention to interfere with or to impair or impairing such a vested right cannot be presumed unless such intention be clearly manifested by express words or necessary implication. In our view, the above observation is apposite and applies to the case before us. The true implication of the above observation is to the decision in the other cases referred to above that the pre-existing right of appeal is not destroyed by the amendment if the amendment is not made retrospective by express words or necessary entanglement. This fact, the pre-existing right of appeal continues to exist must in its turn necessarily imply that the old law which created that right of appeal must also exist to support the continuation of the right. If the old law continues to exist for the purpose of supporting the pre-existing right of appeal, the old law must govern the exercise and enforcement of that right of appeal, and there can then be no question of the amended provisions preventing the exercise of that right. Argument that authority has no option or jurisdiction to admit the appeal unless it is accompanied by the deposit of the assessed tax is required the amended provision to section 22(1) of the Act. Overlook the fact existence of the old law for the purpose of supporting the pre-existing right really amounts to begging the question. The new proviso is wholly inapplicable in such a situation and the jurisdiction of the authority has no exercised under the old law which so continues to exist. The argument of SHRI Ganpat Iyer on this point therefore cannot be accepted. Finally, SHRI Ganpat Iyer frankly urges that until actual assessment there can be no list and therefore no right of appeal can accrue before the event. There are two answers to this plea. When
whenever there is a proposition by one party and an opposition to the proposition by the another, list arises. It may be considered, not deciding it, that when the assessee files the return, list may not immediately arise. Further, section 11(1) of the authority may accept the return is correct and complete. But if authority is not satisfied as to the correctness of the return and calls for evidence, surely the controversy arises involving opposition by the assessee and the opposition by the state. Circumstances that the authority who raises the dispute is himself, if himself the judge, can make no difference. For the authority raises the dispute in the interest of the state and in so acting only represent the state. It will appear from the dates given above that in this case, the list in the sense explained above arose before the date of amendment of the section. Further, even if the list is to be taken as arising only on the date of assessment, there was a possibility of such a list arising as soon as the proceeding started. With the filing of the return or any rate, when the authority called for evidence and started hearing, and the right of appeal must be taken to have been in existence even at those dates. For the purpose of this, of the right of the appeal, critical and relevant date is the date of initiation of the proceeding and not the decision itself. Then, madam, kindly lastly, there are 13. In a three-judge bench judgment of State of Bombay versus Supreme General Films Exchange Limited, the arguments which arose for consideration was that the court fees payable on the memorandum of appeal would be as on the date of filing of the suit and not as per the amendment in this court fee act. 1870 of Bombay Act of Act number 10 of 1951, the court fee on the memorandum of appeal was thus held to be payable as was applicable prior to the amendment of Act. This court held as under Malad and ultimately has held that a right, if the right has been accrued in favor of the party, तो वो जो provision उस time थे वो लागू होंगे, ना कि amended provision.
पॉलिटिकल तो हमने आपको 2016 का डिसीजन दिया है, उसका पैरा 16, 12, 13 and 23. In fiber board case, it has been held that the omission, repeal, everything will be considered it does not. Right has not been held.
Judgment के सर में भी पैरा 2, 8, 9, 12, 13, 14 and 36 में rely कर रहा हूँ सर 2003. पैरा 2, 8, 9, 8. ये 2000 जो जिस पे आप rely कर रहे हैं जी जी वॉल्यूम 2 का सर पैरा 2, 8, 9, 12 to 14, 36. 12 to 14, पैरा 36 and 36. में भी कुछ ऐसी बात नहीं, उन्होंने यही कहा है सर कि
और एक चीज सर है कि रूल्स में जो है डिक्लेरेशन ऑफ रिजल्ट्स दिया हुआ है रूल 18 में,
ये सब सब पूरा नया कैसे
कि हमने आर्ग्यू नहीं किया था
अगर हमने आर्ग्यू किया था और
because the learned single judge observed that we have raised this point. हमारा रिप्लाई भी ढंग से थोड़ी नहीं पढ़ेंगे.
यस
आइए डिले कंडोम कर दीजिए. एडमिट इश्यू नोटिस पीएफ लेवल 4 वीक्स ऑल फॉर द रिकॉर्ड्स. चलिए नेक्स्ट
सर लक्ष्य में एक आइए था कि वो शादी नहीं करे साथ में.
आइए उसको ना इंप्रूव स्टेट पार्टीज आर डायरेक्टेड नॉट टू रीमैरिज इन द स्टेट ऑफ ईयर. चलिए नेक्स्ट कन्वर्ट हो गए.
रेस्पोंडेंट में सेक्शन 11 एंड सेक्शन 27 एक्ट में पिटीशन फाइल की थी फैमिली कोर्ट में.
अभी क्या होगा फर्स्ट अपील हो गई है.
फर्स्ट अपील मैं कर दी थी, उसको कन्वर्ट किया फर्स्ट अपील में. उसमें एक्सपर्टी जो जजमेंट डिग्री हुआ था उसको सेटिस्फाइड कराने के लिए ऑर्डर 9 रूल 13 में हमने एप्लीकेशन फाइल की थी. 13 9/13 की एप्लीकेशन डिसमिस कर दी है, उस ऑर्डर को चैलेंज किया उसके खिलाफ। और अर्लियर एक हमारी एमपी भी पेंडिंग थी, उसमें स्टे ऑर्डर कंडीशनल स्टे हुआ था, एग्जीक्यूशन प्रोसीडिंग का पड़ेगा,
फाइनली सुनना पड़ेगा उसको।
यस लॉर्डशिप। और मेरा ये बताया कि इसमें जो है इन्होंने जो मिलिट्री रिलीफ भी दिया है इनको, 5 लाख रुपए कंपनसेशन और 1,20,000 रुपए ऑर्नामेंट्स के, और 7 लाख रुपए जो एक्सपेंसेस किया है वो
उस
किया।
पॉइंट में अपन क्यों जाएंगे अपन
एग्जीक्यूशन प्रोसीडिंग पेंडिंग है, तो हमारी एमपी में भी स्टे था हमारा, स्टे में उसके नेक्स्ट डेट तक के लिए स्टे कर दिया जाए, रिकॉर्ड हो जाएगा, फाइनल हो जाएगा।
मेरा सबमिशन है लॉर्डशिप।
और कल लगा हुआ है मेटल्स,
ये इतना इजी और ऐसा नहीं है, बहुत ही
इजी नहीं है वो प्रोसीडिंग
आप सबमिट करने देना है असिस्ट लॉर्डशिप्स।
3 दिन में तो फिर ऑर्डर हो गया, 7 तारीख को, 11 तारीख को एक्सपायरी हुआ और 14 तारीख को फैसला हुआ।
My level field is finished off, then I'll assist proper facts lordship. Important aspect है मैटर का।
ये एमपी में जो स्टे था,
ये आपका हो गया हो तो फिर इनसे पूछे अपन।
ठीक, मेरा तो ये निवेदन है सर कि इसमें जो है कि आप प्रोसीडिंग देखें सर, ये प्रोसीडिंग मैंने पेश की है, पेज नंबर 38 से चालू।
इस एमपी में क्या चैलेंज किया था आपने?
एमपी में जो एग्जीक्यूशन प्रोसीडिंग में मेरे को कंडीशनल स्टे दिया था कि 2 लाख रुपए जमा करें, तो उस स्टे
एमपी पेंडिंग है अभी?
नहीं, वो इसलिए इन्फ्रक्चर्स हो गई क्योंकि ऑर्डर 9/13 के डिस्पोजल तक हमने स्टे मांगा था, तो वो चूंकि ऑर्डर 9/13 डिस्पोज हो गई, तो वो विड्रॉ कर ली थी हमारे से लिबर्टी के साथ में कि ये आप क्लियर हो गए थे, उसको विड्रॉ किया, ये पॉइंट इसमें रेस कर। वो देखेंगे सर आप, मैंने प्रोसीडिंग सारी पेश की है, पेज नंबर 38 से सर प्रोसीडिंग की कॉपी।
एक्सपायरी ऑर्डर 49/2019 को स्टे करना के लिए मांग रहा है, 23 में से स्टे करना।
Yes, lordship. Appellant herein is a government of MP gazetted officer. She was married to sitting CSP Manoj Ratnakar in 1999. She honey trapped this Indian Army major who is respondent from KVS. Yeah, she honey trapped him. And she married him without disclosing that she is already married and she has 2 major daughters. When they married, they traveled across India. They celebrated honeymoon in Andaman. They went to Gir Forest. They went to Daman and Diu. They stayed in all 5-star hotels of Indore, 5-star hotels of Bhopal. They have enjoyed vacations in government guest houses. When this fact was discovered, so I filed a FIR against her. Cheating, forgery, impersonation, etc. She also changed. She also mentioned her name as different name. She is actually Jaya Ratnakar, project officer in Mahila Bal Vikas, but she informed herself to me as Anisha Sharma. Then I lodged FIR against her. Later on, next day, she lodged an FIR of rape against me. I have got question filed with that. I have got stay from this honorable court. On this matter, lordship, इस मैटर में जब मैंने फैमिली कोर्ट में नल एंड वाइड की पिटीशन लगाई, तो नल एंड वाइड की पिटीशन में ये अपीयर हुई, उनके 4 लॉयर्स आए अलग अलग टाइम पे, फिर इन्होंने और फिर ये अल्टीमेटली एप्लीकेशन लगाते गए कि मुझे टाइम दे दिया जाए ये करने के लिए, वो करने के लिए। अल्टीमेटली शी वाज गिवन सफिशिएंट अपॉर्चुनिटीज. She did not appear in the court later on, so the ex parte judgment and decree was granted in my favor, declaring the marriage as null and void. There are 2 important aspects. उसके बाद इन्होंने, मैंने एग्जीक्यूशन पिटीशन लगाई लॉर्डशिप, जो मेरी पिछले 4 साल से पेंडिंग है एग्जीक्यूशन पिटीशन 2019 से. ना नल एंड वाइड में क्या हुआ, मेरी मैरिज नल एंड वाइड डिक्लेयर की है, एक पार्ट है. मुझे जो मैंने इन पर खर्चा किया है 7.5-8 लाख रुपया, वो ज्वेलरी दिलानी है, वो 5 लाख का कंपनसेशन, ये पार्ट है. 2 पार्ट्स. मेरी एग्जीक्यूशन 2019 से पेंडिंग है. सुप्रीम कोर्ट से रिपोर्टेड जजमेंट ऑल एग्जीक्यूशन पिटीशंस अक्रॉस इंडिया हैव टू बी डिस्पोज्ड ऑफ फाइनली विद इन 6 months. 4 साल से पेंडिंग होगी इनके कुछ ना कुछ एप्लीकेशन की वजह से. नेवरदलेस लॉर्डशिप, इनकी नॉट मेरिट्स पे रिजेक्ट हुई है, और नॉट के पेंडेंसी में इन्होंने अपनी एक्स पार्टी डिग्री थी. ये ऐसे नहीं था कि इनको पता ही नहीं पड़ा है. हर 5 लॉयर्स अपीयर्ड, फाइल वकालत एप्लीकेशन, स्टे एप्लीकेशन, टाइम दे दो, ये कर दो. Now let's see, kindly see, in North when she filed an affidavit in North declaring her father's name, not as husband's name. So the family court in North proceedings, जो proceeding है challenge में, family court director है, you declare your husband's name on affidavit. family court में husband wife का झगड़ा होता है. अब husband का नाम बताइए, क्योंकि essentially इसमें husband का झगड़ा आपका मुझे रत्नाकर husband है या अंकुर से मेजर अंकुर से husband है. So she did not declare that name, then she filed a petition here. And in that case, this honorable court director has to declare on affidavit her husband's name. Then only she declared her husband's name as she is married since 1999 with Manoj Ratnakar and her marriage is still subsisting. All right, she
dismissed.
जब इन्होंने अपने हस्बैंड का नाम बता दिया है कि she is already married since 1990 and that marriage is still valid. Now the difficulty in staying these proceedings would be on two part lordship. One is कि मेरी इनसे मैरिज जो नलन और डिक्लेयर हुई है वो पार्ट स्टे हो गया तो मेरी मैरिज इनसे रिवाइव हो जाएगी. Now she is already married till today and now I am married to ISS officer. So मेरी मैरिज जो ऑलरेडी चालू है अभी नल एंड वोइड की बात है, इनकी मैरिज जो सन 99 से चालू है, तीसरी मैरिज हम दोनों के बीच में अगर वो रिवाइव हो गई दैट विल बी अगेंस्ट द स्टैट्यूटरी प्रोविजन ऑफ सेक्शन 5 ऑफ द हिंदू मैरिज एक्ट. हिंदू मैरिज एक्ट सेक्शन 5 सेज कोई भी मैरिज इलीगल होगी, इनवैलिड होगी अगर किसी भी पार्टी का स्पाउस जिंदा है तो. सो माय सबमिशन लॉर्डशिप दैट नो स्टे कैन बी ग्रांटेड अगेंस्ट द स्टैट्यूटरी प्रोविजन ऑफ लॉ. और एक प्रैक्टिकल बहुत बड़ी डिफिकल्टी इसमें डेंजरस कॉन्सिक्वेंसेस वाली उत्पन्न हो जाएगी. अगर मेरी शादी जो इनसे हुई है जो नल एंड वोइड कोर्ट ने डिक्लेयर की है 2013 में भी इनकी खारिज हुई है तो अगर उसको स्टे कर दिया तो दैट इज वन पार्ट. सो दैट शुड नॉट बी डिस्टर्ब लॉर्डशिप. That will be harmful for them also and for me also. Now regarding the second part, money part, मेरी एग्जीक्यूशन 4 साल से पेंडिंग है, 19 से 23 चल रहा है. उसमें कोर्ट ने इनको सफिशिएंट टाइम दिया, इन्होंने कहा मुझे स्टे दे दो मेरी एग्जीक्यूशन में. सब साथ चल रही थी नॉट मेरा एग्जीक्यूशन. इन्होंने कोर्ट ने इनको कंडीशनल स्टे दे दिया कि आप 2 लाख रुपए का सिक्योरिटी और 1 लाख रुपए जमा कर दीजिए. 13 लाख का ऑर्डर है, डिक्री है मेरे फेवर. तो ये 2 लाख का सिक्योरिटी दे दें, 1 लाख जमा कर दें. इस कंडीशन पर 1 साल के लिए एग्जीक्यूशन रोक दी गई. वो इन्होंने उसका कंप्लाइज नहीं किया 1 साल तक. उसके बाद इन्होंने एक 151 और लगाई कि मेरे को थोड़ी फाइनेंशियल कंडीशन ठीक नहीं है क्लास 1 ऑफिसर और मेरे को आप समय और दे दें. कोर्ट ने कुछ समय और दिया इनको कंप्लाइज करने के लिए 2-3 महीने, वो भी कंप्लाइज नहीं किया. अब उस इंटरम ऑर्डर कि 2 लाख और 1 लाख वाला उसको इन्होंने एमपी में चैलेंज किया तो जो ऑर्डर है लॉर्डशिप और इसमें वो इंटरम ऑर्डर को रजिस्टर किया था ना कि एग्जीक्यूशन प्रोसीडिंग को. सो दिस ऑर्डर इज नाउ ऑफ नो यूज लॉर्डशिप.
दिस पिटीशन विड्रॉ
हो गई. और ये जो इसमें स्टे भी हुआ था ये 9/13 एग्जीक्यूशन में जो कंडीशन था उसको स्टे हुआ था एग्जीक्यूशन प्रोसीडिंग्स की फर्दर प्रोसीडिंग हो. अब वो ऑलरेडी 2 साल पहले खत्म हो चुका है, उसको हाई कोर्ट ने अगर स्टे कर भी दिया ऑनरेबल कोर्ट ने अब कोई उसकी कोई इफेक्ट नहीं है. नाउ व्हाट आई एम सबमिटिंग लॉर्डशिप, ये स्टे का केस नहीं. आई हैव बीन चीटेड, आई हैव बीन हनी ट्रैप्ड एंड आई एम फेसिंग अ फॉल्स क्रिमिनल ट्रायल वेयरइन दिस ऑनरेबल हैज गॉट बीन रेस्क्यू. अब मेरी पोस्टिंग जब लद्दाख के भी आगे फील्ड पे मुझे 2 दिन के जम्मू तक आने लग जाते हैं. व्हाट आई एम सबमिटिंग इज लॉर्डशिप देयर आर 2 पार्ट्स इन फॉर स्टे. 2 पार्ट है जो इनकी प्रेयर है. एक शादी, अगर डिग्री स्टे होती है तो मेरी शादी से जो नल एंड वोइड डिक्लेयर्ड है वो रिवाइव हो जाएगी. अब 3 शादी हो जाएंगी.
ये डिग्री कब की है? 19 की है, 2019 की.
19 की है मेरी, 19 से एग्जीक्यूशन चल रही है.
हाँ, अभी 2023 आ गया.
यस,
हाउ टू स्टे दैट? हम तो नहीं कर सकते.
अब इस पीरियड में ये तो ऑलरेडी हमारी
एप्लीकेशन कब आया? 9/13 की एप्लीकेशन कब फाइल की आपने?
सर ये विद इन टाइम फाइल कर दी थी.
ना पता, ये अभी
19 की है
सर 2019
19 से 4 साल चलाई इन्होंने.
तो कोरोना का पीरियड 3 साल तक तो कोरोना में काम नहीं चला.
नहीं सर,
अब मेरा निवेदन ये है कि इसमें जो आप बता रहे हैं, जो फैक्ट्स बताए आपने, वो हमने कहीं एडमिट नहीं किया. WSC फाइल हुआ उस केस में और उसमें जो है आप जो बता रहे हैं उसके बारे में हम अपना डिफेंस क्लियर करेंगे जब WS फाइल होगा. तो इसमें जो है पेज नंबर सर पेज नंबर 19 पर देखें. इसमें जो
ये है जो प्रेस्क्राइब पीरियड है मैरिज का देख लिए.
मैंने शादी की क्लियर नल एंड वोइड क्लियर होने के और वैसे भी वो मेरे पे अप्लाई नहीं होगा क्योंकि वो आई एम नॉट, मेरा डाइवोर्स का केस नहीं है, नल एंड वॉइड है।
नहीं, इस पार्टी है
एक्स पार्टी, वो एक्स पार्टी के रीजन कोर्ट में बहुत डिटेल में कंसीडर किया है इनका, इनको बताया कि अगर
तब तक इनका फाइल नहीं हुआ था, 30
नहीं वहाँ उसके बाद ही किए मैंने बहुत बात।
आपको नोटिस हो चुका था उस केस में?
यस शिव, बट 9/13 में कोई स्टे नहीं मिला ना इनको।
निश्चित नहीं मिलना है, अलग बात है। आपको जब नॉलेज है
पर even-
रद्द करने के लिए एप्लीकेशन लग गया है।
लॉर्डशिप इवन अदरवाइज, चलिए आप मेरी शादी 2 मिनट के लिए लॉर्डशिप हटा दें, इग्नोर करो, इनकी शादी का क्या हुआ? ये तो 99 से मैरिड है, अभी शी इज मैरिड टू अ सीएसपी सिंस 1990।
इनका एडमिशन है क्या?
एडमिशन है, इन्होंने एफिडेविट दिया कोर्ट में फॉर रेजिडेंस।
जो पैरा नंबर 13 है जो ऑर्डर का,
वो डीएन का एफिडेविट है रेफरेंस की लॉर्डशिप पर है।
क्या डिसाइड करना था इस 913 में, वो देखा सर आप, इसमें तो वही देख
इसका
सकते
पैरा 5 चल रहा लॉर्डशिप,
स्टे ऑफ पॉइंट की बात।
इसका पैरा 5 देख ले, इन्हीं का एफिडेविट है, हाई कोर्ट में ऑर्डर किया कि आप पति का नाम बताइए, पैरा 5 बहुत रिलक्टेंटली इन्होंने फाइल किया। यह है कि जहां तक शपथ पत्र पर पति के नाम के बारे में जानकारी स्पष्ट किए जाने का प्रश्न है, तो मैं माननीय न्यायालय द्वारा अपने आदेश में उल्लेखित अनुसार मैं विवादित रूप से स्वीकार करती हुई स्पष्ट करती हूँ कि मेरा विवाह श्री मनोज रत्नाकर से दिनांक 17/1/99 संपादित हुआ था, जो वर्तमान में भी अस्तित्व में होकर श्री मनोज रत्नाकर मेरे पति है। या
आपकी शादी तो हो
मेरी 2018 में की इन्होंने मेरे से, 17 में 2017 में।
ये डाइवोर्स के बारे में नहीं बोल रही है, फर्स्ट मैरिज के बारे में।
नहीं खुद बोला ना, मेरा अस्तित्व में है।
डाइवोर्स तो नहीं,
नहीं वो थोड़े नहीं, वो तो गजब
स्टिल इन एग्जिस्टेंस।
स्टिल इन एग्जिस्टेंस। इन्होंने सप्रेस कर के मेरे से शादी की।
मनी पार्ट तो किया जा सकता है इस टाइम।
जी।
मनी पार्ट मैं 4 साल से अभी
अरे एक मिनट, हम लोग
मैं ओनली सैलरी डेकोरेटेड पोस्ट पर मैं अपनी हार्ड एंड मनी को पाने के लिए 4 साल से एग्जीक्यूशन में घूम रहा हूँ। लॉर्डशिप मेरा सबमिशन है, इफ आई लूज इन दिस अपील, आप उसको स्टे नहीं करें लॉर्डशिप, आई विल डिपॉजिट मेरी अंडरटेकिंग अपील, आई विल डिपॉजिट द अमाउंट इन कोर्ट इफ आई लूज। इस अंडरटेकिंग पे एग्जीक्यूशन चलने दो लॉर्डशिप, मनी पार्ट। ये रूटीन मनी रिकवरी शुरू होती है लॉर्डशिप बी पार्ट, तो फिर एक रूटीन ऑर्डर होता है इसके में 50% जमा कर स्टे। ये रूटीन केस नहीं है मेरा सबमिशन।
पार्टी आधा बहुत नहीं लगता।
पार्टी के लिए इनका रीजन क्या है? मेरे पाँव में चोट लग गई। ट्रायल कोर्ट ने इन्होंने एविडेंस दिया है कि मैंने छुट्टी के लिए आवेदन दिए, तो इन्होंने कोर्ट में एग्जिबिट करा दिए, जबकि छुट्टी के आवेदन इनको अपने वरिष्ठ रिकॉर्ड से सब मेडिकल से आर्ग्यू करने के आवेदन नहीं, रिकॉर्ड पे ही एग्जिबिट कराया उन्होंने इसी केस में। 9/13 में जो इन्होंने ग्राउंड दिया, पाँव में चोट लग गई, मैं इसलिए नहीं आ पाई। उसके जो छुट्टी के आवेदन थे इनके सीनियर ऑफिसर के अंदर डिपार्टमेंट में दिए, वो आवेदन उन्होंने
जो ट्रायल को
छुट्टी की आवेदन देगा तो ऑफिसर पे, सुपीरियर ऑफिसर पे
दिवाली।
फाइनल सुन लेना।
हाँ फाइनल।
तो 4 साल में नहीं हुई तो 4 दिन में तो होनी चाहिए वैसे भी एग्जीक्यूट।
सर मेरे सारे मेडिकल डॉक्यूमेंट जो एग्जिबिट कराए पेश
अभी सुन लेंगे, आपको आफ्टर दिवाली इसको सुनना पड़ेगा।
बहुत डिटेल नहीं है।
रिकॉर्ड फैमिली कोर्ट का ही नहीं आया सर, बस डेट लगी।
अच्छा, इसमें लिखिए आपने कैविएट लगाया ना? कैविएट फॉर द रिकॉर्ड्स ऑफ द कोर्ट बिलो दिस केस इन सेकंड वीक ऑफ दिसंबर फॉर हियरिंग।
वो एग्जीक्यूशन प्रोसीडिंग आपने लगा रखी है ना, कल डेट लगी, आप उसमें प्रेस कर रहे हैं और ऑलरेडी स्टे था मेरा।
ये आपको
वो एमपी में क्या चैलेंज किया था आपने? इंट्रीम ऑर्डर। तो दैट इज नॉट नहीं,
जो एग्जीक्यूशन है
एग्जीक्यूशन थोड़ी स्टे हुआ है एमपी में, आप गलत स्टेटमेंट कर रहे हैं।
एग्जीक्यूशन नहीं हमने लगाया था ना,
that is against him only an interim order of maintenance, that's all.
अरे मेंटेनेंस थोड़ी जो हमारे पास मिली डिग्री थी।
चलिए अभी नो स्टे विल हियर इट फाइनली इन
के टाइम कोड में आप कहेंगे कि सर इनकी सैलरी में से अटैच करो, कल बताया मैटर
करना सर इसको करिए।
सर आप देखेंगे उसमें कि डे टू डे प्रोसीडिंग फैमिली बोर्ड में क्या एक ही केस है क्या प्रोसीडिंग देख लें आप उसमें तो proceeding तो था should go tomorrow, let it be heard finally thereafter. And I'll go down to Lordship later. It will have counsel for respondent undertakes not to place the execution proceedings tomorrow, only tomorrow for the trial court. And take a date after the second week of December. And then, if I'm seeking an adjournment, that should be order of the petition was of 27/7. But we have received, we have sent the copy which was received on 10/11. And from that date, 10/11, 3 months are completed. Last week लगा था ना केस ये कितनी लगा था? Three petition है, 3 contempt we have filed. इसको लिखा the request. उसमें क्या ऑर्डर हुआ था? Adjourn कर दिया था लॉर्डशिप, just after दिवाली कर दिया था. List this case after as per list this case after Diwali vacation. 25 also. Same order. 3 महीने में कंप्लाई करना है, वो 10 तारीख को 3 महीने कंप्लीट होगा. पहले पेश कर दिए. चलिए नेक्स्ट 23. आप पीछे बैठिए, आप कौन है भाई? यार भी पिटिशनर पीछे जाके बैठिए और फिर आप आर्ग्यू करिए खुद. यस
Present petition filed for the action of this honorable court.
क्या है ये? व्हाट इज ही? व्हाट इज द प्रोफेशन?
मुझे पत्रकार एंड सामाजिक कार्यकर्ता है. पत्रकार एंड सामाजिक कार्यकर्ता. रतलाम राजवंश की इतिहास देखने ऐसे खंगाल रखे, तब उनको जानकारी प्राप्त हुई कि जो ऐतिहासिक धरोहर का जो भवन है, लोकेंद्र भवन, जो कि रतलाम के महाराजा लोकेंद्र थे, उनके कोई वारिस नहीं था. क्योंकि वारिस नहीं होने के कारण ये प्रॉपर्टी शासकीय होना थी, वो न होते हुए 2006 में एक रजिस्टर सेल एग्रीमेंट होता है. जो लोकेंद्र भवन का गैरेज है उसको सेल करने के लिए, तो सब रजिस्ट्रार रतलाम को ये कहते हैं क्योंकि कलेक्टर ने इस पर रोक लगा रखी है, इसलिए रजिस्ट्री नहीं हो सकती. उसको चैलेंज करते हुए पिटीशन 2006 में फाइल हुई.
समझ में नहीं आ रहा क्या पब्लिक क्या है? व्हाट इज दिस प्रॉपर्टी? प्रॉपर्टी है ये
लोकेंद्र भवन जो है, रतलाम राजवंश के राजा लोकेंद्र सिंह है, उनकी प्रॉपर्टी थी. उनके कोई वेद संतान नहीं थी और नावारिक कोई वारिस नहीं था. जो प्रॉपर्टी
ऐतिहासिक धरोहर उसको डिक्लेयर किया है क्या?
किया नहीं है, बट होना है.
होना है बात है, ऐतिहासिक धरोहर है आप बोल रहे हैं इसको? ऐसा है, डिक्लेरेशन है क्या कोई?
डिक्लेरेशन तो नहीं.
कैसे बोलोगे?
आप ये देखेंगे जो
उत्तराधिकार नहीं होने से लोकेंद्र भवन जो कि ऐतिहासिक धरोहर है, ये कहाँ से बोल रहे हैं आप? कैसे धरोहर है ये?
क्योंकि राजवंश की प्रॉपर्टी है लॉर्डशिप.
नहीं तो क्या वो आर्कियोलॉजिकल सर्वे ऑफ इंडिया ने इसको डिक्लेयर किया है?
डिक्लेयर नहीं किया, पर
नहीं किया तो वो ऐतिहासिक धरोहर हो ही नहीं सकता. वो
डिक्लेयर नहीं किया, बट ये अनडिस्प्यूटेड ये प्रॉपर्टी राजवंश की रही है. इसमें जो आप नेक्स्ट जो मैंने फाइल किया है, उसकी पिटिशन जो फाइल करती है अर्लियर लिटिगेशन में, पेज नंबर 56 लो. में जो पेज नंबर 56 पे है लोग,
ये ऐतिहासिक धरोहर है ही नहीं तो उसको कैसे डिक्लेयर करेंगे? You have to get it declared by the Archaeological Survey of India.
डिक्लेयर होना है, नोटिफिकेशन
होना है, अभी हुआ थोड़ी है. कुछ ना ऐतिहासिक धरोहर.
ये जो नेक्स्ट P1 जो अर्लियर लिटिगेशन में पिटीशन फाइल किया लॉर्डशिप पेज नंबर 56 पे जो रजिस्ट्री के लिए पंजाब ने डिक्लाइन किया था लॉर्डशिप, उसमें सिर्फ उस भवन में स्थित खंडहर गैरेज का विक्रय पत्र के लिए यहाँ पे पेश किया था। और आफ्टर द डिसाइडेड द पिटिशन, उसका भूमि की जो देखेंगे
ये तो ऑलरेडी देयर इज अ डायरेक्शन इन द रिट पिटिशन टू रजिस्टर द प्रॉपर्टी, है ना? डायरेक्शन है।
डायरेक्शन क्या होता
तो फिर इसका क्या हुआ फिर इस ऑर्डर का?
है? इसकी रीट अपील फाइल की थी स्टेट लॉर्डशिप, उसके भी मैंने कॉपी फाइल कर रखी है। एनेक्स P5 उसमें भी मुझे डीपी ने डायरेक्शन दिया था कि अगर कोई डिस्प्यूट अगर होता है, कोई राइट क्लेम होता है, ऑर्डर और पेज नंबर 7 एनेक्स P5 page number 75 of all lordship. In view of the aforesaid reason and the finding of the learned single judge, we are of the view the judgment of the learned single judge directing the appellant to register the said deed reviewed by the respondent number 1 does not suffer from any infirmity. According this appeal is summarily dismissed without prejudice the right of any the state government to claim property before the proper forum.
हाँ, स्टेट गवर्नमेंट का लिखा हुआ वो देखेगी प्रॉपर्टी लेना कि नहीं लेना।
बट स्टेट गवर्नमेंट को लॉर्डशिप एनेक्स P3 का लेटर भी दिया था पिटिशनर ने लॉर्डशिप टुडे एनेक्स P3
वी आर अपीलिंग फॉर द स्टेट। क्या कहना है आपका?
So we'll seek the instruction in this regard.
अभी PIL कैसे है ये?
My lord, if my lord may kindly see the relief clause, my lord. The first thing they want them to be registry should be declared as null and void. So this court cannot be has the jurisdiction to decide that. Second thing, my lord, to register a criminal case. Forum is also available to for entertaining that. Because if they want to register any criminal case to any person, they can move an appropriate application before the Superintendent of Police or concerned police station. Both the prayers number 7.1
रजिस्ट्री को शून्य घोषित किया जाए, यहाँ नहीं हो सकता, वो सिविल सूट में होगा।
बट लॉर्डशिप आपको नेक्स्ट P4 देखेंगे, इसमें जो
ये क्या रिलीफ दी जा सकती है PIL में, मुझे पहले इसका आंसर दीजिए। यस और नो में, और if yes, how it can be granted.
रिलीफ नंबर 3 आप देखेंगे लॉर्डशिप, देखिए रतलाम
रिलीफ नंबर 1 का क्या करेंगे? मेन रिलीफ तो वही है आपकी।
लॉर्डशिप जो नेक्स्ट आपको बताना है,
कोर्ट ने पहले लिबर्टी दी थी, डायरेक्शन दिया था कि रजिस्टर करें आप।
तो जिस प्रॉपर्टी को लेके आए थे उसको रजिस्टर न करते हुए पूरे लोकेंद्र भवन को लॉर्डशिप आप देखेंगे तो रजिस्ट्री मैंने पेश की है इसके साथ सलेक्शन
ये तो पब्लिक इंटरेस्ट तो दिखता नहीं, इसमें कुछ पर्सनल इंटरेस्ट दिखता।
राजवंश की प्रॉपर्टी
देखिए, रजिस्ट्री को शून्य घोषित यहाँ रिट पिटीशन में नहीं किया जा सकता। दैट इज द एंड ऑफ द मैटर, दैट्स ऑल। ठीक है, और विल पास जाएगा।
आप एक बार देख ले डॉक्यूमेंट,
जो नहीं देख लिया, ये रिलीफ नहीं दे सकते इसमें, इसलिए डॉक्यूमेंट नहीं देखेंगे। जो रिलीफ दे सकते हैं तो फिर डॉक्यूमेंट देखेंगे अपन। सिर्फ प्रेयर ही आपकी ऐसी शून्य घोषित कर दिया जाए।
624 स्क्वायर फीट का रजिस्ट्री का ऑर्डर लॉर्डशिप ने किया था और आप रजिस्ट्री देखेंगे
शून्य घोषित कराने के लिए सिविल सूट फाइल करें आप, यहाँ से थोड़ी शून्य घोषित।
स्टेट प्रॉपर फॉरम स्टेट को ही करना था, बट स्टेट ने कोई आज तक कोई कार्रवाई नहीं।
लिबर्टी कोई जरूरी थोड़ी है, स्टेट को नहीं चाहिए वो प्रॉपर्टी। और ही कंसर्न
राजवंश की थी, राजवंश प्रॉपर्टी शासी घोषित हो गई और उसको
तो सेल डीड हो गई ना, उसकी सेल डीड हो गई ऑलरेडी। देयर इज अ सेल डीड ऑफ दैट प्रॉपर्टी।
सेल डीड हुई वो लॉर्डशिप, कोई मैं बताना चाह रहा हूँ कि जो यहाँ पे जो डायरेक्शन था सिर्फ 623 स्क्वायर फीट बट पूरी प्रॉपर्टी
सीएलडी को वो रिट पिटीशन में शून्य घोषित नहीं कर सकते. दैट लीव कैन नॉट बी ग्रांटेड. एविडेंस आपको रिकॉर्ड कराना पड़ेगा. यहाँ एविडेंस रिकॉर्ड होगा नहीं.
इसमें दिक्कत ये आएगी, जो प्रॉपर्टी बेचने वाला था अपना को
आप बता दीजिए, लॉ बता दीजिए, तो हम इसको एडमिट कर लेते हैं अभी कि हियर हाई कोर्ट कैन satisfy that order and declare that sale deed is null and void.
इसको नेक्स्ट वीक रख लेंगे.
नहीं, नेक्स्ट वीक नहीं, अभी बताइए तुरंत. I will pass the order. Yes. Result.
It's like petition against the order of already rejection and denial of the scholarship under Mukhyamantri Meghalaya Vidyarthi. I am the petitioner has passed the petitioner is belong to the EWS category and passed the NEET examination of
Which category?
EWE economically weaker section.
Economically weaker section.
He given the NEET
Rejection order.
रिजेक्शन ऑफ ऑर्डर नहीं है, ओरल रिजेक्शन ऑर्डर नहीं है, क्योंकि वो जो ऑनलाइन जब काउंसलिंग के लिए बुलाते हैं तो उसी समय का बोलता है, एडमिशन उसी के अकॉर्डिंग होता है. और आई हैव पार्टिसिपेटेड इन फर्स्ट टाइम काउंसलिंग held on 10 of August 2013.
Any certificate that you belong to economically weaker section?
Yes, let's say I have filed the connection P1, let's say P16. And let's say I have passed the youth examination. So वो EWS का certificate that is not the disputed. This is the admitted position. I have possessed the EWS certificate. ये NSA P1. It is the certificate. Later, and what I am challenging, Lord sir, I am challenging the denial of the scholarship. So EWS certificate is already verified at the time of counseling, Lord sir.
Firstly, you have been denied the scholarship.
Firstly, I have admitted, I given the examination in the respondent number 4 college with the scholarship of scholarship. Finally, see the scholarship. Annexure P5.
What is the criteria for grant of scholarship?
There are two criteria. I found the policy, which is annexure P12, P11, and amendment part of the
क्या शर्तें हैं इसकी?
ये है लोग P11 में कंप्यूटर नंबर 2 में पात्रता की शर्तें हैं. तो इसका निवासी हो, विद्यार्थी के पिता पालक की आय 6 लाख रुपए से कम हो, और 2.3 भी है कि उसने सीबीएसई की अगर शैक्षणिक 12वीं की शैक्षणिक योग्यता 70% अंक प्राप्त करने वाले छात्रों एवं सीबीएसई द्वारा आयोजित 12वीं की परीक्षा में 85% से उससे अधिक अंक प्राप्त करने वाले छात्रों. और दिस हैज बीन अमेंडेड बाय एनेक्सर P12 which are filed annexure page number 35 also.
8 लाख हो गए.
8 लाख रुपए हो गए. पार्टिसिपेटिंग
सर्टिफिकेट का है आपके फादर का?
सर वो मैंने जो इनकम टैक्स सर्टिफिकेट, इनकम टैक्स जो मैंने वो है इनकम टैक्स रिटर्न दिए हैं वो फाइल किए हैं लक्ष्य मैंने इलेक्शन P13 से.
ये तो आपका तो अमेंडमेंट के पहले का क्लेम है ना?
नहीं नहीं सर, हाँ सर, ये अमेंडमेंट 18 को और सेकंड टाइम काउंसलिंग जो हुई है तो ये लोग से 30/8/2023. और ये जो इलेक्शन टोटल देखें वो ये अमेंडमेंट हुआ वो डेट से नहीं हुआ. देखें इलेक्शन P12 1335
ये हम समझ होना चाहिए.
तो संशोधन शैक्षणिक सत्र 2023-24 से लागू हुआ. तो 23-24 के लिए वो पूरा एप्लीकेबल 12 जो अमेंडमेंट हुआ इसमें लिखा है कि तक के लिए
संशोधन शैक्षणिक सत्र 23-24 से लागू होगा. और आपका पास हुए 12th का पास हुए?
सर ये 12 पास हुआ मैं 2023 में. 12th मैंने मेरा 12th एग्जामिनेशन पास किया मैंने 22/7/2022 को पास किया. और मैंने नीट एग्जाम पास की 13/6/23 को. तो मैंने तो ऑनलाइन काउंसलिंग में किया 24-24 सेपरेटली है.
सर्कुलर क्या बोलता है? 12वीं पास होना चाहिए.
12वीं पास पर्टिकुलर परसेंटेज से होना चाहिए.
हाँ,
कब पास होना चाहिए ये नहीं है.
जो एग्जाम जो
कहाँ है सर्टिफिकेट 12वीं वाला आपका?
सर मैंने लेक्चर P2 फाइल किया।
P2 ये 21-22 की एग्जाम है नहीं तो?
जी सर। नीट मैंने, क्योंकि इसके बाद मैं एलिजिबल हुआ, मैंने नीट एग्जाम दिया, नेक्स्ट P3 मेरा ये वो है एडमिशन
एग्जाम है। दिस इज फॉर द एग्जाम 21-22।
ये तो मतलब 12th पास करने के लिए जो मैंने एडमिशन ले रहा हूँ MBBS में, वो 23rd सेशन 23rd to 24 में, क्योंकि इसके बाद भी मैं नीट दिए मैंने, और नीट जो मैंने दिया नेक्स्ट P3 पे लेट्स मेरा जो एडमिशन कार्ड है पेज नंबर 18, P4 पे मेरा रिजल्ट है। अब नाउ क्या हुआ लेट्स कि फर्स्ट नाइट में तो मेरे को स्कॉलरशिप दे दी, कॉलेज में अलॉट कर दिया। Kindly see annexure P5 notes. When I participated in the first time counseling,
नहीं वो बात नहीं है। जो अनेक्षर P11 है ना, इसमें जो पार्ट होगा की शर्तें हैं 2.3 को करी है।
तो सर 18-19 की शर्तें उस पर्टिकुलर के लिए थी।
हाँ तो अभी आपके सेशन 21-22 के लिए कौन सी शर्त है?
ये वाली कि मेरे को 23-24 में
वेर इज दैट? आपने जो लगाया वो 18-19 की शर्तें लगा दी।
नहीं, 18-19 में केवल उतना अमेंडमेंट हुआ है जो जो आपकी सर्किल
आपके जब जिस साल आप पास हुए उस समय कौन सी स्कीम थी लागू? सर
तो आज मेरे जो नीट एग्जाम में जो एडमिशन लेना, आप
नीट से थोड़ी
P11 फिर से देख रहा हूँ, वो जो एग्जाम पास करने के लिए नहीं है। ये देखिए, ये तो पात्रता की शर्तें हैं, उसमें देखिए 3.2
ऐसा है। अपन आर्ग्यू करते रहेंगे तो नहीं होगा, पर पात्रता बताइए आपकी कहाँ से आ रही है?
सर ये जो
हाउ आर यू एलिजिबल फॉर ग्रांट ऑफ स्कॉलरशिप, ये बताइए। यू आर पास इन द ईयर 21-22। अब बताइए इसमें से देख के कि कैसे आप पात्र हो रहे हैं, करके बताइए एक एक क्लॉज। देखिए 2.1 सेटिस्फाई करते हैं, विद्यार्थी मध्य प्रदेश का निवासी हो, ये ठीक है। नंबर 2,
सर नंबर 2 वाली तो मैंने P12 में मैंने दिया, उससे मैं इस क्राइटेरिया में आ गया।
नहीं वो 23-24 से लागू हो रहा है, वो इसके पहले से लागू हो ही नहीं रहा। 21-22 में पास हुए। सही आप ही तो पढ़ के बताया ना P12 लास्ट लाइन, उप संशोधन शैक्षणिक सत्र 23-24 से लागू होगा।
तो MBBS का जो सेशन है,
इसलिए 2.2 एक बार पढ़िए।
सर विद्यार्थी के पिता पालक की आय 6 लाख रुपए से कम है, परंतु ऐसे विद्यार्थी जिनके पिता पालक की वार्षिक आय 6 लाख रुपए तक तथा BPL कार्ड अनुसूचित जाति अनुसूचित वर्ग के हैं तथा जो कंट्री 3 3 2 3 3 3 4 3 5 के लोग सत्यापन योजना में सम्मिलित नहीं पड़ रहे, तो विशेष पत्र मात्र संबंधित विभाग समन्वय में सक्षम अधिकारी का अनुमान प्राप्त करें। योजना में सम्मिलित माध्यमिक शिक्षा मंडल की 12वीं की परीक्षा में सचिव 18-19
माध्यमिक शिक्षा मंडल की 12वीं 12th क्लास 18-19 70%
वाले छात्रों एवं CBSE द्वारा
CBSE वाले हैं।
हाँ CBSE
इसमें 85% होना चाहिए।
86.4% मेरे। उससे अधिक प्राप्त करने वाले लोगों का छात्र मिलेगा। ऐसे विद्यार्थी घंटा 3 से घंटा 3-5 में उल्लेखित पाठ्यक्रमों में प्रवेश लेते हैं, जिन्होंने वर्ष 2016 के पूर्व से ही इस घंटा में उल्लेखित परीक्षा में विधातन पास हुए भी योजना के पात्र होंगे।
ठीक है, तो अभी आपकी इनकम पहले 6 लाख
6 लाख मैं तो प्रदेश ही अब ले रहा हूँ ना। अब जो अब इसके बाद लगेगा सर, ये जो योजना मुझे मिलेगी 3.2 के भी लगेगी मेडिकल। दिस इज नॉट फॉर दी, मुझे स्कॉलरशिप केवल 12वीं की परीक्षा प्राप्त करने से नहीं मिलना है, लेकिन मैं मेडिकल में प्रवेश लूंगा के आधार पर। जिन विद्यार्थियों ने राष्ट्रीय पात्रता एवं प्रवेश के आधार पर केंद्र राज्य शासन के मेडिकल कॉलेज के MBBS पाठ्यक्रम मध्य प्रदेश के प्राइवेट कॉलेज के MBBS पाठ्यक्रम प्रवेश लेना किया, उन विद्यार्थियों को देश शुल्क शासन राज्य शासन द्वारा वहन किया जाएगा। भारत शासन के ऐसे संस्थान जो स्वयं की आयोजित परीक्षा के आधार पर कोई भी योजना में अनुदान किया जाएगा, शासकीय मेडिकल कॉलेज में शिक्षित स्वयं से ये तो 3.2 के लिए मेरे को एलिजिबिलिटी के लिए 2 चीजें चाहिए थी। मैंने उसके लिए फर्स्ट टाइम काउंसलिंग पे नीट में दी, नीट में पास हुआ। नीट मैंने पास की 2023 में। तो उसके बाद फर्स्ट टाइम काउंसलिंग में गया, तो फर्स्ट टाइम काउंसलिंग में एडमिशन मिल गया विद स्कॉलरशिप। आप देखेंगे P5 से ये तो सेकंड काउंसलिंग जो है, सेकंड काउंसलिंग में आपने एक ऑब्जेक्शन उठाया कि आपकी जो एज है, वो आपकी जो इनकम है आपके फादर की, 6 लाख से ऊपर इसलिए नहीं थे, तो वो पुरानी पॉलिसी को ला कर रहे थे, जबकि 18 साल में अमेंड हो गई और वो सेशन 2023-24 के लिए आपको डिनाई कहाँ किया है? सर डिनाई किया ना, तो मैं एनेक्सर कर सकता हूँ कहाँ सर, एनेक्सर P फैरत देते हैं, आपका क्लेम रिजेक्ट कर दिया, वो कौन सा ऑर्डर सर, ओरली बोल दिया आपने, मैं बताता सर बिल्कुल, क्योंकि जो प्रोसीजर क्या है, हम ऑनलाइन काउंसलिंग में लाए कुछ पर्टिकुलर कॉलेज में जाते हैं जो हमको अलाउड होता है, तो वहाँ पे वेरिफिकेशन कहा तो 1000 रुपये फीस भरने का बोलते हैं उसके साथ में, देखेंगे एनेक्सर P फाइल देते हैं, दिमाग साहब मैं तो एनेक्सर P6 देते हैं, जो फर्स्ट राउंड काउंसलिंग में मेरे को जो एडमिशन मिला, इनको डायरेक्शन दे देते हैं, डिसाइड डिसाइड करें उनकी पात्रता है या नहीं है, ठीक है, डिसाइड विद इन वीक्स। They will file a representation for this. Fresh representation file mentioning along with the certified copy of the order. क्योंकि अभी तो रिजेक्ट किया ही नहीं है ना, तो how can we direct them? अपने right to admission तो आपने एडमिशन दे दिया, जब हम सेकंड राउंड काउंसलिंग में बेटर कॉलेज के लिए है, वहां पे आपने मना दिया, ठीक चलते रहिए।
26 के लिए पेड का विड्रॉ विड्रॉल पिटिशन
26 क्या है? ये देखिए इसमें आफ्टर आर्ग्यूइंग फॉर सम टाइम लर्नर काउंसिल फॉर द पिटिशनर सीक्स लो ऑफ दिस विड्रॉ द पिटिशन, विड्रॉ। चलिए नेक्स्ट। यस
present petition draft to petitioner is challenging the amendment introduced in the Nagapata Gram Nivek Schedule Law for formation of the scheme for the development of the scheme. That is contra right petition.
already admitted.
Number of cases में notice issue की.
इसमें इश्यू नोटिस पीओ 4 weeks लिस्ट अलॉन्ग विद कर देना लो,
स्टेटस को आगे सबमिट किया।
सेम ऑर्डर पास करना स्टेटस को लिस्ट अलॉन्ग विद यस नेक्स्ट।
सर 29 30 आ गई
सेम है, ठीक है चलो नेक्स्ट।
31
My lord, I am waiting for listing of 22nd November. Where council from Bombay will have it. GST का नहीं, challenging showcase notices. Mr. State आपकी बात जरूरी अभी जल्दी माइक। स्टेट ऑफ एमपी को तो पार्टी नहीं बनाया आपने, पार्टी किसको बना दिया आपने? ज्वाइंट कमिश्नर, डिप्टी कमिश्नर, असिस्टेंट कमिश्नर। गुड्स एंड सर्विस टैक्स नेटवर्क, ये क्या है? This is investigation being of this GST. ये डिस्क्रिप्शन गलत नहीं है सब लोग?
Yes, one.
I will correct also. This private council prays for weeks time to amend the description of the respondents. My lord. By filing appropriate application list. Week commencing 20 November. Lordship पहले अमेंड करना पड़ेगा, उसके बाद फिर एडमिशन पे सुनेंगे आप। अभी पार्टी है ही नहीं, वो उसी ग्राउंड पे डिसमिस हो जाएगा। यस
Number 32.
इसमें 30/10/23 को जो है ऑनरेबल कोर्ट ने जो पिटिशनर को टाइम दिया था फाइल करने के लिए,
रीजनल एप्लीकेशन amendment order other documents to show that the appellant has opted for school education department.
मैंने 3/11/23 को जो कुछ डॉक्यूमेंट्स फाइल किए हैं, एक सिंगल डॉक्यूमेंट
कुछ डॉक्यूमेंट्स कंटेन करते हैं कि ये डॉक्यूमेंट जो आपको डायरेक्शन दिया था
उसी में कंक्लूड है। एक सिंगल डॉक्यूमेंट और छूट गया है, जिसके लिए मैंने एक आरटीआई एप्लीकेशन मूव किया हुआ है डिपार्टमेंट को, वो डॉक्यूमेंट माने मुझे मिलना बाकी है, काइंडली ग्रांट 2 weeks टाइम टू
So लिखिए Leonard Council submit that one of the documents is not yet received and he has applied to RTI. Therefore 2 weeks time may be granted list after 2 weeks as paid.
Item 33 and 34 lordship. The last official in the lordship directed us to file an IF for amendment in the prayer clause. I've already got an application.
What amendment?
Amendment in the prayer clause because lordship, this is the prayer was for the direction to the concerned officer for handing over the vacant physical possession of the property. The order has already been filed under section 14. So since SDM was not a party, so lordship, we had filed an application for
SDO engine. Respond number 6.
respondent 6 lordship.
SDM.
SDM.
ठीक है इसको अलाउ कर देते हैं.
Grateful.
लिखिए और क्या इसमें लिखिए hold on IO number 539023 application for implementing to SDM as respond number 6.
Yes, lordship.
For the reasons stated, application allowed necessary amendment with incorporated
Lordship.
petition.
Lordship, there actually this IF for implement of SDM has already been allowed, lordship.
Then
It was an amendment in the prayer clause, which is filed on 14th of September. This is IA number 6828 and 6829.
so he already allowed it.
Yes, lordship.
Prayer clause. Hold on IA number 6828. 23 application for amendment in the prayer clause. For the reasons stated, application allowed necessary amendment be incorporated within 3 working days.
Yes, lordship.
List after the amendment is incorporated.
Lordship, can it be on 5th request because I'm outstation council, lordship. Can it be on either within this week itself or on 5th of December, lordship?
You can use this case on 5th December as well.
No problem.
20 cases.
Yes, lordship. Much great.
Yes.
Well, last time Rakshit has given direction to file the copy of NSCP. The NSCP, I have already plans order.
What is the matter?
Matter is my lord that the applicant is claiming the third MSCP, my lord, and for that she filed an OA, which has been dismissed on the ground of limitation, my
Ground of limitation.
lord. In fact, my lord, she was appointed as a staff nurse on 30th 977, my lord, and then she was promoted to the post of nursing sister on 11090, my lord. Then promoted to the post of matron on 16/6/1995, my lord.
There is a huge delay in filing the original application.
In fact,
In fact, you are right. I was approved in the year 2004.
no, my lord. Kindly see, my lord, page 48 of the compilation, my lord.
When was
And
the
the
first?
strength of that
When was the first MSCP granted to you?
promotion was given on 11090, my lord.
110,
90.
90. Promoted. Then second,
Then second, 16/6/1995, my lord.
16, 6, 1995 ये promotion है
List of metron, my lord. This is
this is also a promotion.
promotion. And this is a Group C post, my lord, metron. When she was there, and she completed, my lord, 30 years of his qualifying service on 30th 9 2007, my lord.
30 years. Is now 2007.
2007. She also completed 3 years of her service as metron, my lord.
अगर if you are claiming the third MSCP under the scheme then 10 years 3 साल में होता है. हाँ 12 years से 12-24 वाली applicable नहीं होगा.
मैं ये बता रहा हूँ कि 95 के बाद भी उसने 12 साल पूरे कर लिए थे. 2000 जब 30 साल उनके पूरे हुए तो 12 साल ऐसे मेट्रोन रह चुकी थी.
And then you superannuated in the year 2009. And then you file away after lapse of almost 10 years after retirement.
Page 48
क्या recurring cause of action है क्या?
पेज 48 देखिए सर. ये रेलवे बोर्ड का एक
लिमिटेशन ऐसा है, लिमिटेशन के पॉइंट डिसमिस हुआ है तो why should we go enter into the merits of the case? If we find that period is controllable, then we'll remit it back to the tribunal for re-hearing on merits. 48 we have to satisfy how this delay you meet out.
Page 48 now.
क्योंकि section 21 of the Central Administrative Tribunal Acts provide for a 1 year limitation.
1 year.
What is your explanation to that?
And can this
This is a writ appeal arising out of the OA. What explanation you have submitted in the OA? We have to see that. बताइए ना कहाँ है? Where is the copy of the OA?
OA की कॉपी जो है सर वो
Order copy of OA page 22.
और इसमें
अब आप यहाँ नया ग्राउंड थोड़ी ले सकते, जो ग्राउंड वहां लिया उसी पे देखना पड़ेगा कि वो ऑर्डर सही है या गलत है.
जी एप्लीकेशन है एनेक्सर P3 में at page 60. Application under subsection 2 of section 31 of CAT Act 1985 for condonation of delay.
इसमें क्लॉज 3 है लिमिटेशन. पेज नंबर 26 में ओए के अंदर में क्लॉज लिमिटेशन का दिया हुआ है ऑलरेडी. जी उसमें एक्सप्लेनेशन होना चाहिए.
ये इन्होंने 31 of CAT Act 1985 पे फाइल किया है सर.
Since the pension is a recurring cause of action every month, you are not claiming pension, you are asking for third upgradation. तो ये recurring कैसे हो गया?
Because pension is not proper, so cause of action is recurring, my lord. My submission is, my lord, kindly see next page 48, my lord, from where she gets the cause of action, my lord. Kindly see, my lord, 48, my lord.
There is no explanation. There is no explanation.
Kindly see, because here railway board says that if they are promoted
फर्स्ट एंड सेकेंड में फिर आप मेरिट पे आ गए. मैं आपसे ये निवेदन कर रहा हूँ कि आप डिले एमएससीपी क्लेम कर रहे हैं ओए में. यू आर नॉट क्लेमिंग पेंशन. पेंशन डेफिनेटली इज अ रिकरिंग कॉज ऑफ एक्शन. जी एवरी डे एवरी मंथ यू गेट अ लेसर पेंशन, यू हैव अ कॉज ऑफ एक्शन. एमएससीपी में आप 2004 में एंटाइटल्ड हुए, 2009 में आप रिटायर हो गए, 2000 उसके बाद भी 10 साल बाद ओए में आ रहे हैं आप. 10 साल के बाद
2004 में 95 में हुए सर. उसके बाद जो है चूंकि एमएससीपी थर्ड एमएससीपी जो है वो 30 साल होने को हो गया. 2007 में मिला.
एक्सप्लेन अपन लीव इट असाइड. 2010 साल के बाद आप वही में आए, 10 साल का एक्सप्लेनेशन भी नहीं है. नो एक्सप्लेनेशन इन धारा 3 पेज नंबर 26.
2018 में एक सर्कुलर निकला सर रेलवे बोर्ड का, जिसमें ये कहा गया कि अगर 21/2008 तक अगर 2 प्रमोशंस मिल गए या 2 अपग्रेडेशंस मिल चुके हैं तो थर्ड अपग्रेडेशन में 5500 का जो ग्रेड पे है उसकी जगह 6600 दिया जाए सर. तो ये
उनको 2018 मिला, इसके बाद उन्होंने का केस ट्राइब्यूनल ने मेरिट पे डिसाइड ही नहीं किया। नहीं किया सर, आप मेरिट पे क्यों आ रहे हैं हम नहीं देख सकते यहाँ पे, हम तो लिमिटेशन ठीक डिसाइड किया कि नहीं वो देखना है अपने को। लिमिटेशन छोड़ के सब आर्गुमेंट्स कर रहे हैं। लिमिटेशन में बताइए ना, हाउ दिस केस इज विद इन लिमिटेशन एंड व्हाट रॉन्ग हैज बीन कमिटेड बाय द ट्राइब्यूनल। दिस इज द इशू। ये है कि सर जो क्लेम कर रहे हैं जीपी 6600 का, वो 2018 में प्रोवाइड किया गया है आपका एक्सप्लेनेशन बिफोर द ट्राइब्यूनल। टू दी पॉइंट आर्गुमेंट करना चाहिए, इधर उधर जाने से कोई ऑर्डर थोड़ी बदल जाएगा, ऑर्डर तो वही होगा।
इसमें पेज 61 देखें।
नहीं वे में बताइए, वेयर इज द एक्सप्लेनेशन इन वे रिगार्डिंग
एप्लीकेशन ऑफ डिले में है सर इसके एप्लीकेशन।
नहीं, वहाँ अलग से एप्लीकेशन लगाने की आवश्यकता नहीं है, फ्लैट है। पैराग्राफ 3 देखिए पेज नंबर 26 पे, उसमें आपको देना पड़ेगा एक्सप्लेनेशन, बाकी अलग से। अगर ट्राइब्यूनल ने बोला होगा कि फाइल ए सेपरेट एप्लीकेशन देन इट इज अ सेपरेट इशू। रिकॉर्ड नहीं है ना इसमें, रिकॉर्ड है क्या ट्राइब्यूनल का? ठीक है, दूसरी फाइल
इसमें तो उन्होंने कुछ नहीं कहा है, लिमिटेशन नहीं कहा है, लेकिन कंडेंसेशन ऑफ डिले की अलग सेपरेट एप्लीकेशन दिया है, उसमें लिखा है सर।
उसको थोड़ी कंसीडर किया ट्राइब्यूनल ने, कंसीडर क्यों करेंगे, उसमें कोई प्रोविजन थोड़ी है। Unless directed by the tribunal to file a detailed application separately, ऐसा कुछ है क्या?
नहीं ऐसा कुछ, ये ऐसा कुछ। कंफर्मेशन डिले की एप्लीकेशन को पार्ट 5 में लिखा है सर, पेज 61।
ठीक है, रिजर्व
Manoj, I'm praying for a Passover in this. Mr. Nima has to argue this, Manoj. He is on his way.
The contract matter, same as Mondays. I'm not supposed to it for final year disposal today.
today.
Yes, my lord. My lord, if I can draw my lord's attention to the last order, my lord, dated 26/10, my lord.
Can we not hear it after?
This is a serious problem, my lord. It's a stay. Now, the contract had already come into force. As many as 200 agreements have been executed, and 3,000 employees have been supplied.
That you mentioned that.
Yes, no, but I'll just.
But as per the provisions, the existing contractor will continue till the new one takes over.
No, the earlier contractor has already been terminated, and why he has been terminated? They were paying him, my lord, as much as 10% of the service charge. Whatever the billing was, he was getting 10%. I'm doing it at 2%. So
Who is appealing for the state?
all the stay Monday is there. my lord.
Think board, my lord. My lord, we have also filed an application for vacating the interview. Because what the learned senior counsel has submitted, my lord, that amounts to about 10 to 11 crores, my lord. And there, my lord, now they are taking advantage of the.
Even if we hear it, we don't have time, 3-4 days are left.
I'll just repeat my request, my lord, to modify that interview. What I'm saying, requesting is, my lord, is only a equitable, this thing that the day my lord stayed in, my lord may restore that position, because the 3,000 more employees that I've provided, let them, because the Mondays are getting affected. It's not only me. I'm just getting.
How Mondays are going?
My lord, we see the nature of work employees, watchmen, computer operators, security guards, everybody.
But the problem is that, my lord,
ठीक है, last में देखते हैं इसको after
the list is completed. And then you would be required to produce the original record also in the meanwhile. Because we have to see, everything from that.
But I don't think the record will be required. It's all the terms of that. What is challenged is the terms of the tender. The terms of the tender, the NIT has to be sealed. His challenge is, he cannot challenge the working of the mandi. It's a purely an option.
He says that some certain conditions have been
Tailor-made. Let us see, my lord, let us see. If my lord will just bear with me only for 5 minutes, I won't exceed 5 minutes.
We'll see in the next round because he is not there.
Even if it is tailor-made, my lord, you
He is full here he says that don't expect the order अभी 1-2 दिन में possible नहीं है.
my lord, this festive season is around the corner, we've got to pay the employees.
The situation would be same even if we hear after Diwali immediately.
That's why I'm today.
And there's some difficulty. I'm not making any submissions on merits. The difficulty is that now what is happening? Certain
That's vacating stay is over now. We have decided to hear it early. This time only.
yes.
That is why we have fixed it today.
So
We can hear, but I am afraid we can deliver the judgment today, tomorrow itself. It's not possible. So it will go after Diwali only. Then we'll get time to.
My lord, if I could request my lord could find some wire media at least to cover this period. My lord, in this festive season, my lord, some payments have to be made. And I am not in a position to, my lord, dish out 11 crores.
Okay, we'll hear it.
The hearing also, my lord, is it was a modification of the internal relief so that I get my payments and I can pay the workers.
देखता भी.
Yes.
Yes.
Yeah.
ठीक है.
The request for 230, my lord.
कितनी लंबी लिस्ट है. ठीक है.
Yes, 235.
Yes. Yes.
I have put counsel on behalf of Mukesh B and matter number 27.1.
Same judgment is pending before. कौन आ गया? Connected में इसको लिखिए that he is admitted for hearing. Part तो है already और इसमें suspension of sentence है क्या?
Yes, my lord.
2 weeks time to file reply.
Suspension की application
Suspension है.
but there is a reflecting application for ignoring the defects. Suspension की जो application देखनी है DSP पे attention application is my lord page number 15759
Page number 105.
106.
One 106 में क्या है? Not available. Application for
Application for ignoring the defects. Defects eligible copies, type copies.
page number 105 not filed.
जी.
105 को दिख रहा है यहाँ पे. ये है ना?
The legal copy was not filed above the defect.
क्या एलिजिबल तो है? अच्छा इधर का ये. ये. So इधर का इग्नोर कर देते हैं. इसमें लिखिए that he is admitted for hearing IA number 1576023 application for ignoring defects allowed. Just after 2 weeks.
138.
Admission. Conviction. Admit call for the records. Chalo next.
39.
Admission limitation.
Confirmation of due privilege.
दो दिन delay. Delay. ये allow कर दीजिए. Admit call for the records.
7 record card and victim office and GA card plan. Suspension का reply.
Suspension लगा क्या आपने?
Yes, sir.
So 2 weeks time to file reply and notice to the victim.
Yes, sir.
लास्ट डेट को स्पेसिफाइड कॉपी पेस्ट करने का बोला था वो कर दी
तब फाइल कर दिया आपने.
सर मैं बीच
आइए कितना डीलर है इसको लिखिए द सर्टिफाइड कॉपी हैज बीन फाइल्ड बाय द लर्नेड काउंसिल फॉर अपीलेंट ऑफिस इज टू कैलकुलेट द डीलर 85 पे वैसे कैलकुलेशन के साथ नहीं ऑफिस करेगा ना कैलकुलेट अपन नहीं कर सकते ऑफिस का काम है कैलकुलेट करके लगाना के बाद फिर कंडोनेशन ऑफ डीलर आपने ऑलरेडी लगा दी पहली हाँ वो कितनी डीलर था ही ना नेक्स्ट वीक लिस्ट इन द वीक कमेंसिंग 20 नवंबर एक्चुअली 41 में सब लास्ट डेट पर हमने कहा था कि वो ऑफिस को कैलकुलेट करने के लिए कहा था कैलकुलेट कर लिया है ठीक है Petition is time bound by 2 to 7 days. 2 to 7. आइए लगी है क्या? लगी आइए सर. लगी. लिखिए अभी ऑर्डर आइए 1287523 application for condonation of delay. Office has calculated the delay of 2 to 7 days for the reason stated delay condoned IE allowed. Appeal is admitted for hearing all for the records. Suspension of sentence भी है. Suspension नहीं लगा है. Each time to file reply to IE for suspension. Application seeking amendment in cash control. IE number 17067. 2023, referred by the petitioner for completing the complaint to party bana. IE number 1706723, application seeking amendment in the cost total by including the complainant as party respondent for the reason stated application allowed. Necessary amendment be incorporated within 3 days with this case in the week commencing these. November. Notice. नोटिस भी कर दो उसमें है ना इशू नोटिस टू द न्यूली एडेड रेस्पोंडेंट पीएफ 7 days रिटर्नेबल 4 weeks छुट्टी है ना आप डेट ऑफ हियरिंग की सर पहले पीएफ तो दे दीजिए तो 3 days तक दीजिए पीएफ रिटर्नेबल 3 weeks चलिए नेक्स्ट
अलर्ट इन दिस मैटर
इसमें मेरी आई है अमेंडमेंट भी प्रेयर में मैंने रेस्पोंडेंट नंबर 6 के अगेंस्ट कोई रेमेडी नहीं चाहिए थी तो इसलिए वो रिकॉर्ड पे लाना जरूरी है
अमेंडमेंट इन रिकॉर्ड
आइए नंबर
7276 उसके बाद भी और आईएएस पेश किया आपने
ये तो वो डॉक्यूमेंट रिकॉर्ड पे लेने की है जो बाद में मुझे आरटीआई में मिले हैं तो वो भी रिकॉर्ड पे आना आवश्यक है फाइनल डिस्पोजल के लिए
नहीं 7276
My lords, one is IA number 7326 of 23, my lords, filed by the state government for recalling of order dated 10/11/22 and 18/1/23, my lords. By virtue of these orders, my lords, right to file return of the state government has been closed in previous one, and second one was subject to the cost of rupees 10,000. So, my lord, since we have already filed the reply, but it cannot be read till the time those orders are recalled. So, therefore, my lords, we have filed.
Have you deposited the cost?
My lords, we are paying for recalling of records.
तो जमा करो तो रिकॉर्ड पे लेंगे उसको दो बार ऑर्डर हो गया ना
No, we have explained our bona fides, my lords. My lords, can kindly see that interim application. This is idea number 7326 of 23.
7
Paragraph 2, my lords, that this honorable court by order dated 10/11/22 has directed that if the reply is not filed within 4 weeks from today, then the same shall be filed on the cost of rupees 10,000. Now, my lords, we have explained this because of delay in paragraph 3, my lords, since the officer in charge
10-11. फोन लगा दिया. सब टाइम में कॉस्ट लगा. कंडीशनल ऑर्डर था वो, तो रिप्लाई टाइम दिया था आपको, फिर आपने जमा नहीं किया.
Reply was not filed in this 4 weeks, my lords. And we have explained it in paragraph 3. Then we go down to my lord's directions for them. My lord, it happened so the officer in charge is the assistant for the present case is assistant director backward minority department. However, my lord, since that post was lying vacant, so additional charge was given to district pension officer DHARMADHIKARI. And on account of this additional charge, that reply could not be filed within the stipulated period, my lords. And we have further tendered our unconditional apology for the delay occurred, my lords. That is our submission on this.
Then which is another order?
That is just subsequent to that, my lords.
18-1-23.
18-1-23, because wherein my lords have observed that since the right is already closed, my lords. So therefore, until and unless we file this application for recalling of that order.
अच्छा ऐसा है क्या?
Though my lords, we have filed reply, but that cannot be taken on recall unconditionally since my lords have already passed this order dated 10-11-22.
ये 18-1-23 में कुछ नहीं बोला है. इतना बोला कि राइट्स to file reply by the state stands forfeited in view of the order.
For the purpose of this observation, my lords, even if that order goes, then there is an observation that it is already forfeited.
रिकॉर्डिंग
फिर मुझे कोई आपत्ति नहीं.
आपत्ति नहीं है ना, रिप्लाई तो पेश कर ही दिया है. ऐसा नहीं है कि बहुत इनको 10-20 बार टाइम दिया और फिर रिप्लाई नहीं दिया. ऐसा नहीं, बहुत जल्दी कॉस्ट लगा दी गई थी इनके ऊपर. ये केस है, डिजर्व करता ही है.
एक्चुअली सर वो रेस्पोंडेंट नंबर 5-6 की था, पर अनफॉर्चुनेटली वो ऑर्डर में कुछ इस तरह से आया कि वो स्टेट के ऊपर चला गया, तो इसलिए
5 and 6
स्टेट का जो डॉक्यूमेंट
ultimately the purpose of filing this petition has been achieved. My college has been closed now. मेरा कॉलेज इनको बंद करवाना था, वो बंद हो गया, करवा दिया. हाँ, वो करवा दिया. अब आप देखना से इनके क्या इंटरसेडेंट, हाउ दिस पिटीशन इज मेंटेनेबल बनो. पहले तो इनको ये ऑर्डर रिकॉल कर लेता है जी, उसके बाद देखते हैं जी.
फिर हमारी अमेंडमेंट की आई है,
ये अब ये देखना पड़ेगा. अमेंडमेंट
रेस्पोंडेंट नंबर
सर्वाइव करेगा तो अमेंडमेंट, नहीं करेगा तो फिर खत्म. कॉस्ट सर्वाइव करना चाहिए तभी अमेंडमेंट.
मेरिट पे अगर केस सुना जाएगा और अगर हुआ तो फिर अगर एडिट नहीं होगी तो वो कैसे मिलेगी?
नहीं, आपकी raised an preliminary objection to the maintainability of the petition and IE number 732623 application for recalling of the orders dated 10-11-22 and 18-1-23. The council for the state submit that right order dated 10-11-22, 4 weeks time was granted to file the reply, failing which the ₹10,000 shall be paid. Learned counsel has pointed out that the OIC of the case was holding a dual charge, and on account of this additional charge, the reply could not be filed within the stipulated time. He has also tendered unconditional apology for the lapse on their part. Is taking into consideration the facts of the case. This is the order dated 10/11/22 is hereby recalled. As a consequence, the order dated 18/1/23 is also recalled. The cost imposed is waived. Reply is taken on record. अब दूसरा आयु क्या है?
7276।
इसमें क्या प्रेयर है आपकी?
सर मेरी प्रेयर है कि मेरे जो प्रेयर क्लॉज है उसमें रेस्पोंडेंट नंबर 6 के डिलीट नहीं चाहिए थी, तो केवल रेस्पोंडेंट नंबर 5 का ही लिखा था उसमें, जबकि रेस्पोंडेंट नंबर 6 मेन कॉलेज उसमें
Yes.
यस सर। जो 3 प्रेयर है उसमें रेस्पोंडेंट नंबर 6 ऐड करना है, और 3 एडिशनल प्रेयर है मेरी रिलीट करना।
But I will request if your lordship is kind enough to hear this petition, the question of maintainability itself first.
I am trying to find out the petition. Where is the petition? It's order sheet showing.
जी पेज नंबर प्रेयर
भी फाइल वाइल अरेंज करते सामने वकालतनामा लगा हुआ है। रिप्लाई लगा, पिटीशन अभी मिल नहीं रही है।
The petitioner has no social antecedent, though having a criminal antecedent.
निरस्त करें। अब यू आर फॉर रेस्पॉन्ड नंबर 5
5 and 6 months.
5 and 6। ये तो मान्यता प्राप्त, मान्यता निरस्त हो गई आपकी।
मान्यता निरस्त हो गई, कॉलेज बंद हो गया, इसका पर्पस सर्व हो गया।
वैसे जिस समय था उस समय का एलिगेशन है ये, और रिकॉर्ड इसमें सब मैंने फाइल किया हुआ है, और जिसका ये बोल रहे हैं
जो आपको प्रेयर क्लास नंबर 1 हो गया ना, मान्यता निरस्त हो गई, कॉलेज बंद हो गया।
हाँ लॉर्डशिप 2020
रेस्पॉन्डेंट क्रमांक 2 को निर्देशित किया जाए कि वह रेस्पॉन्डेंट नंबर 5 को पीजीडीएम कोर्स हेतु प्रदत्त मान्यता निरस्त करे।
केवल पीजीडीएम का निरस्त किया है, कॉलेज चालू है, लेकिन मैंने जो एलिगेशन लगाया है वो 17, 18, 18, 19 का लगाया है, जिस समय में
आपका जो सारा ग्रीवियंस है वो पीजीडीएम का ही है। पीजीडीएम का कॉलेज बंद हो गया, उसकी मान्यता खत्म हो गई।
ऑलरेडी उन्होंने अवैध तरीके से स्कॉलरशिप का और फर्जी डॉक्यूमेंट का होना चाहिए। जब मैंने कंप्लेंट करना शुरू किया तो उन्होंने पीजीडीएम के लिए मान्यता लेने से इनकार कर दिया, मतलब तो इन्होंने कुछ दिया नहीं, तो ऑलरेडी नो एडमिशन घोषित कर दिया इनको। बार बार इनको कहा गया कि आईआईसीटी द्वारा कि आप जो है अगर कंटिन्यू करना चाहते हैं तो सबमिशन दीजिए, ये उपस्थिति नहीं हुए क्योंकि इनको एडमिशन कंटिन्यू करना ही नहीं था,
हमको चलाना ही नहीं था कॉलेज। अभी हमारे
अमेंडमेंट का चार
अमेंडमेंट मेरा ये है कि मैंने रेस्पोंडेंट नंबर 6 के अगेंस्ट रेमेडी नहीं मांगी थी। आप देखिए पेज नंबर 24 पिटिशन का, जिसमें मैंने 4 प्रेयर करी थी, उसमें रेस्पोंडेंट नंबर 5 का ही हवाला आया, 6 का नहीं आया, जबकि मेन जो है वो 6 है। 5 तो जो इसकी सोसाइटी है जो रन कर रही 6 को।
रेस्पॉन्ड नंबर 6 जोड़ा जाना है। ये सब पीआईएल में कैसे मेंटेनेबल होगा? ये इनके खिलाफ रजिस्टर किया जाए, फलाना किया जाए।
इंक्वायरी कैसे होगी?
विदाउट इंक्वायरी प्रॉपर अथॉरिटी के सामने जाइए आप, तो वहाँ वो इंक्वायरी
मैंने सबके समझ कंप्लेंट करी, मैंने आप देखेंगे मैंने 10 कंप्लेंट फाइल करी है। 10 कंप्लेंट फाइल करने के बाद भी कोई जांच नहीं हुई। जब मैंने पिटिशन फाइल करी तो रेस्पोंडेंट नंबर 1, 3 और इनकी ओर से एक जवाब फाइल किया गया है, उसमें ये पाया गया है कि इस तरह का काम हुआ है, इसलिए मैंने इनके जवाब पे कोई आपत्ति नहीं करी है, क्योंकि वो रिपोर्ट मुझे कभी दी नहीं गई थी। तो मेरी कंप्लेंट कर दी जांच।
also held an IU number 727623 application for amendment for the reason stated application allowed necessary amendment interpreted within 7 working days list for hearing in the month of January 24.
On the last date of hearing, last opportunity was granted to the respondents to file reply. No reply has been filed. My lord, this is a petition where I'm seeking payment of the undisputed amount as per the works that was already completed by me in the year 2014-15. And there is an acknowledgement of the liability, and the reason is that
किसी को बुलाइए, क्यों नहीं फाइल कर रहे?
My lord, in this, the contesting party is, my lord, the respondent number 3, my lord.
my lord, both are
Notice we have already issued ना? 2022 में notice हो गया है. Then
the payment has to be made.
already appearing for
My lord, some power is there, my lord, but for the past 3 hearings, nobody is appearing.
Ranjit Sen and Ranjit Sen.
इसमें लिखिए notice was issued. In this case, the notice was issued on 20/12/2022. Thereafter, on 7/8/23, time was granted to the respondents to file the reply. However, reply has not been filed. Though from the record it is seen that there is a wakalatnama filed on behalf of respondent number 3, but no one appears for the respondent number 3. In these circumstances, the respondent number 3, Chief Municipal Officer, Municipal Council Rajgarh, is directed to remain personally present before this court on 22nd of November. The registry of this court is directed to inform the respondent number 3.
Be granted to them, and if they fail to reply, then
यहाँ वकील साहब ने वकालतनामा पेश कर दिया, आते नहीं है, तो इन्हीं को बुलाना पड़ेगा, जो क्लाइंट है उसी को बुलाना पड़ेगा ना. ये आते तो मत आइए.
will inform the advocate, my lord.
नहीं, आप इन्फॉर्म कर दीजिए, ऑर्डर हो गया हमारा. Used on 22nd of November. In the meanwhile, state will also file reply.
My lord, last indulgence was already granted.
Last date of the ऐसी रिपेलिंग की एप्लीकेशन आती है. Yes. Cases are allotted to the government advocate, and it is their responsibility. Then only they will draft the reply. Otherwise, they are not going to draft. कितने लोग ड्राफ्ट करते हैं आपका रिप्लाई?
Lord, we read the letter.
40-50 लोग हैं ना? कितने लोग ड्राफ्ट कर लेते हैं?
Everybody, my lord, is
करते हैं. अगर ऐसा है तो फिर यहाँ एक भी केस में रिप्लाई नहीं है, सब हर केस में रिप्लाई मिलेगा फिर. You accept the responsibility. This case is allotted to you, for example. Then it is your responsibility.
my lord, that is
जब तक ऐसा करेंगे नहीं, तब तक ये टाइम वाला काम चलते ही रहेगा.
the only thing is
अपना हाईकोर्ट में जीए को अलर्ट हो जाती फाइल हो. It is his duty then.
Lord, it is allotted.
He is responsible then. पूरा साल भर का परफॉर्मेंस देखा जाता है, तब रिन्यूअल होता है. ऐसा नहीं होता रिन्यूअल. अपने यहाँ ऐसा नहीं है, अपने यहाँ सब पॉलिटिकल है सब ये. Yes. Next.
On 18/23 notices were issued and it was directed to be listed after 4 weeks. So it may be kept after Diwali.
It was directed to listed in the week commencing 6th of November.
हाँ, तो अभी पॉसिबल नहीं है, सब केसेस कहाँ से सुन लेंगे फाइनली. नॉट पॉसिबल.
After PhD, any be given, my lord, because construction work has been stayed, because building permission has been cancelled without opportunity.
Today the matter came out, we are finally listing the week commencing 28th of November, 27th of November.
Okay.
चलिए next.
Sir, this is the tender matter. टेंडर कैंसिल किया तो ब्लैक लिस्ट किया था सर बाय वर्च्यू ऑफ ऑर्डर डेटेड 23/8/2023 मानो I have deposited the guarantee amount and they have allotted me work amount. Grievance has been redressed, please.
हो गया ब्लैक लिस्टिंग का बचा, ब्लैक लिस्टिंग में बचा
अलाउट कर ही दिया तो अपने आप ऑटोमेटिकली स्पोर्ट्स आप स्टेटमेंट से जिस ऑर्डर से
अलर्ट किया हुआ पता है
वो तो हो गया इसमें कोई डिस्प्यूट नहीं है उन्होंने ऑर्डर दे दी डिस्पोजल की एप्लीकेशन आपने लगाम के चालू
ब्लैक लिस्टिंग हटा दी तभी तो वर्क दिया आपको, नहीं तो कैसे वर्क देंगे
सर वो ऑनलाइन अभी भी देखिए हटाई
उसको बाद में देखेंगे, अभी तो आप काम करो उसके बाद देखते हैं. So here, Budget Council for the petitioner submit that the work has already been allotted to the petitioner. However, the order of blacklisting has not been withdrawn. Therefore, the matter is to be heard. Take a list in the month of January 24. Yes, next.
And this notice were issued to the respondent and they have marked their appearance, my lord. And as per instructions, some talks for settlement is going on between the parties, my lord. So it would be that within 70 days, my lord, it would be settled, my lord.
So they have filed some I was decided on last date of hearing 7610. They have made some amendments in the application, which they have not supplied the copies to us. And another amendment has been, another I has been filed, wherein they have not supplied the copies. They have not filed the copies of audited 36/2023, certified copy of DRT. So that was in defect also. So my submission is like, only provide us the copy of all IAs and amendment applications.
थोड़ा नहीं, that is under challenge. क्या challenge किया आपने?
But then my application number 17 has been dismissed by the DRT, my lord, on the ground that it is barred by limitation, my lord, and limitation cannot be condoned, my lord. Similar issue has been pending consideration before your lordship, my lord, and for that and the honorable court as in other petitions, my lord, has issued notice and interim is also granted.
Delay cannot be condoned.
Yes, lordship.
Provision नहीं है वहाँ पे.
So in this, my lord, the section 17.
Is mentioned in section 17(1) of SUSHRUT. If the borrower is aggravated by any action taken under section 13(4), he can file an appeal under section 17(1) before honorable DRT. If he is aggravated with any order passed by the honorable DRT, he can file an appeal under section 18(1) under SUSHRUT. Within 30 days from that such order. But those days have already been passed, despite that they have not approached the appropriate authorities. Even this case also, they have an alternate remedy to approach honorable DRT for filing an appeal instead of approaching this very honorable court.
P9 is the order passed in identical petition, my lord, and in that case, my lord, that issue is under consideration, same issue, my lord, regarding the limitation, my lord, whether limitation can be condoned or whether there is limitation, my lord.
P9.
There was a detailed order passed by the honorable DRT in this regard. Technically mentioned that the delay cannot be condoned or the due indices of the delay is
one by one. दोनों एक साथ बोलोगे तो आप पहले आप डिसाइड करो कौन बोलेगा.
He is requesting.
थोड़ा P9 देखने जा रहा है, वो बिना देखे आप चालू आगे नहीं करते जा रहे. You should wait for a minute at least. We should go through that order.
Yes, sir.
एक्सप्रेस एकदम क्या बुलेट ट्रेन थोड़ी है, धीरे धीरे चलिए, तो जल्दी नहीं. Issue is pending.
Yes, sir.
And
another matter is also pending before the division bench at principalship, my lord, which is also P10.
What do you want? Reply दे दिया आपने?
नहीं sir, I have to file a reply unless they not supply me the copies of the IA amendment copies. You cannot file reply.
What IA?
amendment was on 120, there was a IA filed by them for an amendment application, which was duly allowed by this honorable court.
Incorporating challenge of the order passed under section 15. इनको दो ना amendment की copy दो.
I will supply the copy.
Let a copy of the amended application for amendment. We supply to learned council.
Also, to make some amendment in the application, what amendments have made, we would be requiring the
amended copy of the petition दे दीजिए. क्योंकि आपकी application बहुत clear नहीं है, आप क्या amend करने वाले हो.
I will supply the
जनरल एप्लीकेशन बनाते हैं यहाँ पे, इंसर्ट करना है किस पैराग्राफ में करना है वो कुछ लिखते नहीं आप लोग. तो नेक्स्ट टाइम से विल डिसमिस योर एप्लीकेशन फॉर अमेंडमेंट इफ इट इज नॉट प्रॉपर्ली कॉन्स्टिट्यूटेड. वी मस्ट आल्सो अंडरस्टैंड आप कहाँ पे अमेंड करना चाह रहे हो उसको. क्या होता है कि आप करते कुछ हो फिर उधर अमेंडमेंट दूसरे टाइप का हो जाता है. यू शुड मेंशन इन द एप्लीकेशन कि हम फलाने पैराग्राफ में अमेंडमेंट करना चाहते हैं. कुछ नहीं लिखा रहता है, वेरी वेग एप्लीकेशन एकदम.
in this case.
amended copy सप्लाई करिए इनको within 3 days. Reply be filed within 2 weeks.
Right. Next week, it would be just on submission after the probably it can be up to
After 2 weeks.
Case number 48, next matter, Your Honor. I'm playing for a judgment in this case, Your Honor. So Sethi, in this case, Your Honor. And I'm only saying that this may be taken in first week.
I should be wait now.
Section heard finally, with what they were in finally, Your Honor. As we have last supported, I'm sorry.
Yes.
Well, on 25/4/23, that stay order was passed by this honorable court, ex parte stay order, well, hearing the petitioner. And it was suppressed in the petition that an appeal has been filed before the commissioner and the stay application has been rejected by the commissioner. This was on 25/4. Then my lord, we filed.
We'll come after lunch.
Yes.
In this case, I'm playing a role. Mr. Sethi was leading me in this case, Your Lordship. On the last pretext, Your Lordships have granted us time because he was not keeping well, Your Lordship. By way of last opportunity, I'm playing for 2 weeks' time, Your Lordship. Because this has to be argued finally. Because alternate arrangements are also made, Your Lordship. Those arrangements also could not be carried out, Your Lordship. Therefore, by way of last opportunity, only speaking that.
Yes. But 25-4 as I submitted, Manoj, an order came to be passed suppressing the fact that the appeal was pending before the commissioner and the stay application had been adjudicated. Number one. Number two, thereafter,
सोटी साहब आपने 17 को टाइम दिया था 4
हम 4 हफ्ते लेते हैं आपको उसके बाद सर ये 2 महीने बाद लग रहा है ये मैटर
I bow down to that, Your Lordship.
One of the matter has been stayed and it is the public exchequer, my lord. The lease deed has been cancelled, that is not. It's just a case, my lord, where
immediately दिवाली के बाद डेट दे देते हैं you don't argue will decide
जो भी बना के रखा हुआ है सर इसमें आपने पेश करा हुआ है मैंने
इसमें लिखिए the 11th council for petitioner again praised for time on the ground that Shri A.K. City senior counsel is not well. As of last indulgence, time is granted to argue the matter in this case in the week commencing 20 November.
Can I pray for just in the week, in the first week of December?
That will be too late, but 17-8 को आपने 6 हफ्ते का समय दिया yes 10 हफ्ते हो गए सर
And make arrangements in the week commencing these.
Yes, I have to continue.
Obliged. Yes.
Lordship, the arguing counsel is not available for today, and the adjustment is already filed. Can you give us the short date? Your Lordship, my name is Shruti Mittal.
When is he available? Arguing counsel का available है?
Next week.
Yeah, we adjusted for today only. Only today he is adjusted.
Yes, sir. As you did.
No urgency. इसमें लिखिए मैं counsel for the arguing counsel is adjusted just after Diwali vacation.
Application is suspension of jail sentence. Offenses for 376 for poxo act में conviction में 20 years. और during trial, present applicant is on bail. और directly come to the point that case is of consent. और age उसकी at the time of incident
कोई एक इनका भी है, इनका भी दो। कितना टाइम लगेगा आपको? 10-15 पासवर्ड है, पासवर्ड। इनका कौन सा नंबर है? पासवर्ड 9, आइटम नंबर 9। तो लो ना, इसको पहले ले, पहले लो नंबर 9। अच्छा, rather undisputed, if your lordships are pleased to turn to annexure 3-5 at page 35. कौन सी petition लिया? This is 1413 this petition. 19 number. ठीक है। 3 है इसमें total. It will take time. Won't take more than 10 minutes. The only issue is ideal floated a tender. We submitted our tender. That tender was sent for approval under Rule 19 of the Variant Name 1975, which was then in force. It was the duty of the state government to have decided it one way or the other. State never decided. Rather, in 2013, after a lapse of 4.5 years, they asked the IDA whether you are prepared to allot it at your old rates. So this is a case where there has been no decision taken by the government in terms of Rule 19. I just point out these documents to you, Lordship. The document I will come to page 55, my lord, annexure P5. That decision is required to be taken. The government has to decide it one way or the other. The government has not decided it. And I point out only one document from the return. If my lords are pleased to see the return, it is February 20th, February 2018. If my lord see, the election are page 16, my lord, with their return. This recommendation was forwarded to the state government for approval. Yes, my lord. That your lordship would be pleased to find P7, page 45 with the petition. P7, my lord, dated 13th November 2009. When the resolution was passed that they are not ready to make allotment at the old rates. My lord, 13th November 2009, it was sent for approval to the government. Yes. The government under Rule 19 of the Variant Name, it was privileged to take a decision one way or the other. I just point out to you. Those regulations of 1975, my lord. Can you see those? So first, this idea has to take a decision, and the idea has already forwarded tender. After approving it, it will only just seize P7 at 245. Just for 1 second, below. P7, 13th November 2009. This is a letter by IDA to Pramukh Sachiv, Madhya Pradesh, Awas एवं पर्यावरण विभाग मंत्रालय. Kindly see, madam. First two paragraphs talk about details of the NIT given, madam, which was noted by the IDA. Recommendation to the government, madam. Then your lordship may kindly see this letter, madam. They accept it.
This is letter फाइल इसी paragraph. उक्त चारों निविदाओं में भूखंड क्रमांक 121 हेतु श्री महादेव सुप्रत ट्रस्ट द्वारा रुपए इतना इतना प्रति वर्ग मीटर तथा भूखंड क्रमांक 522 हेतु इंदौर एजुकेशन एंड सर्विस सोसाइटी द्वारा इतना इतना प्रति वर्ग मीटर की उच्चतम निविदा प्रस्तुत की। नेक्स्ट पेज में सेकेंड पैराग्राफ हम लिखा। इसी प्रकार भूखंड क्रमांक 521 हेतु श्री महादेव शारदा सुप्रत ट्रस्ट द्वारा शिक्षा विभाग के नियमों के अंतर्गत पंजीकरण संबंधी प्रमाण पत्र आज प्रस्तुत किया गया है तथा सोसाइटी द्वारा प्रस्तुत उच्चतम निविदा दर रुपए 5811 प्रति वर्ग मीटर को पर्याप्त एवं उचित पाते हुए स्वीकृत की गई। तदनुसार शासन अनुमोदन प्राप्त करने के लिए अग्रसर कार्रवाई की जा रही है। प्राधिकारी बोर्ड द्वारा लिए गए निर्णय के परिप्रेक्ष्य में योजना क्रमांक 114 द्वितीय में नर्सरी स्कूल के भूखंड क्रमांक 600 हेतु श्री महादेव शारदा सुप्रत ट्रस्ट इंदौर द्वारा प्रस्तुत उच्चतम दर रुपए 100 एवं रुपए 100 और भूखंड आवंटन की अनुशंसा के समक्ष प्रखंड शासन के अनुमोदन हेतु प्रस्तुत है। So this was formal government my lord. Yes. Now finally see rule 19 these rules my lord, which I just passed down to my lords. Rule 19 man. Yes. The authority may, with previous approval of the state government, lease out on concessional terms any authority land to any public institution or body registered under any law for the time being in force. So they recommended it to the government. So the government had to take a decision one way or the other. They did not decide the matter. My lord, I will not take precious time. P9 no decision there. No decision was taken. There was correspondence going on from 2010 until 30th of March 2016. These documents are P9 to P30. The matter was pending before the government. We tried to deposit balance money also with idea. With idea returned. Now, surprisingly, the only decision taken by the government is, if your lordships are pleased to see the reply, on number 2 and 3, held in February 2018. Reply, yes. Kindly come to page number 1. Respond number 2 and 3. Idea. And that's you. 16 month. Marked as R21. ये एफिडेविट ऑफ सीईओ ये है क्या? नहीं सर, इस पे R21 के तो मार्क किया इसको एज एक्स्ट्रा। पूरी लॉजिक बेटे किया देख रहा हूँ। R21. This is the letter issued by the Madhya Pradesh Shasan Awas एवं पर्यावरण विभाग dated 26/9/13. Reply to rejoinder, additional reply. No, madam. This was the first reply filed by respondent number 2 and 3. This is filed in February 2018. Yes. Page 16, my lord. And kindly see the pleadings and document both, my lord. Para 2F of the pleadings, R21, page 16. Yes, this is 26/9/13, my lord. And if your lordship sees the endorsement to left hand, it is received by the ID on 8th of May 15. There is a stamp, my lord. And kindly see what the government writes. संदर्भ मुख्य कार्यपालन अधिकारी इंदौर विकास प्राधिकरण से दिनांक 18/9/13 को हुई चर्चा। उपरोक्त विषयांतर्गत संबंध में निर्देशानुसार लेख है कि प्रकरण में 2 वर्ष पूर्व बोर्ड में भूखंड वहन का निर्णय लिया गया तथा अब प्रश्नाधीन भूखंड की वर्तमान कलेक्टर गाइडलाइन के अनुसार कीमत बहुत बढ़ गई है। अतः क्या इस भूखंड को पूर्व दरों पर विक्रय किए जाने के निर्णय पर बोर्ड सहमत है? अगर जानकारी यथाशीघ्र भेजने का कष्ट करें। It is not a decision, madam. Trying to put words in the mouth of idea. Are you prepared to give it on all days? This proposal was forwarded to them on 13th November 2009. After almost 4 years, and then, my lord, what transpired is, your lordship may kindly come to the next document, R22. Next page, my lord. 8/5/15 they received this document, and 16/7/15 they pass a resolution that we are not prepared to adopt it on old rates. This is their resolution dated 16/7/15. Yes. And then, madam, kindly turn to the next page. On 10th August 2015, they informed the state government that we are not prepared to adopt it at old rates. And then your lordship would be pleased to find the impugned order came to be passed. One of the impugned order is P32, page 92. Of the petition. Yes, madam. This is dated 26th November 2016. P32, page 92. Now we have kindly come to page 93. Yes. They refer to, kindly see last but one paragraph. I'll not read it, but they say this letter was received by them on 8/5/15. Letter dated 26/9/13. Then they refer to the resolution dated 16/7/15, which I just demonstrated before the lordship. And then, your lordship may just kindly come to the operative portion of this order. Page 95, madam. विधि प्रावधान क्या है सर? ये कुछ ऊपर से छोड़ के इधर से आप देख लें, वर्ष 2009 से 2013. It's around 9 of this paragraph. 2009 से 2013 के मध्य. Yes. प्रश्नाधीन भूखंडों की बाजार दर कलेक्टर गाइडलाइन में वृद्धि हुई है एवं वर्ष 2013 में ही राज्य शासन द्वारा दिनांक 26/9/13 में यह स्वतः उल्लेख करते हुए कि प्रश्नाधीन भूखंड की वर्तमान कलेक्टर गाइडलाइन दर अनुसार कीमत बहुत बढ़ गई है, अधिकारी से यह अपेक्षा की गई कि क्या इन भूखंडों को पूर्व दरों पर विक्रय किए जाने निर्णय पर बोर्ड सहमत है। इसके प्रति उत्तर में अधिकारी बोर्ड द्वारा संकल्प दिनांक 16/7/15 के द्वारा अपनी असहमति का निर्णय लिया जाकर शासन को पत्र दिनांक 10/8/15 के द्वारा अवगत कराया जा सकता है। मध्य प्रदेश शासन नगरीय विकास एवं पर्यावरण विभाग द्वारा पत्र दिनांक 21/12/15 के द्वारा अंतिम रूप से निर्देशित किया गया कि प्रश्नाधीन भूखंडों के वहन के संबंध में प्राधिकारी के मतानुसार इंदौर विकास प्राधिकारी के वित्तीय दृष्टिगत रखते हुए कार्रवाई की जाना सुनिश्चित हो, अर्थात पत्र दिनांक 6 अनुसार राज्य शासन का भी यह मत रहा कि प्राधिकारी प्रश्नाधीन भूखंडों की वर्तमान कलेक्टर गाइडलाइन अनुसार कीमत बहुत बढ़ गई होने से पूर्व दरों पर आवंटन हेतु सहमत नहीं है। आप वर्तमान में पूर्व दरों पर भूखंड का वहन किए जाने में प्राधिकारी सहमत नहीं है। राज्य शासन को भी यह भलीभांति ज्ञात हो गया था कि प्रश्नाधीन भूखंडों की वर्तमान में दर अत्यधिक हो जाने के कारण यदि पूर्व दरों पर आवंटन किए जाने का निर्णय लिया जाता है, प्राधिकारी के वित्तीय हित विपरीत रूप से प्रभावित होंगे। इस कारण ही राज्य शासन द्वारा दिनांक 21/12/15 द्वारा प्राधिकारी को निर्देशित किया गया कि प्राधिकारी यह वित्तीय हित को दृष्टिगत करते कार्रवाई किया जाना सुनिश्चित करें। स्थिति के आलोक में यह कहा जाता है कि प्रश्नाधीन निविदा है, निविदा होने के बाद 90 दिन के अवधि के पश्चात प्रभावशील नहीं रहेगी थी। वर्तमान में प्रश्नाधीन भूखंडों का बाजार मूल्य कलेक्टर गाइडलाइन पर अत्यधिक वृद्धि हो जाने से यदि इनके परिप्रेक्ष्य में प्राधिकारी द्वारा प्रश्नाधीन भूखंडों को न लाभ न हानि की दर पर व्यय की पुनः कार्रवाई की जाती है तो निश्चित रूप से प्राधिकारी को वित्तीय लाभ प्राप्त करना सुनिश्चित है। इस स्थिति में शासन के पत्र दिनांक 6 के परिप्रेक्ष्य में प्रश्नाधीन भूखंड क्रमांक 521 के लिए महादेव सहरा उपलब्ध की ओर से प्रस्तुत निविदा एवं भूखंड क्रमांक 522 के लिए इंदौर एजुकेशन एंड सर्विसेज सोसाइटी द्वारा प्रस्तुत निविदा स्वीकार करते हुए निरस्त करने का निर्णय लिया जाता है। They are harping upon the increase in price. This is just a reference which I will point out to your lordship. If your lordships come to the conditions of the tender, 36. P6 page 36. This is Nivida, my lord. Page 36. Annexure P6.
Yes.
And your lordship may kindly come to these are the conditions. Page 40, my lord. And clause 11. Now this would bring out the fallacy of the logic which is applied. विज्ञप्ति में उल्लेखित भूखंड की न्यूनतम दरें न लाभ न हानि की दरों के आधार पर निर्धारित की गई है, जबकि योजना में व्यावसायिक भूखंड के लिए निविदा कलेक्टर द्वारा वित्तीय वर्ष के लिए निर्धारित गाइडलाइन के आधार पर न्यूनतम दर निर्धारित करते हुए आमंत्रित की जाती है। These are the keywords. इस प्रकार विज्ञापित भूखंड की न्यूनतम दरें गाइडलाइन की दरों से अत्यधिक कम होकर भूखंड की निविदा दरें भी तदनुसार प्राप्त होती है। इसलिए भूखंड पर निर्मित होने वाले भवन में निर्धारित उपयोग अनुसार जो गतिविधियां की जाएंगी उसमें समाज के कमजोर एवं निम्न आय वर्ग के परिवारों के लिए न्यूनतम 10% आरक्षण रखा जाना होगा और साथ ही इस श्रेणी के लिए संस्था द्वारा गठित की जाने वाली संचालक समिति द्वारा किया जाएगा। इस संचालक समिति में प्राधिकारी के अध्यक्ष अथवा अध्यक्ष द्वारा अधिकृत वरिष्ठ अधिकारी को स्थायी सदस्य के रूप में सम्मिलित करना होगा और संचालक समिति की बैठक प्रतिवर्ष कम से कम 2 बार आयोजित की जाए। So the rates which were at that point of time, it was more than the collector's guideline. So since it was a concessional clause for educational purposes, logic that there has been an increase in price over the period of time, 2009 to 2013 in itself occurs, madam. And then the second defense which they raise is based on subsequent rules which I shall presently point out to your lordships. My lord, they say that now it is not possible for them because the field is occupied by these rules. 2013 rules because they repeal the previous rules, my lords. If my lord comes to me, कब का है टेंडर पहले का पुराना 2009 इनकी एनआईटी की डेट है 22/8/2009 इलेक्शन थी because of these new rules 2000 new rules with the saving clause, madam. That's what I want to point out. This is rule 38. Rule 38. Yes, my lord. Sub-rule 2 is material, my lord. Kindly see the language of the rule, my lord. May I read, my lord? Yes. Where disposal of any property has been initiated by any authority prior to the date of final publication of these rules and public notices for disposal of such property have been published in any newspaper, such disposal shall be governed by Madhya Pradesh Nagar तथा ग्राम निवेश विकसित भूमियों भवनों अन्य संरचनाओं का विनियमन नियम 1975. However, if by any reason the authority fails to dispose of the said property under the process initiated by issuing said public notice in newspapers mentioned here and above, the subsequent process, this comes to subsequent, if that subsequent process of disposal of the property shall be undertaken under these rules, that is मध्य प्रदेश विकास प्राधिकरणों की संपत्ति का प्रबंधन तथा विनियमन नियम 2013. Now in this way they fail to dispose of the property. The issue condition is satisfied here, madam. They advertise it in newspapers. The process was initiated. Now it was kept pending by the government for long, 4.5 years. I come to that aspect of the matter also. But this saves it. And then, I'll point out one more set of rules. In 2018, again, new set of rules came along. And there is no provision which disturbs or obliterates any process which is initiated under the previous rules. You will also see sub-rule 2. These rules, sorry, that was it. These rules shall come into force from the date of their publication in the official gazette. Before the date of coming into force of these rules, any action taken for properties disposed under provisions of मध्य प्रदेश नगर तथा ग्राम निवेश विकसित भूमियों ग्राम भवनों तथा अन्य संरचनाओं नियम 1975 एंड मध्य प्रदेश विकास प्राधिकरणों की संपत्तियों का प्रबंधन तथा व्यय नियम 2013. So it talks of property disposed either under 75 rules or under 2013 rules. These are the keywords. Unless such work is incompatible with provisions of these rules, the action taken under the corresponding provision shall be deemed to be taken under these rules. So these two set of rules, they do not obliterate the process which is initiated under 1975 statutory minimum. Now there is one more aspect. Your Lordship may kindly see a detailed order dated 30th November 2018 passed in this writ petition. In terms of pleadings which are raised in para 1.13 of the writ petition. Please see order dated 30th November 2018. I am referring to, it is a case, madam, in this particular matter. It is a case where the government has not decided on the recommendations of Indore Development Authority in matter of allotment, and therefore proper reply has to be filed by Principal Secretary Urban Development Authority. The petitioner, in para 5.13 of the writ petition, raised very vital questions which has to be answered by the state government. Let the reply be positively filed along with the affidavit of Principal Secretary. Another aspect of the case is, in similar circumstances, Guruji Seva Nyas, as stated by the petitioner, was allotted land in 2007. Petitioner has been discriminated. Land has finally been allotted to Guruji Seva Nyas on 21/7/2017, charging same rate of 2007 after 10 years. So these two aspects were directed to be clarified. Now your Lordship may just kindly come to detailed reply which is filed by the government, my lord, this is in form of reply, number one, respondent number one. My lord, this is a reply wherein affidavit is sworn on 9th January 19. So it is filed somewhere in January 2019. And the index contains details of 3 documents, R12, R13 and R14. Now let kindly see the reply which they have given. I'll just point out those paragraphs. At page 3, my lord, of this return, they have reproduced paragraph 5.13 of my writ petition. At page 3 of the return. Here is 5 question. Who is responsible for the delay in deciding on request for permission sought for by IDA? What action has been taken by the state against that person? In how many cases permission has been granted by the state? What was the date on which permission was sought? The date when permission was granted. The tender rate and rate on which such permission is granted. If permission has been considered and decided by the state for request, rate after the request made is present. Reasons for deciding those cases are raised by you have been answered. Yeah. Now, not kindly see the answers given in the next page. और जो चार्ट आपने पेश किया will show that fact to you. 2. Without prejudice to aforesaid preliminary objection, as regards para 5.13a, it is submitted. There was no willful delay on the part of the government in deciding allotment of petitioner's plot in question. Correspondence was going on between the answering respondent and respondent number 2 with regard to the plot in question. The state government has taken the decision exercising powers conferred in Rule 19 of MP Nagar Gram Deposit 1975. Copy of details of correspondence is annexed to and marked as R12. Now, please see this document. R12. This is the correspondence की डिटेल्स दी है कि 13/11/2009 को आईडीए ने इनको प्रस्ताव भेजा और 21/12/15 तक ये correspondence चलती है. Now please come to the next page, madam. सर इन्होंने एक लिस्ट पेश करी है 9 केसेस की. कंसेशनल रेट्स पे जो देना है और इनके पास कब प्रपोजल आया और इन्होंने उसको मंजूर किया. या आइटम इसका रेंज जो है सर वो 2 दिन से लगा के 19 महीने के भीतर किया है. ऑल अदर केसेस प्रायर टू दिस केस द मिनिमम ड्यूरेशन वाज 2 days एंड मैक्सिमम ड्यूरेशन वाज 19 months. ये आप देख लें सर आइटम वाइज इसको. पहला प्रपोजल 13/12/80 का था और ये सिमिलर केसेस में उन्होंने किया है. और ये मैं आपको दिखा देता हूँ सर. दिस इज बिकॉज दिस इज आइटम नंबर 1 से देख लें सर. 13/12/80 का प्रस्ताव आया इनके पास इस चार्ट में. 15/12/80 को इन्होंने ग्रांट कर दिया 2 दिन में. 15/2/2007, 13/6/2007, 15/2/2007, 13/6/2007, 6/10/82, 7/10/82, 10/1/79, 28/5/79, 29/10/82, 16/12/82. देन 20/12/78, 25/11/80. ये मैक्सिमम ड्यूरेशन है 19 महीने का. 4/10/2000, 24/10/2000. ये लास्ट जो है सर ये गुरुजी सेवा न्यास. दिस इज मटीरियल 4/2007, 12/4/2000. Within 2 days. Yes. And then they admit in their reply, because this is what ultimately comes to. If your lordship is pleased to see, of the question would be whether we can deny the allotment. Sir, allotment का नहीं, मैं तो ये कह रहा हूँ कि आपके पास एक प्रस्ताव आया है, उसमें से you are enjoined by the statutory rule to decide it. Yes. One way or the other. Because you are the approving authority. Now you keep it pending. After 4-5 years, you write a letter to the authority कि क्या आप पुराने रेट पे देंगे? Are they trying to put words of in the mouth of the authority? They have to decide. They have to decide one way or the other. You will not kindly see para 5. This is material. Para 5 of the same return. Same return. They say we don't have a prefixed codified criteria within which we have to deal with such cases. Para 5, my lord. Similar, the ground is open for a more prefixed codified or set principle on the basis of its decision to approve or reject any proposal of the authority to lease out the land, and constructional terms are to be decided. Since there is no prefixed codified or set criteria, the question as to whether petitioner satisfies that criteria doesn't arise. Because we don't want to decide. But in these circumstances, the position of law is very, very subtle. I'll just point out very quickly few decisions which occupy this field. Well, the first case is, this is a Supreme Court judgment, that here NIT was for sale of damaged food grains. And not take your facts. Negotiations for increasing highest rate quoted were going on. Now there was a refusal to accept highest rate which was challenged. And kindly see the observations on the Supreme Court, para 7 and 8. May I read one?
Para 7.
In contractual sphere, as in all other state actions, the state in all its instrumentalities have to conform to Article 14 of the Constitution, of which non-arbitrariness is a significant facet. There is no unfettered discretion in public law. Public authority possesses power only to use them for public good. This imposes the duty to act fairly and to procedure which is fair play in action. Due observance of this obligation as part of good administration raises a reasonable or legitimate expectation in every citizen to be treated fairly in its interaction with the state and its instrumentalities, with this element forming a necessary component decision-making process in all state actions. To satisfy this requirement of non-arbitrariness in a state action, it is therefore necessary to consider in due way reasonable or legitimate expectation of persons likely to be affected by the decision, or else that unfairness in the exercise of power may amount to an abuse or excess of power apart from affecting bona fides of the decision in a given case. The mere reasonable or legitimate expectation of a citizen in such a situation may not by itself be a distinct enforceable right. Failure to consider, now this is very relevant. Failure to consider in give due way to it may render the decision arbitrary, and this is how the requirement of due consideration of a legitimate expectation forms part of principle of non-arbitrariness, a necessary concomitant of rule of law. Every legitimate expectation is a relevant factor requiring due consideration in a fair decision-making process. Now, let's kindly come to the last line. The doctrine of legitimate expectation gets assimilated to the rule of law and operates in our legal system in this manner and to this extent. Then we have finally come to the second celebrated judgment in Sandula as to what is expected of the government. So straight away take my lords to paragraph number 69, my lord. These are the broad parameters of a valid tender. Then can we see para 70 first 3 lines. It cannot be denied that principles of judicial review would apply to the exercise of contractual power by the government bodies in order to prevent arbitrariness and favoritism. Can we skip 3-4 lines? The principles laid down in Article 14 of the Constitution have to be kept in view in accepting or refusing a tender. There can be no question of infringement of Article 14 if the government tries to get the best person or the best quotation. The right to choose cannot be considered to be an arbitrary power, of course. If the said power is exercised for any political purpose, the exercise of that power will be struck. Kindly come to the next page, my lord. 74. Judicial review is concerned with reviewing not the merits of the decision, in support of which application for judicial review is made, decision-making process itself. And then kindly come to para 77. The duty of the court is to confine itself to the question of legality. Its concern should be, not kindly come to item 5, abuse its power. And in this line, therefore, it is not for the court to determine whether a particular policy or particular decision taken in fulfillment of that policy is fair. It is only concerned with the manner in which those decisions have been taken. The extent of the duty to act fairly will vary from case to case. Shortly put, the grounds upon which an administrative action is subject to control by judicial review can be classified as under. Now, we will kindly see one, illegality. This means the decision maker must understand correctly the law that regulates its decision-making power and must give effect to it. So you have to decide whether this proposal of the authority is to be approved or not approved, or even is to be decided by you. You can't leave it and go back after 5 years to the authority that are you prepared to do that old race. Then your lordship can kindly come to third judgment below. This is a Delhi division bench wherein the entire law is crystallized, and in para 21, this Supreme Court judgment in Food Corporation of India was considered. And kindly come to para 23. The proposition of law which emerges from judgment cited above is that highest bidder has a right to consideration of his bid. However, highest bidder need not be accepted. The tenderer has a right to reject the highest bid if the bid is inadequate. But he has a right of consideration.
He has a right of consideration.
Yes. And that's what my complaint is. You keep my proposal pending for 4.5 years, still you can decide it. Then your lordship may kindly come to a recent Bombay Division Bench judgment below, flag 4, wherein this aspect has again been highlighted by law. Para 11. Before proceeding to consider prayers as made in the writ petition, it would be necessary to first consider as well as broad parameters laid down by the Honorable Supreme Court in tender matters. Same can be done that the following heads: right of a bidder vis-a-vis right of principal to accept the bid, best bid. The right of a bidder to a fair consideration of his offer, coupled with the fact he is entitled to a fair, equal, and non-discriminatory treatment in the matter of evaluation of a bid is well recognized. Then you will just skip few lines. At the same time, the principal has a discretion not to accept the lowest or the highest bid to undertake a fresh exercise of bidding in a given case. So I don't dispute it. But you have to first decide it. And then we come to the decision-making process versus correctness of decision. And I am referring to last 3 lines of this paragraph in this regard. Let you get it? In this regard, we may refer to observations of Honorable Supreme Court in Tata Cellular versus Union of India, Tata 74 is quoted here again, madam. And then can we come to next, clause B, duty to record reasons vis-a-vis reasons that persuaded the authority to take its decision. Reference can be, I am referring to somewhere here. Reference can be made to a recent decision of the Honorable Supreme Court, is National Highway Authority versus Madhu Kumar, wherein aspect of duty to give reasons has been considered. The earlier decision in Rajiv Suri versus DDA was referred to, wherein it was held when the statute itself provided an express requirement of a legal order. It was understandable that absence of reasons would be a violation of such legal requirement and therefore illegal. In cases where there is no such express requirement of reasons, the ultimate effect of absence of reasons on the final decisions cannot be seen in a straight-jacketed manner. Such cases would have to be examined from a proper perspective in the light of overall circumstances. The court would look at the nature of decision-making body, nature of rights involved, stakeholders, form and substance of the decision, etc. The ultimate inquiry would be of application of mind. The reasoned order would be merely an element in this inquiry. Then, after quoting at the bottom of the option you find, para 62 of this NHAI judgment is quoted. Please come to the next page. This is the quotation para 62 of this NHAI judgment. Even if, actually get it now on the next page. Even if there is no duty to record reasons in writing, undoubtedly it must be followed, and it would amount to violation of the statute if it were not followed. Even if there is no duty to record reasons or support an order with reasons, there cannot be any doubt that for every decision there must be reason. The Constitution does not contemplate any public authority exercising power with caprice or without any rationale. Here again, in absence of the duty to record reasons, the court is not to be with power to strike down administrative action for mere reason that no reasons are to be found recorded. In certain situations, the reason for a particular decision may be gleaned from the pleadings of the authority when the matter is tested in a court. From the materials, including file notices which are made available, the court may conclude that there were reasons the action was not illegal or arbitrary and so on and so forth. And last but not the least is the latest 2023 judgment, wherein their lordships have again emphasized on Article 14. My lords may kindly come to para 30. Almost identical, the subject matter is different, but the point is same. The above discussion gives way to the question whether such an action of application remaining pending for an unreasonable period will itself be classified as an arbitrary and unreasonable act. A constitutional bench of this court in natural resources allocation, so and so, observed in regards to contracts having the state as a party as here under reproduced. Now, I'm referring to here, my lord. For an action. For an action. For an action to be able to withstand the test of Article 14 of the Constitution of India, it has already been expressed in the main opinion that it has to be fair, reasonable, non-discriminatory, transparent, non-capricious, unbiased, without favoritism, nepotism, in pursuit of promotion of healthy competition and equitable treatment. The judgments refer to endorse all those requirements where the state, its instrumentalities, and their functionaries are engaged in contractual transactions. Therefore, all governmental policy drawn with reference to contractual matter, it has been held, must conform to the aforesaid parameters. While Article 14 of the Constitution of India permits a reasonable classification having a reasonable rational nexus to the objects of to be achieved, it does not permit the power of pick and choose arbitrarily out of several persons falling in same category. Therefore, criteria or procedure have to be adopted so that choice among those falling in the same category is based on reasons, fair play, non-arbitrariness. Even if there are only two contenders falling in the zone of consideration, there should be a clear, transparent, objective criteria or procedure to indicate which out of the two is to be preferred. And now let us kindly see before. The lordships have made an attempt to define what is reasonable time. This case hinges on what would be construed to be reasonable time to consider any application reduction in maximum demand by the authorities. A three-judge bench of this court in adjudicating officer was so and so versus Bhavesh Papri, then it is quoted, my lord. Then we come to the next paragraph, 35. It has been observed that this is all too well settled principle to require buttressing precedent. Nonetheless, The court refers to state of Gujarat versus Patel Gaga Nathan, wherein period of 1 year was found to be too long for the commissioner to exercise revisional jurisdiction under section 211 of Indian Land Revenue Code. The principle of reasonable time as mentioned herein was followed recently by a two-judge bench in Security and Exchange Board of India versus Sunil Krishnan Khaitan. Keeping in view all above stated well-established principles that state action, irrespective of being in contractual realm, must abide the Article 14 so that A, after passage of considerable period of time in July 2004, the reduction to so-and-so PVA was agreed to and a new agreement to that effect was entered. Irrespective of amount of reduction, kindly come to C. No reason has been put forth for keeping such application pending. So, what is the reason why the government kept it pending? It is still pending. It is the authority which scrapped the process under the lead of the government that based on that 26/9/2013 letter, that are you prepared to award it at older rates? And now, IDA has filed a return, additional return, in compliance to my lord's order dated 30th November 2018, my lord. This is an additional return, my lord, filed by the IDA, my lord. I just give a glimpse of this return, my lord. Reply to the journal. This is titled as, my lord, number 2, respond number 2. Additional, this is by respond number 2 and 3, my lord. This is September 2018, reply to the journal. Additional reply. Yes. My lord, in this they have tried to justify. It shows those documents one by one to my lord. Your lordship may just kindly come to the failed voluminous documents. Please come to page 11, my lord. Page 11, sir. R25 सर ये 10/4/2007 का अलॉटमेंट है। इसमें आइटम नंबर 7 और 8 पे आप देखेंगे गुरुजी सेवा न्यास। इनको 2 प्लॉट्स 5200 के रेट से पर स्क्वायर मीटर के अलॉट हुए। उसके बाद सर आप देखेंगे R26 13 ये 12/4/2007 है। 2 दिन में गवर्नमेंट ने अप्रूवल 10/4 का आईडीए ने भेजा गवर्नमेंट को 12/4 को। उसके बाद सर नेक्स्ट पेज देखे पेज 14 12/4/2007 को इनको रखना सेम डे। सबको अलॉट करके इनको छोड़ दिया। और इसके बाद नेक्स्ट पेज 15 पे आप देखेंगे ये इनका अलॉटमेंट लेटर है 29/8/2007। इसका गुरुजी सेवा न्यास। ये 2 हैं सर, एक 15 और 16 का। एक प्लॉट ए का है, एक प्लॉट बी का है।
So their applications were decided promptly.
प्लीज नहीं, इसमें दूसरी चीज हुई है सर। हाँ, मैं बताना चाह रहा हूँ, आप जो कहना चाह रहे हैं कि मैं निकल गया है सर, ये 21/6/2007 को इसकी शिकायत हुई और लोकायुक्त ने ये रिपोर्ट भेजी है सर 21/6/2007 को। और इस रिपोर्ट में इस पूरे प्रोसेस को स्क्रैप किया गया है। पेज नंबर 27 से निष्कर्ष में यदि आप देखेंगे सर इसके बाद पेज 28 पे देखेंगे WP 7724 ऑफ 2008 फाइल हुई और ये रिट पिटिशन हुई सर। ये पेज 57 पे आपको लास्ट पैराग्राफ में मिलेगा। And the locality was requested to consider it again. सर इसके बाद 60 पे आप देखेंगे 13/30/2016 को लोकायुक्त ने ये प्रकरण समाप्त कर दिया। कॉपी आपने लगाई है। ये पेज 68 पे कंक्लूजन है सर। The case is hereby closed with a direction to initiate concerning parties accordingly. Sir, फिर ये 15/3/17 almost after 10 years, the allotment was dated 10/4/2007. 15/3/17, we passed the resolution, kindly come to the next page of this resolution, my lord, page 70. बात कर पेज नंबर 70 है सर मेरे जो सप्लाई किया आपने। This is the last portion of this note sheet, madam. It's resolution. संकल्प क्रमांक 72 15/3/17। ऐसी स्थिति में यहां से मैं निवेदन कर रहा हूं सर, ऐसी स्थिति में निविदाकर्ता द्वारा जो प्रस्तुत उच्चतम निविदा दर ₹5200 प्रति वर्ग मीटर जो शासन द्वारा पत्र क्रमांक 1600 दिनांक 12/12/7 द्वारा अनुमोदित की गई थी के अनुसार जारी भूखंडों का आवंटन यथावत रखा जाता है। भूखंड हेतु शेष राशि का आवंटन का सूचना पत्र प्राप्त होने के दिनांक से 30 दिवस के अंदर होगी and so on and so forth. But in this case, this entire matter remained pending before the Lokayuk, then before this honorable court, and then it went back and again remained pending before Lokayuk. So this was fault of nobody. Neither party could be imputed with the delay cost. Still they allotted after taking up on same rates. Now, in my case, the matter was kept pending by the government for no fault of mine. I presently point out to your lordship that I tried to deposit the amount also. If your lordship sees page 62 with my writ petition, ये मैंने सब 15/7/15 को इनसे पैसा दिया। Page 62. इनको चेक जमा किया था मैंने 39 लाख रुपए का आईडीओ को। ये 15/7/15 पे मैंने इनको पेमेंट किया है सर कि आप मैं जमा करने को तैयार हूँ। 88 पे आप देखेंगे कोई डिमांड था क्या? जी सर, कोई डिमांड नहीं था सर। तो डिसाइड ही नहीं हुआ तो डिमांड कहाँ से आएगा? जब मैंने to show my bona fides that I'm prepared to deposit. 88 is a lordship CP29.
Certainly deposit का रेट बढ़ चुका है ना
सर। इसमें रेट का जो this question will have to be addressed by the government. I'm not saying that the government doesn't have authority to decide. It can take any action. It can decide one way or the other with reasons. And in that process, I'll have to be hired. What is my fault? आपकी क्लॉज का कि हम उसी वक्त जो दर थी उससे पहले दे रहे हैं। That is what clause 11 says. So where is the question? This is a case where the government has committed a blatant violation of its statutory duty, not deciding it, and throwing the ball back to the idea. Yes. That is the submission. Therefore, my request submission is that this P32 may be quashed, and the government will be directed to consider and take a decision on the recommendation of IDA P7 by law, dated 13th November 2009.
Decision and recommendations of the IDA.
My lord, dated 13/11/2009, Annex Check P7.
13/11/2009 annexure P11, my lord. P11. Yes.
And my lord, just since I have crystallized everything, just prepared a synopsis for my lord's convenience. All list of dates and events, everything is in this, my lord. That is the assumption. Right.
Yes. If you are appealing for ID 2 and 3. Yes. तो किया और बड़ा वर्मा लिखना सुप्रीम कोर्ट के गवर्नेंस रेफर करके
The NIT was published on what 22/8/2009.
वो तो सर एडमिटेड पोजीशन है उसमें कोई डिस्प्यूट नहीं है The only thing is you are required to complete the process, either reject their claim or allow.
That has been rejected.
Where?
By NHS P32.
P32.
And that decision has been communicated to the petitioner. P32 at page 19, no? 92. It is in order passed by the Indore Development Authority after the restrictions of the state government to take appropriate decision in the matter. It starts from page 92 law 26
ये वहाँ प्रोविजन ऐसा है कि रेट बढ़ गए तो आप उनको नहीं देंगे
That has been reservation in our tender condition itself. I draw your lordship kind attention, Lord, with page number 36. Lord. The condition number is 15 with page number 40, which is very material and decisive to decide the whole controversy or to decide the petition. Page number 41.
conditions of tender.
Yes, please.
Which clause?
Clause number 15, page number 41. निविदा प्राप्त होने के बाद निविदा समिति द्वारा जो भी उच्चतम निविदा समिति द्वारा निर्धारित शर्तों के परिप्रेक्ष्य में प्रस्तुत अनुशंसाओं के आधार पर प्राधिकारी बोर्ड द्वारा लिए गए निवेदन तथा राज्य शासन की अनुमति के पश्चात I will emphasize on that part कि राज्य शासन के
यहाँ पे आपने डिसीजन लिया कि इनको अलॉट करना है.
there is no such decision. And
अनुशंसा तो किया आपने.
received the tender and they are tender to be
Yes.
and therefore we have forwarded to
Recommended. Permission from the state government.
so have not recommended allotment in favor में
वैसा नहीं किया आपने. Permission
recommended to the government we have received and if the government has accepted the tender then we will issue out the
The question is of delay. Government sitting tight over for 4 years, 5 years. That is the issue.
that is pending is part of the government here, not at my part. And here, the entire submission was made like that, Lord, when the concluded contract come into the force. Then only all such case law and all such proposition, it was argued by my friend, has been applied. Here there is no case of concluded contract. Here the case is only that we have received the tender.
So who is at fault? Whether the petitioner can be said to be at fault or the respondents.
And not
इन्होंने तो सब भर दिया, पैसा पूरा जमा कर दिया आपने. As per conditions, जो भी stage रही वहाँ तक पैसा जमा कर दिया.
they have only paid the initial tender amount.
Yes, definitely.
It's 5 lakh.
Once you approve, thereafter they will pay.
And that has not been approved.
Why? Why are you keeping tight? आपने तो बता दिया कि हमने भेज दिया. स्टेट गवर्नमेंट से पूछ लेते हैं क्या किया.
Government has taken sign below.
Why?
Thereafter the government has taken the decision.
Can you keep this matter pending for indefinite period? That is the issue. साल के बाद कीमत बढ़ गई. अब आप बोलते हैं कीमत बढ़ गई. वो भी कर सकते हैं कि नहीं करते, कर सकते हैं, वो भी देखना पड़ेगा.
वो मैं आपको जब इसके लिए आप देखें सर, सबसे पहले मैं आपका ध्यान एक ऑर्डर शीट की तरफ आप इन्वाइट करूंगा. That order sheet is your.
तो ठीक है, मतलब आईडीए का तो रोल खत्म हो गया. आपने कहा कि आपने फॉरवर्ड किया, उन्होंने डिसीजन लिया नहीं. We asked the state government what is the reason.
But that is order sheet dated 10/9/2018. It is very bad.
In this case,
Yes.
10/9/2018.
18.
Yes.
Parties through their counsel, learned counsel for the parties wishes to examine Supreme Court judgment passed in Haryana Urban Development Authority Limited and others versus Orchid Infrastructure Developers Private Limited and others reported in 2017. So Supreme Court cases to participate. Prior to that period, my entire case is based upon law. One Supreme Court judgment of Rishi Kiran Logistic Private Limited case. But this Rishi Kiran Logistic Private Limited case is just a position to other case. And one more situation is in the case of Rishi Kiran Logistic case, Lord. In that particular case, Lord, letter of intent has already been issued. And the government has taken the time to decision in the matter. And that has been upheld by the Honorable Supreme Court, Lord. Let us see. Lord, it starts from running page 1 to 40 of this statement. Paragraph 1 here, to understand the factual metrics of the case. The court plus took a decision sometime in the year 2005 to allow its plots on leasehold basis for a period of 30 years for the purpose of enabling the allottees thereof put up the construction of decreed storage tank. For this purpose, the Kerala Court Trust issued notice inviting tender dated 12/3/2005 and keep lot 45 line and I come directly on para number 2. The bidders were also informed that since these plots are under coastal regulatory zone, requisite permission from the competent authority under CRJ was required, which would be obtained by the Kerala Court Trust. In trial number 3, the appellant submitted his pleas with respect of clause number 14, 15, and 17. These bids were scrutinized by the tender committee of the Court Trust. Recommendations were placed before the Board of Trustees in its meeting held on 8/12/2005. It was followed by communication dated 7/1/2006 to the appellant in the form of letter of intent. But in our case, there is no such LOI has ever been issued in favor of the petition. This communication further mentioned that the formal letter will be issued to the appellant after the receipt of CRJ clearance in general. Now below para 5, it appears that CRJ clearance was ultimately received on 16/8/2010. However, this occurred more than 5 years after the NIT dated 12/3/2005 was quoted. This prolonged time led resulting to taking decision by the Board of Trustees on 9/12/2010 in the form of resolution number 108 deciding to cancel the tender process started in the year 2005. The decision of the Court Trust was conveyed to the appellant by letter dated 9/12/2010. Similar letters were written to the other tenderers as well who were issued similar laws.
But here there is no reason assigned that they have not decided at all.
Because we have decided at our end. After sending the matter to the state government instruct us take the decision with the present scenario of the present marketing.
State government did not have asked you any question. They have to decide. State has to take a decision and then communicate to you.
नहीं क्यों सेम सिचुएशन यहाँ पर भी तो है
नहीं यहाँ पे बकायदा उन्होंने उसको कैंसिल किया उन्होंने गवर्नमेंट ने लेटर लिखा
ट्रस्ट ने कैंसिल किया ना था सेम सिमिलर सिचुएशन हियर है
कैंसिल रिकमेंडेशन ऑफ द गवर्नमेंट
वहां पर जो है
दोनों में ये फर्क है कि अभी इसमें गवर्नमेंट का रिकमेंडेशन है आपके इसमें अभी नहीं है गवर्नमेंट आपसे पूछ रही है
गवर्नमेंट कोस्टल रेगुलेटरी जोन में कोई भी हमको रिकमेंडेशन तो नहीं
ठीक है उसको कंसिडर करेंगे और कौन सा गवर्नमेंट है
तब देखिए इसको आगे
क्लियरेंस आ गया था अल्टीमेटली CRZ क्लियरेंस वाज अल्टीमेटली रिसीव्ड ऑन 2010 in your case there is no clearance from the government is asking you question क्या आप इसको कर सकते हैं कीमत बढ़ गई ये जस्ट अबोव इट
जस्ट अपोजिट
नहीं, आप देखिए पैरा 5 पढ़ी है के केस में कहा है क्लियरेंस गवर्नमेंट का? यहाँ पे लिखा है इट अपीयर्स दैट CRZ क्लियरेंस वाज अल्टीमेटली रिसीव्ड ऑन 16/8/2010. Thus, चूंकि this clearance was granted after a period of 5 years, therefore you cancelled it. There was a clearance in this case. In the present case, there is no clearance.
Let us take the case in justa positions, my lord. The CRZ granted the dividend. Here in our case, the government has not given the dividend. In spite of that decision of CRZ, the port trust has taken the dividend, cancelled the allotment on the basis of 5 years delay in paying. After the decision of Coastal Regulatory Zone 1, the port trust of Kandla Port Trust has taken the dividend to cancel the NI2. In our case, there is no dividend.
टेंडर काय का था? अलॉटमेंट ऑफ स्पेस फॉर कंस्ट्रक्शन ऑफ सम स्टोरेज फैसिलिटी. They didn't become owner of that.
If we have been allotted to those, their position is also a levy. In Kandla Port Trust also, they intended to allot the land on the legal basis. There is no question of any ownership in both the two cases.
आपका क्या जवाब था? स्टेट गवर्नमेंट ने आपसे पूछा कि क्या इसको आप अलॉट कर सकते हैं, तो आपने क्या जवाब दिया गवर्नमेंट को?
जवाब दिया कि हम इस पुराने रेट्स पे करने की इच्छुक नहीं.
But that according to that clause, rule है ना, government rule 19 says that government has to take a decision. As per rule 19, government has to take a decision. You cannot take a decision on your own.
We have taken the decision on.
Please show us under rule 19 where government has taken a decision. There is no decision. Rules provide you have to follow the rules.
The authority may, with the previous approval of the state government, these are constitutional terms any authority lying to any public institution or body registered under any law for the time being in force. तो हमें तो यहाँ अप्रूवल मिला ही नहीं ना सर.
उन्होंने आपको क्वेश्चन पूछा था, उसका जवाब क्या दिया आपने?
हमने उसका जवाब ये दिया है कि हमने अपने बोर्ड में मीटिंग को कॉल किया, बोर्ड की मीटिंग हुई, तो बोर्ड इस बात पे सहमत नहीं है इसको ओल्ड रेट पे जो है अलॉट किया जाए, क्योंकि 2009 से 2015 के बीच सब्सटेंशियली गाइडलाइन वैल्यू में भी इंक्रीमेंट, और ये हमने कम्युनिकेट किया गवर्नमेंट को कि आप उस पर डिसीजन दो. गवर्नमेंट ने तो वापस से यही कहा कि आप अपने स्तर पर डिसीजन लेके और कम्युनिकेट करें. ये डिसीजन जो भी लिया है
19 बोलता है गवर्नमेंट हैज टू टेक अ डिसीजन. देयर इज नो डिसीजन ऑफ द गवर्नमेंट.
गवर्नमेंट पे कोई भी जो है सर,
चलिए आगे आगे बढ़िए.
अगर में जो है कोई डिसीजन ली,
यस
ना मिला Rishi Kiran logistic plan. I come directly on paragraph number 19.
19.
I skip over 3-4 lines now. It is a matter of record. It is a matter of record that for more than 5 years, the clearance has not been granted and come to be granted only on 16/8/2010. At that time, significant change occurred from the date of the issuance of the SIT in March 2005. The prices of the property had taken quantum jump. Now you are para 20. It is more than obvious that larger public interest demanded a fresh tender process in order to receive maximum amount is the premium of rupees 612 per square meter originally fixed. And even the quotation of rupees 3,000 in all of the applicant
which we have found to be highest, was far below market rate. There are 21. On the opposite fact, there is hardly any scope for argument if the decision of the port trust is arbitrary. It is based on valid consideration. It is based on valid consideration. We have to keep in mind that while examining this aspect, we are in the realm of administrative law. Para 22. When competing claims are private interest versus public interest, that is also covered in our case. Then in the case of disposal of public property, the question would be whether right of the person who has the right to have to the public property in a public auction is to be preferred over the right of the public to ensuring that valuable public assets were not disposed of except for a fair price and in a fair and transparent manner. Now, not in para 25, conducive pronunciation of the judicial review in the Tata Consular case has also been considered. Government is the guardian of the finances of the state. It is expected to protect the financial interest of the state. The right to reuse the lowest or any tender is always available to the government. And the principle laid down in Article 14 of the Constitution have to be kept in view. And accepting or refusing a tender, there can be question of infringement of Article 14 if the government tries to get the best person or the best quotation. The right to choose cannot be considered to be an arbitrary power. Of course, if the state power is exercised for any political purpose, exercise of that power in this strata. Now 74 or 77 से बात जो है, therefore, it is not for the court to determine whether a particular policy or particular decision in the fulfillment of that policy is fair. It is only concerned with the manner in which those decisions have been taken. The extent of the duty to act fairly will vary from case to case. Shortly put, grounds upon which an administrative action is subject to control by judicial review can be classified as under law. Now, at page number 250, para 28.
Yes, promise of the estoppel.
We therefore reject the contentions of the appellant whether doctrine of promissory estoppel applies. Again, to clarify at the outset that even the principle of promissory estoppel is in the field of administrative law, and while entertaining the argument and discussion on this issue, the question as to whether there was a concluded contract or not has to be kept aside. Precisely, this was done in SHRI Chini Mills case. The court dealt with the issue of legitimate expectation, etc., separating it from the issue pertaining to the concluded contract, and made the following pertinent observation in the process law. And after that law, come to the law para 30. Having noted the conceptual aspect of the doctrine of promissory estoppel, let us consider as to whether the applicant successfully invoked principle in the present case. For this, let us recapitulate the salient feature of this case having bearing on this. Apart from paying PMD of rupees 3 lakhs, the applicant did nothing more, and in fact, the occasion for the same even occurred in the present. But here in our case also, we have initially said the initial deposit of the tender. Now we are on next page, 52. After 5 lines block, thus except making payment of rupees 3 lakh in way of earliest money, the applicant did not incur any other expenses or suffered any liabilities or took any steps to implement the project of construction and maintenance of the tank. The High Court has therefore rightly remarked that even if it is assumed that issuance of NOI tantamounted to a promise given by the court, the applicant did not enter their positions to have prejudice went thereto to such an extent which could inspire the court to take the decision holding the promisor to its representation if necessary to do justice between the parties. Now we have para 32. The contention of the applicant therefore is equally deprived of preliminary. Whether there was a included contract between the parties, we have already indicated above that the doctrine of fair will as well as promissory estoppel are in the realm of the administrative law, whereas the issue as to whether the concluded contract was entered into between the parties, and if so, the question of enforcement of such a contract would be in the field of law of contract. Bearing in mind this distinction becomes more important as the High Court was dealing with the petition filed by the appellant under Article 226 Constitution of the India. And now in Miller, para 38. We have already held that the impugned decision of the court trust was not arbitrary, unreasonable, unmalicious, and further that the doctrine of promissory estoppel has no application in the present fact and circumstances. And the concluded paragraph in Lot 42. Having considered the matter and this limited angle in exercise of power of judicial review, we are of the view that on the fact of this case, no interference is required. The case of the appellant is that with the issuance of NOI, the concluded contract was entered in. He had submitted that only CRJ clearance was required, and even if NOI, which amounted to acceptance of the offer given by the appellant, it was contingent based on CRJ clearance. Even that clearance was granted by the competent authority ultimately. However, what is lost sight of in the entire process is that clearance was given by a period of 5 years. Because of that, neither any final NOI could be issued, nor position of the clerk, even or the payments received. It is also to be borne in mind. And apart from general CRJ clearance, specific clearance and individual basis in this behalf were also to be obtained. And ultimately, the appeal of the tender has been guiding Honorable Supreme Court. Another decision below on this issue is below Haryana Urban Development Authorities. I straight away come to the page number 255 of this bill. Two fifty five, para number 12. The reference of the judgment was converted into our order sheets.
Yes, yes.
It was not dated.
Parties wanted to
J.
go through this judgment, that's all, nothing more than that.
Firstly, the examine to question whether there being no concluded contract in the absence of acceptance of bid and issuance of
issue considered हुआ है क्या? Delay of 5 years.
सर इसमें नहीं ऋषिकेश में होगा
इसमें नहीं हुआ है, इसमें तो बिल्कुल ही मतलब जब वो हुआ, जब वो नहीं कर रहे थे तो वो कोर्ट में आ गए।
इसमें भी वही है कि कंक्लूडेड कॉन्ट्रैक्ट अगर आपके टेंडर पे से कोई भी जो है एक्सेप्टेंस नहीं हुआ,
वो तो बिल्कुल सही है, एक्सेप्टेंस नहीं हुआ बट हाई लॉन्ग क्वेश्चन विल बी हाई लॉन्ग।
जी allotment letter has never been issued to the petitioner as per regulation 6.2 in view of non-acceptance of the bid, that there was no concluded contract. And
ठीक है,
the last period एक पैरा नंबर 30 देखिए। इसमें ये सुप्रीम कोर्ट डिसीजन को जो है सब रेफर किया है और उसका पैराग्राफ 27 यहाँ पे कोट किया है, मेरिट डेवलपमेंट अथॉरिटी वर्किंग एसोसिएशन ऑफ मैनेजमेंट इंफॉर्मेशन, पैरा 27 है इसका। The bidders participating in the tender process have the right, except the right to equality and fair treatment in the matter of elimination of competitive bids offered by interested persons in response to notice inviting tender in a transparent manner and free from hidden agenda. One cannot change the terms and conditions of the tender. ये ही नहीं छूटगा, ये 2-3 लाइन के बाद आया। जो bidder is entitled as a matter of right to assist the authority inviting tender to enter into further negotiation unless the terms and conditions of the notification provided for such negotiation.
यहाँ पर negotiation नहीं है। ठीक,
अब सर बार बार आपके सामने पर गुरुजी सेवा लास्ट वाले केस को जो है हाईलाइट किया, मैं उस पर ही बता दूंगा सर कि गुरुजी सेवा न्यास का केस और इसका केस एक भाग वो आप देखिए सर उसकी
ये इनका ग्राउंड है डिस्क्रिमिनेशन का, ये सब आप सबको अवार्ड कर रहे हैं 10-10 साल के बाद,
वो नहीं कर रहे हो, नहीं है सर, वो नहीं है, उसका रिजल्ट है सर, वो मैं आपको पॉइंट आउट।
but that proceeding was quashed, allotment was also quashed, matter was referred to the लोकायुक्त, लोकायुक्त ने आया कि इसमें गड़बड़ी है, उसके बाद भी आपने 10 साल के बाद अलॉट कर दिया उसने।
लोकायुक्त ने क्लियरेंस दिया था,
हाँ, उसके बाद में क्लियरेंस दिया
कि कोई गड़बड़ी नहीं है, उसके बाद किया था, तो वो अलॉटमेंट नहीं किया था हमने, वो अलॉटमेंट बॉडी डेज के पहले हो चुका था, वही मैं आपको पॉइंट आउट करना चाह रहा था। अलॉटमेंट जो है गुरुजी सेवा न्यास के केस में जो है सर, 2007 को हमने रिजर्वेशन लेटर जो है गुरुजी सेवा न्यास को दिया, सर डेट मटेरियल है सर 12/4/2007 रिजर्वेशन लेटर हमने दिया था, ये रिजर्वेशन लेटर है सर हमारा। सर 8 to 7 8 to 7 our additional reply note
Yes.
तो ये R27 जो है हमारा, ये रिजर्वेशन लेटर हमने इशू किया 12/4/2007। इसमें नेक्स्ट पेज पे जो है सर अलॉटमेंट लेटर है 29/8/2007 को।
ये अलॉटमेंट है।
नेक्स्ट पेज 15 पे अलॉटमेंट लेटर है 29/8/2007।
इसमें गवर्नमेंट से परमिशन आ गई थी।
उसके पहले परमिशन आ गई, परमिशन के बाद हमने रिजर्वेशन दिया उनको, और रिजर्वेशन के बाद जो है अलॉटमेंट की।
तो उनका बिल्कुल विश्वास है कि कुछ सर्टन केसेस में परमिशन 2 दिन में आ जाती है और जिसमें अलॉट नहीं करना है उसमें 5 साल लग जाते हैं।
अलॉटमेंट के बाद जो है सर, अलॉटमेंट के बाद जो है सर लोकायुक्त की जो है प्रोसेस स्टार्ट हुई।
अगर उनके इसमें परमिशन आ जाती टाइम पे अलॉट हो जाता, तो वैसे ही जैसे सबको किया, वही तो है डिस्क्रिमिनेशन। Yes, this is the allotment letter 29/8/2007, पेज 15।
ठीक है। उसके बाद जो है सर लोकायुक्त की प्रोसीडिंग स्टार्ट हुई सर। लोकायुक्त की प्रोसीडिंग जाके क्लियर हुई सर 2016। उसके बाद 2017 में हमने जो है अलॉटमेंट लेटर्स को जो है एक्सेप्ट करते हुए जो हम पहले इशू कर चुके हैं, यहाँ इनके केस में न तो कोई रिजर्वेशन लेटर है न कोई अलॉटमेंट लेटर है। तो they are not supporting.
The issue is delay in deciding.
Delay in deciding the decision taken process by the government.
Even today, the government has not decided. In rest of the cases, government has decided in 2 days, 1 month, 2 months, maximum 18 months. So why not in this case?
In my respectful condition, government has decided or taking their decision. We communicate to us कि भाई अगर आप वो क्रेडिट दे सकते हैं तो बीपीओ भी दे सकते हैं, तो आप डिसीजन लीजिए।
गवर्नमेंट नहीं कर सकती थी वो, गवर्नमेंट had to take a decision on its own as per Rule 19. They cannot ask you questions कि ऐसा कर सकते हैं क्या। वो ना करते हुए आपने बोला, आपने हिंट लेते हुए उसको कर दिया खारिज। ये है डिस्क्रिमिनेशन का पॉइंट है इसमें, और कुछ नहीं है।
फिर डिस्क्रिमिनेशन से गुरुजी देवान्यास तो नहीं हो सकता।
नहीं हो सकता, वो बेबी का आपने अलग कर दिया था उसको ऑलरेडी, फिर वो सब्जेक्ट मैटर रहा लोकायुक्त का, किताब में आप एग्जोनरेट हो गए, वो बात अलग है। आफ्टर 10 years है ना, 2017 में। ठीक है, और कोई? ठीक है, रिजल्ट
चीजें आपको बता रहा था।
Because otherwise two petitions are also there, connected to this and
एयरपोर्ट तो 5-7 मिनट से अलग नहीं लगेंगे, क्योंकि पर्सनल कमेंट करते हैं आप लोग।
पर्सनल कमेंट छोड़ कर
और क्या कर रहे हैं, नहीं कर रहे, और क्या कर रहे हैं कोर्ट में सुनाई। 10 मिनट में कोई केस यहाँ DB 1 में होगा क्या? सब बड़े बड़े मैटर आपके यहाँ पर। मैटर on the larger side, you not more than 10 minutes, not more than 10 minutes. I'm making a promise here. ठीक है, tomorrow we'll continue. Yes, Mr. D'Souza.
I can only request my lord to modify the interpretation. Because looking at Mr. Raja,
If you are ready to hear after this, we'll take up your case.
my lord, I'm not able to impress my lord, is that this is, we have to make payments, man. There are 3,000.
Without hearing, we cannot modify even. We have to hear the parties.
Nobody is going to suffer if the order is placed.
If they are ready, then we can
challenge. It's a challenge to a tender, man. It's a consistency.
In this case is to be heard finally. It will also take time.
What I'm saying, my lord, normally tenders never stayed, because the public at large suffers. Now it has been done, my lord. Now what I'm seeking only from my lords is to modify it to a status quo. I'm not saying to vacate it. Modify it to status quo so that the mighty work continues, my lord. Now the situation is such that we don't We don't know where we stand because the contract has already been awarded to us. We got the whole assembly.
Without hearing, we cannot even modify. We have to hear.
They kept the matter today, Malak.
We have kept that. We have adjourned all the other cases. यहाँ सब पूरे final hearing motion में करते हैं. They don't touch the final hearing list. Normally, all cases are final hearing.
I appreciate.
So it's not possible for me. Yes, we are all the cases final.
Why not make this hear me 5 minutes on interim and reject it? I say reject it, my lord. But hear me once.
So we kept it today. You said we will take a chance. Because I knew that this only 4 days working, it's not possible to hear these kind of matters.
My lord, my lord may see my lord's order.
If you are ready, we can fix it on V16, Y7, any date you want.
I don't mind adjournment. What about those workers? What about the monthly work?
No, yes, Mr. Nema.
In case I lose, my lord, as it is, my lord, they continue, but then if it is modified, my lord, I will be nowhere, my lord. Now who's holding all the contracts?
Is Mandi work going on or not?
No.
We are already continuing.
No, there are these
He's neither the last.
He is the bidders.
It's only the bidder. We L4, not even L2, not even L3.
So we'll hear it tomorrow if you want.
We can hear it tomorrow if I can address my lord online. Because I have to be in.
देखिए आपको आवाज नहीं आती यहाँ पे. We must be, मतलब clarity होना चाहिए. में clear होना चाहिए.
Take a chance online. I have to be in Jabalpur. I will accommodate it item number 1 before.
Or whichever date you say, we'll fix it. Tomorrow, day after tomorrow.
I'm repeating myself, my lord, may just modify it to status quo, that's all, my lord, so that they can make the payments.
But I'll just verify what
My lord, which is, my friend can also, he's the Mali.
because I'm the representing the board, my lord. I'll just verify what is the problem. They are nowhere in picture, my lord.
They were able to point out certain discrepancies at the initial hearing. That is why
Answer with due respect.
Otherwise, there's no cause of interim, my lord.
See, my lord, I'm not favoring either them or them, my lord. What I'm submitting is that, my lord, they are not providing the manpower as of now. Even in the previous year, they were not providing the manpower. Now, my lord, SETMAP was providing the manpower.
he is not a contractor.
No, my sister concerns are there. And the contractors have been extended, my lord.
They are not discussed before the honorable court.
And we file it on record, my lord. Mandi has extended, my lord.
Where is that?
My lords.
Now, what they are doing, my lord, taking shelter of this parking court.
Reply to IAM rejoined, my lord.
There is a stay of this honorable court, my lord. And that's why the world.
Have you extended the period?
Yes.
Have you extended the
43,
What provision?
extended it?
My lord, that is the difficult situation. My lord will have an illegality. But why is your order cannot gain an illegality?
We are ready to hear the matter. There is no problem.
Then my lord,
And that way only you have to respect vacating or modification. We said we'll hear it finally. We can't finally.
in that case, reject my interest.
I will not take more than 5 minutes, my lord. And my lord may record my submission. Only in 5 minutes I'll make out my case.
ठीक है, बताइए.
What the case of the petitioner is that, my lord.
होगा. क्या करना है उसमें? उसमें लिखिए the matter is that heard list for further hearing tomorrow. पहले वाला.
Yes, sir.
But their essential facts are that, my lord. Fitted in the 19.
Which is your application for vacating stay?
It's I-8079 of 2023, my lord.
नहीं, ये बताइए मिस्टर नेमा, whether you have पुराने लोगों का contract extend हुआ कि नहीं?
13 को my lord page 7 in the this reply to their vacating, my lords. This now
Reply to vacating stay.
my lords. This is my lords IA number 39018, my lords. Respondent number 3. Reply to respondent number 3, my lords. Same. This is on the top. There is a number, my lord, 39018, my lords.
8079 is their application. When did you file it? फाइल किया अराउंड 25th
नहीं हमारा
Saturday post once they filed it.
सैटरडे
हाँ it was a working Saturday. We'll just pass it over, man. We'll just pass it over, man.
आया नहीं रिकॉर्ड पे
My lords. Then we placed it on record, my lord. That extension, he did. Page 14 onwards, my lords.
extension orders. Should this answer. अभी वहाँ दिया दिवाली यूनिवर्सिटी में क्या होगा? So because of the interim order, this has been extended.
Yes, my lords. So it's not as if it's come to a standstill, my lords. What they say that everything has come to a standstill, it's not correct, my lords.
May I be permitted to pass on these? This has been cancelled because this was because they insisted, my lord, that there is a stay of this honorable court. But this is of the Satna Mandi, my lord. And then
ये कहाँ का ये मालवा का अलग है वो?
same, my lord, में kindly उसी का, my lord, on which they are relying. The next page is page number 15. It's of Satna, my lord. Page number 15 of what they have passed on, my lord.
Satna.
Yes, my lord. My lord, they kindly peruse the documents which I have sent triplicate, my lord. And it has been cancelled, my lord. Because that's exactly what I'm trying to point out. Taking shelter of this honorable court's interim order, ये my lord, इनके sister concerns या जो भी whatever they are saying, the other persons, they are filing applications that there is a stay order and you can't provide this agreement to the new contractor. और setback को my lord, sir, again, और setback के साथ my lord, we have got a huge difference, my lord, of 8%, up to 8%.
So that is why it requires hearing. Okay.
Yes. And now, my lord, since they are not in Pithiga, they are not providing the manpower as of now. So ultimately, even if they are successful in this petition, this would be cost to them. ऐसा तो है नहीं कि आज इन्होंने manpower provide कर रखा है और इन्हें salary नहीं मिली. But अगर आज इन्होंने manpower provide कर रखा है, tomorrow it will be litigation against us, because then we will not be able to pay them. Because this is a condition where there is an interim relief. Now they are providing manpower, but we will not be able to pay them. So it will result in a chaos, man. That was our submission that way also, man.
Double payment. मिला कहाँ?
हमारा agreement terminate कर दिया. Terminated our agreement with this Satna. So now there is a hard fact situation, वाला.
ड्यू टू पॉसिबिलिटी ऑफ टाइम अभी सुनवाई करना बहुत मुश्किल है. वो भी सब इंसिस्ट करते हैं हमारा केस सुन लो. इंस्पाइट ऑफ दैट आगे ज्यादा केसेस बढ़ा दिए.
It's not possible that extends, my lord, but this is a peculiar situation here, my lord.
We are ready to hear forward.
That is true, man. That is true.
कल सुनने को तैयार हम. आप बोले तो कल लगा देते हैं इसको. कल इसको फाइनली सुन लेते हैं.
Tomorrow.
I'll take care of my chance.
Yes, due to paucity of time, this matter could not be heard today. This case tomorrow, I have to continue.
There is a supplementary tender है वो कल खुलने वाला है. कल खुलने वाला. आज की आपने मेंशन की थी.
लाइए. एक और पासवर्ड अभी
You did 5 minutes, my lord.
इसको बाद में करेंगे.
5 minutes. So because
पैनल नहीं मत करेंगे. अभी भी हम
पहली बार आ रहा है सर. ये तो पहली बार ना.
प्रेशर. बताइए.
Only 5 minutes, madam. Well, in this case,
it is to be heard finally.
नहीं. ये तो पहली बार लगा सर. So in this case, the appellant was respondent number 6 before the record. Undisputedly, my lord, respondent 6 had taken a loan from the bank, State Bank, and he defaulted in payment On the proceedings on the application filed by the bank, proceedings under the Madhya Pradesh Lok Dan Shodhya Rashtra ki Vasuli was started against them. They may not, this property was attached and put to auction. He did not pay the amount. Requested the court, requested the Tehsildar, and ultimately, my lord, the property was auctioned and I purchased the property for 9,90,000. The auction, the sale certificate was issued in my favor. Thereafter, my lord, against the order of the recovery officer, he filed an appeal which he could not have done so because there is a restriction on filing of appeal or revision against the power exercised by the recovery officer. My lord, after the issuance of sale certificate, the SBO granted an order of status quo, and in that appeal, I was the successful bidder, my lord, who got impeded as a party in the appeal. Thereafter, my lord, a civil suit was filed which was dismissed under Order 7/11D.
क्या आपको रिट पिटीशन अलाउ हो गई थी?
Writ petition under by the LR.
No, this is Radheshyam, no?
I am respondent number 6 before the record. Now the sale certificate that was issued in my favor, the registered sale deed that was issued in my favor, after having deposited the sum of rupees 9,90,000, been set aside by law. I am a bona fide purchaser. Before the appeal, the respondent number 6, that is the petitioner before the record, he did not impede me as a party. The payment I am a bona fide purchaser. My sale deed has been set aside by the red court. Respect, my lord, the red court did not have the power to set aside the sale deed, my lord, which has been executed in my favor.
It was not your petition.
It was not my petition, my lord. It was respondent number 6 petition. And he was a defaulter. He made a request that I am depositing 50,000, but no time was given. But there is no mistake, and my lord,
the directive conduct the inquiry.
It's like the Tehsildar, my lord. I mean, but that would be just for the Tehsildar to challenge that order, my lord. But ultimately, he also did not commit any illegality. Because the SDO passed an order of status quo, it will be changed.
That notice was issued.
Yes, sir.
You participated.
I participated.
You are the highest bidder.
I am the highest bidder. I paid the amount.
You are auction purchaser.
I am the auction purchaser. And my sale deed has not been set aside by the red court. Payment has been made by me. The SDO, my lord,
You are not a party.
मैं
नीचे
बाकी सारा रिप्लाई दिया ये सब बातें मुझे बताई कि कोर्ट को कि मेरा बहुत मतलब भेजा है कि कोर्ट हमें खुद ही कंडक्ट ऑफ द तहसीलदार को बोलते हैं but the conduct of the तहसीलदार my lord could not have been routed for the simple reason that
the petitioner, that is respondent number 6, challenged the sale of this land. Yes. Proceedings conducted by respondent number 7 in favor of respondent number 6 at the instance of respondent number 5. Proceedings कहाँ 7 कैसे करने पड़े?
7 में इन्होंने क्या करा सर तहसीलदार तो की बनाया इन्होंने respondent number 3 भी बनाया और 9 भी बनाया.
Land illegally by way of auction.
मतलब the proceedings under the लोकदंड शोध्य राशि की वसूली उसमें ऑक्शन का नोटिस दिया उसके बाद people participated. I was the highest bidder. 9,90,000 was deposited by me, credited in the account of the Tehsildar, my lord. And then, my lord, in my straightforward submission, my lord, he has made the respondent number 7 by name party. My lord, first of all, the appeal could not have been made against the order of the recovery officer under the Lokdhan Shodhi Rashi. And in the appeal also, I was not impeded as a party. I should have been impeded as a party because I was the highest bidder and the sale certificate has been issued against me. Now, if the order of the STO of status quo, status quo could not have been complied by the Tehsildar. That is the reason why the inquiry has been ordered. जब सब कुछ हो गया और अपने स्टेटस को ऑर्डर कर दिया तो यथास्थिति रहेगी जैसी स्थिति है वैसी स्थिति रहेगी स्थिति से सर्टिफिकेट
respondent number 6 petitioner है ना
respondent number 6 was the petitioner
उसने पैसे दे दिए थे 9,90,000
9,90,000 तो मैंने दिए सर
कैसे none of the respondents disputed what had happened to the check of rupees 9,90,000 number 6 लिखा है यहाँ पे
6 मतलब मैं आपके समक्ष आया है
so you are 6
I am 6 petitioner की लैंड petitioner जो रिकॉर्ड में था कि लैंड ऑप्शन हो गई थी Sir, change हो गई है position. The appeal now has become the appellant and the petitioner has become.
ऐसा क्या स्टेट गवर्नमेंट ने रख लिया तहसीलदार ने?
तहसीलदार ने रख दिया, तहसीलदार को आगे पैसा वहाँ बैंक को देना था,
स्टेट बैंक को देना था, दिस वाज इन डिस्चार्ज ऑफ द
लायबिलिटी my lord. मतलब मेरी तरफ से तो मुझे तो चेक तहसीलदार साहब के यहाँ जमा करना था, वो मैंने जमा कर दिया और मैंने डॉक्यूमेंट भी लगाया इलेक्शन यूट्यूब कोर्ट। इनकी प्रोसीडिंग कौन से मैंने देखो फाइल पे
जिस अकाउंट का चेक दिया आपने वो अकाउंट ही बंद हो गया था पहले।
सर मेरा अकाउंट सर ये तो क्रेडिट हुआ मेरा, ये मेरा वही कहना है कि दी द वन एनोनियस पेमेंट्स माय हैव फाइल द कॉपी ऑफ द book showing that the amount has been credited in the account, मेरा अकाउंट से डेबिट हुआ है।
अंदर से तो ऐसे ही लगता है।
मतलब मेरे से ये प्रोसीडिंग पेश की है सर, ये रेड कोर्ट में सामने जो प्रोसीडिंग्स पेश की है आप देखेंगे 28 फरवरी 2011 को।
चेक कौन से बैंक का दिया था आपने?
चेक वाज ऑफ द बैंक,
कॉर्पोरेशन बैंक और स्टेट बैंक? तो स्टेट बैंक कॉर्पोरेशन का लगाया आपने 9,90,000। तहसीलदार उज्जैन को दिख रहा है ये पेमेंट हुआ है
सर मेरे
9,90,000। तहसीलदार उज्जैन को चेक नंबर 500।
सर आप इसमें लिखेंगे जो तहसीलदार के आगे प्रोसीडिंग्स
है लास्ट पेज में। जमीन 112 के आसपास है, 112 के आसपास है।
सर मैंने अपील के साथ ये जो पासबुक लगाई है मेरी, उसमें ये तहसीलदार उज्जैन 9,90,000 पेज नंबर 29 में
name of bank is not disclosed, given by him was credited from his account.
So the point is, I am not required to deposit because I am purchasing the property from the तहसीलदार।
Sale deed challenge किया था इनने।
Yes. Even sale deed भी challenge किया था, but the sale deed could not have been set aside by the Red Court one under the red jurisdiction. After having made the payment by 9,90,000, the complete payment was made. And the interestingly, my lord, before the SDO, appeal or revision could not have been laid by any party. And if the appeal was filed, I should have been made a party.
Ultimately, recovery was only for 60,000 and odd rupees.
It was for 5 lakh and odd rupees.
पर यहाँ तो ऑर्डर में जो लिखा है
मैं भी बता रहा हूँ कि सर जरा सर्टन erroneous facts were which have been recorded. सर 2 लाख थे इनके, 3 लाख का, 3.5 लाख, 6 लाख 42,000 की रिकवरी की।
डिमांड कर सकता हूँ किसी सब आपसे ऐसा बोल रहे हैं
सर P1 जो डॉक्यूमेंट इन्होंने लगाया पिटिशनर ने, उसमें 6,42,000 का रिकवरी
कितनी अंदर की पिटिशनर से
होना थी। उन्होंने कहा मैं 50,000 जमा करता हूँ, मेरे को 7 महीने का समय दीजिए। The court, the तहसीलदार rejected that prayer, my lord. And till today, my lord, the amount has not been deposited after the sale certificate. He approached the bank after the issuance of the sale certificate. My lord, the possession has not delivered, the sale certificate was issued, the sale deed has been executed. He filed an appeal before the SDO, should not maintain including any other party before the SDO, my lord.
Respond number 7.
Before the respondent number,
respond number 7 filed the appeal.
6. Respondent number 6.
नहीं आप कौन है ये तो बताइए सर, नाम क्या है?
मैं इन पिटिशन में
राधेश्याम।
Yes. I'm Radhesham. I am respondent number 6. From the Red Court.
Option processor.
सर ये ऑर्डर में देखेंगे 20 नंबर पे कॉस्ट टाइटल है रेड कोर्ट का। सर मैं कैलाश इज दी पिटिशनर, नाउ बिफोर द ऑनरेबल कोर्ट एज respondent number 6. ट्रांसपोज हो गई सर पोजीशन बिकॉज़ किसी रिस्पोंडेंट अपनी जगह है। सर और इसमें तहसीलदार को रिस्पोंडेंट नंबर 3 बनाया और बाय नेम बनाया रिस्पोंडेंट नंबर 7 तहसीलदार का नाम। और द एप्लीकेशन ऑफ put up by the bank before the तहसीलदार for recovering the amount.
9,90,000 कहाँ गए?
9,90,000 सर मैंने जमा कर दिए, तहसीलदार के खाते में चले गए, तहसीलदार ने बैंक में जमा कर दिए होंगे या नहीं भी किए होंगे, पर माय ड्यूटी वाज टू ओनली बिकॉज़ आई वाज इंटरैक्टिंग ओनली विद द तहसीलदार।
नहीं किए ना,
नहीं की है जहाँ
सर रिस्पॉन्डेंट सर मेरा अकाउंट शेयर कि मेरे अकाउंट से तो 9,90,000 चलेगा नहीं तो पासबुक पे यहाँ भी पेश किया क्वेश्चन नेवर अरोज मेरा काम था कि मैंने
why cost has been imposed on you? All the respondents are supposed to pay 50,000 rupees.
एग्जैक्ट सर मैं वही एटलीस्ट आई शुड नो व्हाट मिस्टेक आई कमिटेड
ऑप्शन परचेजर है इनकी गलती।
मैंने 9,90,000 जमा कर दिए मेरा अकाउंट से डेबिट हो गया
स्टेटमेंट से दिख रहा है।
मैंने लगाया स्टेटमेंट से पासबुक के लिए तहसीलदार के अकाउंट में गए एंड आई एम रिक्वायर्ड टू डिपॉजिट द अमाउंट विद द तहसीलदार।
ये एटीएम विथड्रॉवल कहीं तो रहा है, एटीएम विथड्रॉवल तो रहा है,
वो अलग है। ये 17 अच्छा ये ऊपर तहसीलदार उज्जैन है ना 9,90,000।
And inquiry has been initiated against me also, my lord.
ठीक है अभी नोटिस करते हैं इसमें इशू।
So, my lord, the order of this, at the status quo may be ordered, my lord, because I have paid the amount, the sale deed cannot be set aside, my lord, in such proceedings. 9,90,000 has been parted with me. I have told that amount has been doled out by me, and this amount has been credited in the account of the Tehsildar. But at least I am entitled to know what mistake I have committed by purchasing a property which has been paid to the state government.
चलिए रिटर्नेबल 4 वीक्स अभी कुछ नहीं हो रहा है।
Status quo, I think when we go now, really not set aside, my lord. At least that will be protected.
अभी आ जाने दीजिए।
Fix the time, इसलिए मैं निवेदन कर रहा हूँ कि status quo at least will be ordered.
सर हम सर गिव ए कॉपी टू देम।
अभी ऐसा कॉपी के बगैर तो हम वैसे भी फाइल
इनका नाम आ रहा है कि नहीं आ रहा? राधेश्याम यादव है ना, स्टेट का नाम आ रहा है बस।
हाँ तो स्टेट को अच्छा दिए कॉपी उसकी सर्व दी कॉपी ऑन देम और स्ट्रेंथन दी स्टेटस को आप आगे की डेट लगा दे।
स्टेट क्या करेगी इसमें?
ऑनलाइन स्टेट के पास में है सब बैंक ने इनके यहाँ पे एप्लीकेशन लगा दी आगे परचेज की प्रॉपर्टी अगर आई बोला कोई परचेज and inquiry has been initiated against me. My sale deed has been set aside. Sale certificate has been issued by the
पूरा फिर से सुनना पड़ेगा इसको पूरे में वही रखना पड़ेगा। फैक्चुअल बड़ा एरर है उसमें।
मैं वही सर मैं
बराबर नहीं आया उसमें।
सर मैं भी निवेदन कर रहा हूँ कि इसमें सिर्फ स्टेटस को ऑर्डर आप करते तब तक लगेगा 30 तारीख लगा एटलीस्ट मेरे प्रोटेक्शन रिक्वायर्ड।
क्या कार्रवाई चल रही है?
सर मेरा सेल डीड एनी टाइम व्हेन इन द एप्लीकेशन बाय स्टेट गेट कैंसल्ड बाय द रजिस्ट्रार और द स्टेट गवर्नमेंट विल डायरेक्टली सेंड द ऑर्डर टू द।
ठीक है चलिए इसका इशू नोटिस ये रिटर्नेबल फीलिंग व्हिच इन द मीनवाइल स्टेटस को एज इट एग्जिस्ट टुडे विल बी मेंटेन्ड in the next date of hearing. Leave this case in the week commencing 4 हफ्ते बाद to week commencing दे दीजिए इसको। और
Yes, sir, मैंने participate किया। Tender question.
P4 is the tender at page 79. एक GM पोर्टल है, यूनियन गवर्नमेंट कंपनी बनाएंगे और advertise the tenders and they do the tendering for essential services. Now it is statutory. P4 at page 79 में क्या किया? Modification only the bid date has been modified. नहीं, हाँ, bid opening date has been modified. Modified to standard to हाँ, इसलिए मैं आपसे कह रहा हूँ। तो नहीं तो मेरा चैलेंज तो कुछ और है। मेरा चैलेंज से मेरे को पार्टिसिपेट करना है बाय मैं सबमिट में तो यू आर डिराइव्ड फ्रॉम पार्टिसिपेटिंग। इनकी एक कंडीशन ऐसी है कि पार्टिसिपेट नहीं कर सकते, तो उसके लिए क्या करेंगे हम लोग? सर्टिफिकेशन नहीं, कंडीशन ऑफ टेंडर। एक मिनट, क्या चैलेंज है इसमें? कंडीशन ऑफ टेंडर वो म्यूचुअली कॉन्ट्रडिक्टरी टेंडर कंडीशन में एक ही टेंडर में दो कंडीशन है। कोई एक बोलता है पार्टिसिपेट कर सकता हूँ, एक बोलता है मैं पार्टिसिपेट नहीं कर सकता। तो वो कंडीशन चैलेंज की है एनआईटी डेटेड 28/9/2025। जी कौन सा कंडीशन है? जी सर कंडीशन let me find the condition at page 50. उसी में दो कंडीशंस है सेम बिल्डर। एक्चुअली डिस्क्लेमर है, डिस्क्लेमर का बोला है कि ये किसी कंडीशन के वायलेशन में कोई कंडीशन है तो नहीं बनते। क्या हैव यू बीन डिबार्ड फ्रॉम पार्टिसिपेटिंग? आई कैन नॉट पार्टिसिपेट बिकॉज़ ऑफ दिस। बताइए कौन सा क्लास है? जी 50 सर पेज 23 सर्टिफिकेशन देख रहे हो सर, ये है टैबलेट फॉर टैबलेट। 23 में ये जितनी भी है ये सब सर्टिफिकेशन है विदेशी एजेंसी,
मिनिमम टेक्निकल स्पेसिफिकेशन
जी। इसमें ये जो BIS, CE, CB, FCC
फुलफिल नहीं करते मतलब
नहीं इंडियन है, ये फॉरेन नहीं है। ऐसे ही
इनको फॉरेन भी चाहिए, इनको इंडियन नहीं।
ये नहीं कर सकते वो, वो नहीं है। उसके लिए आ जाइए पेज 83 पे।
टर्म्स एंड कंडीशंस कैन ऑलवेज बी सेट आउट बाय द कंसर्न्ड।
नहीं पर ये जो रिस्पॉन्स नंबर 3 है जो ये डिस्क्लेमर है 83 पे, ये गवर्नमेंट ऑफ इंडिया का डिस्क्लेमर है पेज 83 में। Any clause incorporated by the buyer, buyer मतलब जिसका टेंडर है, I think following shall be treated as null and void and not be considered as a part of bid. इसमें no sir, line क्या लगा सर? Mandating foreign international certification in case of existence of Indian standards.
Mandating foreign international certifications even in case of existence of Indian
Standard without specifying equivalent Indian certificate standard. दूसरा incorporating any clause against MSME policy.
and preference to make in India policy.
ये जो फॉरेन का सर्टिफिकेशन है, मेरे पास फॉरेन का मतलब इंडियन है, होता है इसी एक ही टेंडर में ये डिस्क्लेमर है गवर्नमेंट ऑफ इंडिया, टेंडर निकाला है लेकिन टेंडर जो एडवर्टाइज करते हैं वो एजेंसी रिस्पॉन्स नंबर 3 है। All I have is to participate, subject to my lord order. मैं participate कर रहा हूँ, अगर आप allow करेंगे तो ठीक है, दरअसल नहीं। तू का टेंडर है सर?
Yes.
So इस पे same day की mention पे आया मतलब
नहीं पर ये डिस्क्लेमर क्लॉज कहाँ दिखाई आप इनको?
जी
अभी इधर अपन बोलते हैं मेक इन इंडिया और वो करो और इधर आप फॉरेन में इसको प्रमोट कर रहे हैं। Equivalent you have to mention as per this disclaimer clause. Mandating foreign international certifications even in case of existence of Indian standards without specifying equivalent Indian.
ISO जो सर्टिफिकेशन
ये भी इंटरनेशनल देखिए
ISO
ये हाँ
उनसे पेज पे 50
और सर एक और है वो तो सिर्फ बोल दिए पेज 53 पे मुझे डेस्कटॉप कंप्यूटर चाहिए वो
तो मतलब इंडियन
नहीं इंडियन
standards
इंडियन स्टैंडर्ड
इंडियन स्टैंडर्ड
ऑर्गेनाइजेशन
नहीं इंडियन स्टैंडर्ड
ISO
हाँ
इंटरनेशनल
स्टैंडर्ड ऑर्गेनाइजेशन ये स्विट्जरलैंड वगैरह किसी का ये
इंडियन सर
इंडियन नहीं सर ये
ऑर्गेनाइजेशन फॉर स्टैंडर्डाइजेशन जो अपने आप में बहुत सारी कंपनीज ISO मार्क लेंगे
इंटरनेशनल लेती है
इंटरनेशनल ले जाओ
ये मालूम समझना what I mean to say इसमें कमी है इंटरनेशनल ऑर्गेनाइजेशन फॉर स्टैंडर्डाइजेशन यानी ये अगर किसी को सर्टिफाइड कर दिया नहीं वो तो
सर एक सेकंड पेज 53 लीजिए या ISO भी हो
नहीं ऑलराइट तो इसमें नहीं इंडियन कंटेम्प्ररी कोई सर्टिफिकेशन है अवेलेबल नहीं अरे
इसलिए अब तो मेरे पार्टिसिपेट करना लिया है तो मैं
इसको कल
खुलना है
इंस्ट्रक्शंस ले
कल बिड भी है और कल खुलना भी है ये
कितने बजे खुलना है
सो ये
my lords will take it up as the number 1 in the morning.
absolutely
My lords will kindly take it.
Take it up as a first case tomorrow. You seek instructions and even find out कि क्या है ये ठीक है अब क्या मेंशन होता है ना तो they don't have the file है ना they don't have
मैं भी सर बताऊं मुझे पता
अच्छा ठीक है इसको लिखिए learned counsel for the state is directed to seek instructions with this case tomorrow as a first case. This case be taken up as a first case tomorrow.
This is understood.
Yes. हाँ कहीं भी लगा हो पहले आप आ जाइए
ये मत सोचिए कि आपका जिस 50 नंबर है तब तक वो खुल जाएगा उधर आपका
जी जी जी
इंफ्रैक्चर्स हो जाएगी।